Ankit. Ankit. See court all six.
Only three.
Only three people are.
Only three. That too from same office.
Yes, sir. Go ahead.
I'm sorry, my lord. Yesterday was supposed to be listed, my lord, KAT matter wherein interim order was not granted. Your lordships have adjourned it by 1 week. That is last Wednesday. It was supposed to be listed yesterday, my lord.
ನೋಡಿ ನೋಡ್ಕೊಂಡು ಹಾಕಿ ನೆಕ್ಸ್ಟ್ ಒಂದೇ ಟ್ವಿಸ್ಟ್ ನೋಡ್ಕೊಳ್ಳಿ ಯಾವ್ದು ಸ್ಲಾಟ್ ನೋಡ್ಕೊಂಡು ಹಾಕ್ಬೇಕು ನಮಗೂ ಪ್ರೆಷರ್ ಆಗ್ಬಾರ್ದು ಆ ರೀತಿ ಹಾಕ್ಬೇಕು ಹಾ ಎಸ್
Petition was dropped, your lordship, in the aid, due to stay order of this court. And the matter was not.
Make it.
Your Lordship, contempt application was dropped, Your Lordship, in KAT due to the writ petition was challenging the order of 2027/1/2023. The stay was granted on the 13/6/2020.
ಏನ್ ಬೇಕು
The matter should, yes, please.
ನೋಡಿ ಮುಂದೆ ಹಾಕೊಡ್ರಿ ಯಾವ್ದ್ರ ಬಗ್ಗೆ ಹಾಕ್ತಾರೆ
So,
ಹಾ
Hearing on vacating interim order, my lords, granted by this court,
2 weeks but
my lords.
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟಾ
Yeah, I am for the respondent to my lords. Next week, will be posted, my lords.
ನೆಕ್ಸ್ಟ್
Lords, one more matter, my lords.
one lawyer, one person, one vote, one soldier,
Lords,
one
this-
pension.
my lords, the Honorable Court has granted 1 week for the petitioner to do the research and come back. It's been a month. They have not yet come back. That's why I am filing this memo, my lords.
ಅದಾಗ ಎಂಟ್ರಿ ಮಾಡಿದ್ದೇನು
Yeah, interim order is there and they were granted 1 week to do the research and come back. It was on 23rd, last month.
2 weeks next
my lords, there was a consumer complaint filed by the purchasers against the developer, my lords. I am the landowner, my lords. There was an order in the purchaser's favor. They filed an execution. In the execution, they have included me in the execution when I was not even a party to the consumer complaint, my lords.
You're not a party there.
No, my lords. And now the consumer court is taking course of action. My lords, it may be had tomorrow, my lords. If
So
the-
we are not in this bench, na?
my lords, Monday, Tuesday, my lords, any day.
Monday, Tuesday.
Tuesday, my lords.
My lords, I seek to mention an RFA, my lords, which was erroneously disposed. My lords, the review petition was preferred and subsequently it was the award, I mean, the judgment was set aside, my lords.
Wait,
It was, yes, my lords, it was reinstated back before this honorable court, my lords. I seek to mention this the previous week, my lords. My lords had told that it
You
be
have
listed this
filed
week. My lord?
Filed review petition.
No, my lords, we were successful in our review petition. Our judgment has been set aside, my lords, and reinstated before this honorable court. My lords, I sought to mention it, my lords. A hearing is required as the urgency is based on that erroneous judgment.
ಅದು ಮ್ಯಾಟರ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಆಗಿದೆಯೋ ಪೆಂಡಿಂಗ್ ಇದೆಯೋ
It was disposed of, my lords.
ಅದಕ್ಕೆ review-
Review petition was, yes, ma'am.
ಅಪ್ಲಿಕೇಶನ್
My lord, fresh matter for admission.
Huh?
Fresh matter for admission, my lord. Monday, my lord.
ಎಮರ್ಜೆನ್ಸಿ ಇದೆಯೇನು
Agency is order challenge ಮಾಡಿದ್ದಾರೆ KT ಆರ್ಡರ್ಸ್.
80 ಆರ್ಡರ್
Please, my
ದೊಡ್ಡ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗುತ್ತೆ ಹಾಗೆ ಎಸ್ ಬ್ರದರ್
My lord, serial number 21, my lord.
51
21.
21
I'm for appellant in this case, my lord.
2013 ಮ್ಯಾಟರ್
ಅವ್ರು ಚಂದ್ರಶೇಖರ್ ಅವರು ಆಸ್ಟೆಂಟ್ ಆಗಿದ್ದೇನೆ. ಡೆಸ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ ಒಂದು 2 weeks ಕೊಟ್ರೆ ಅವ್ರು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ವಿ ಅವ್ರಿಗೆ.
ಅವರಿಗೆ ಬರಬೇಡಿ ಅಂತ ಹೇಳಿದ್ರು ನಾವು
ಹ್ಮ್.
2 weeks at the request of finally
Please.
Lords, kindly, serial number 29, my lords. ಅದರಲ್ಲಿ 3 ಮ್ಯಾಟರ್ ಇದೆ.
ಹಾ
My lords, I want some short accommodation. ಆ ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಕೌನ್ಸಿಲ್ ಹೆಸರು ಸರಿಯಾಗಿ ತೋರಿಸಿಲ್ಲ, ಅವ್ರ ಹೆಸರು ತೋರಿಸ್ಬೇಕಾಗಿದೆ.
ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಹಾಕೋಣ
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್
ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಬೇರೆ ಏನಾರ ಮ್ಯಾಟರ್ ಇದೇನು ಹೆಸರು ತೋರಿಸ್ಬೇಕು
ಅವ್ರದ್ದು
ಕೊಡಿ.
ಹೆಸರು ತೋರಿಸ್ಬೇಕು. ಸೆಕೆಂಡ್
ನೋಡಿ.
ಮ್ಯಾಟರ್ ಅಲ್ಲಿ 23.1 ನಲ್ಲಿ
ನೋಡಿ
ಕೌನ್ಸಿಲ್ ಹೆಸರು. ಮಚ್
My lords, serial number 25, ma'am.
25 ಏನು
Coming up after some time, requesting.
2013
Yes, ma'am.
Huh?
Maybe had after a week, ma'am.
not ready 2 weeks at the request of yes inform your friend also
I'll inform.
Ah. Good.
Ready,
Ah.
coming. ಈಗ
Raju,
ಫೈಲ್ ಮಾಡ್ಬಿಡು. ತಂದಿದ್ದೀನಿ ಫೈಲ್ ಮಾಡಿ.
council submits, for the appellant submits that he will file the paper book today itself. First, call this matter next week after next.
My lords, in item 2, my lords, I appear in item 2.1. My lords, the matter is actually
2.1,
right.
Gautam.
2.1, my lords, the matter is right for hearing. Paper book is filed. My lords, so far as in item 2, my lords, non-filing of paper book, my lords, the office note in the cause list in item 2, that may be deleted, my lords, because in the connected matter, the paper
ನಿಮ್ಮ ಮುಖ ಕಮಲ ಕಾಣ್ತಾ ಇಲ್ಲ, ಬರೇ ಮಸ್ತಕ ಕಾಣ್ತಾ ಇದೆ.
my lords, it can't.
We are not able to see your blossoming face. We
My
are
lord-
seeing your skull only. Yes.
My lords, is it better now?
Yes.
My lord, sorry, my lord, my apologies. My lords, in item 2, my lords, the office note in the cause list may be deleted because the paper book is filed in the connected matter.
ಬರ್ಕೊಳ್ಳಿ.
My lords, I'll just complete, my lord.
ಇನ್ನು ಅಲ್ಲ, we'll complete one sentence first.
Wait, wait,
Otherwise we
wait,
may
wait.
get confused.
Wait.
We agree with learned counsel Gautam Bharadwaj appearing for the appellant in RFA number 1209 of 2017 that since paper books are filed in the companion RFA 942/2017. ಆ ರೀತಿ ಮಾಡ್ತೀವಿ, ಒಂದು ಸ್ವಲ್ಪ ರಿವರ್ಸ್ ಮಾಡ್ತೀವಿ. ಓಕೆ, ಅದನ್ನು the filing of paper book, one more set of paper book is not necessary. Yes, next.
Then, my lords, in item 2.1, office note number 4 in the cause list, my lords.
4 and 5.
Not taking steps.
My lord,
Steps
so
in
far,
respect of deceased R2A.
R2A, my lords, the other legal representatives are already on record. So that
ಯಾರ್ಯಾರು
may-
ಅವರು? Who are
my
they?
lords, they would be, my lords, I will give the details of that, my lords. You need to amend the cost.
At least you have to file a memo at least.
No, my lords, they are, my lords, already 2B, 3, 2B3, and original appellant who is passed away, his interest is represented, my lord.
We also accept his contention, submission that the respondent,
Respondent number 2B and
second respondent having died,
R2A died.
R2A died.
2A, my lord.
Respondent number 2A having died, comma, his estate is represented by respondent numbers
2B and 3.
2B and respondent 3.
3, yes, my lord.
A note
Yeah.
to be made beside cost title to this effect. Okay.
My lords, otherwise the matter may be set down for final disposal on any date convenient to my lords.
Any
my lord.
date, all.
It's a short point, my lords, because the
No.
trial court holds
The
time is not the
Second,
essence.
which year suit ಯಾವ್ದು?
My lords-
ಅದ್ರ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗ್ತದೆ. ಈ
My lords-
ಅಪೀಲ್ ಡೇಟ್ ಅಲ್ಲ.
My
Suit
lords,
ಯಾವ್ದು?
the-
Which year suit?
The suit is of 2010, my lords.
10.
10, my lords.
Post this matter in the second week of January 2025.
My lords, for final disposal, my lords, the request.
Second week of January 25.
For final disposal, my lords.
Yeah.
Great.
ಬ್ರದರ್, ಅಲ್ಲಿ ರಿಪೇರಿ ಮಾಡಿ ಏನೋ ಆರ್ಡರ್ ಮಾಡಿದೇವ್ರಿ, ಮತ್ತೆ ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಡೇಟ್ ಹೋಗ್ತದೆ. ಅದಕ್ಕೆ ಒಂದ್ಸರಿ ಪೋಸ್ಟ್ ಆದ್ರೆ ಒಂದು ಕೇಸಿಗೆ ಪರ್ ಮಿನಿಟ್ ವಿ ಆರ್ ಸ್ಪೆಂಡಿಂಗ್ 2000 rupees. Government is spending 2000 rupees. What the audit report says. Yes.
Yes.
I appear for the appellant in this.
Yes,
matter,
madam.
lords. My lords, a week's time may be granted to take notice on the respondent number 2 if the counsel for the, who had appeared in,
For R1.
you are for R1. If he can, I'll ascertain if he can take up for R2 as well.
We'll ascertain.
Please, my lord,
Brother, can you appear for R2 also? Okay. You can.
please.
Learned
So that may be.
counsel Sri Devraj Allah? Yes, Your Honor. Devraj N appearing for the aviator respondent 1 submits that he would appear for our respondent number 2, second respondent as well. First off, we appreciate
With
this.
regard-
Okay.
With regard to non-amendment, my lords, I will carry out the amendment.
ಇಲ್ಲೇ ಮಾಡ್ಬೇಕು.
ಮಾಡ್ಕೊಡ್ತೇನೆ ಈಗ.
Good. Sorry.
And in the meanwhile, my lords,
ಅದ್ ಮಾಡಿ ಆಮೇಲೆ ಮಾತಾಡಿ.
ಹಾ.
Yes.
a date may be fixed with regard to arguments on this case,
ಯಾವ ಇಯರ್ದು ಸೂಟು?
2017.
17.
17.
In the second week of February 2025. Yes,
Lords may have it sometime next week.
very difficult matter. Huh? Yes, good, next point.
At least your lordships may take up in January, my lords.
Last week of January. Okay.
Much.
All right, ನೋಡಿ, ರಿಪೇರಿ ಮಾಡಿ fast ಆಗಿ.
Please, I will amend the first. Much.
My lord, all these applications, my lord,
Ah.
wherein the petitioners, my lord, had the, they were required to be extended the benefit of promotion.
ಬಡಿ, ಏನಾಗಿದೆ ಇದು?
On the basis of the order of this honorable court, my lord, were made in Dharwad bench.
Ah.
Now, my lord, endorsement, the persons, my lord, who were promoted on the basis of diploma certificate, my lord,
Ah.
were to be reverted, and we should have been considered for promotion, my lord, was the order of this honorable court. That you will also will find, my lord, at page 92. The division bench, coordinate bench of this honorable court, my lord, 92, wherein the qualification prescribed for promotion to be diploma has been set aside. And we were all, my lord, though juniors, my lord, we had possessed the requisite qualification of pass in MA, B.Ed in English subject particularly.
92.
Page 92, my lord. In first case, my lord, 5106 of 22, my lord.
Redraw the senior.
Read of the seniority list as explicit as possible and at any rate not later than 6 months from the date of receipt of copy of this order.
Based upon?
XP as possible at the rate not later than.
no.
Based upon the qualification, my lord, which the persons would have possessed for the purpose of consideration of promotion, that is pass in B.Ed. As against diploma. My seniors, my lord, they had passed diploma. We challenge the provision relating to diploma certificate. That is others, my lord, others have challenged. In that, my lord, this honorable court held that diploma on the way, promotion on the basis of diploma is bad. That is the order.
That is the order.
So we should have. We should have been promoted, but we were the persons, my lord, who have been promoted, who have been qualified, my lord, in B.Ed qualification. As against our seniors in diploma. So we were required to all things are required to be done. These are the 3 cases wherein, my lord, we have come from Hassan district 2 persons and Davangere district 2 persons.
ಬಿಡಿ, ಯಾವ್ದಾರ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಬಂದು ಕರ್ನಾಟಕದವ್ರು ಇದ್ರೆ ಆಯ್ತು. ಈಗ ಇದು ಟ್ರೈಬ್ನಲ್ ಏನ್ ಮಾಡಿದೆ?
Tribunal reject ಮಾಡಿದೆ on the ground that you will be given promotion on the basis of the present existing list.
List
Seniority list.
a list was drawn when?
That list, my lord, was drawn in 2016, 10, 2020.
16/10/2020.
Yes,
Consequent to that judgment,
but not consider, not revert. Yeah, I'm sorry.
You excluded the diploma holders. You placed them below the degree hold, B.Ed holders. These B.Ed holder.
Yes.
You have placed them above diploma? Below. How? The very judgment, go to page 92. 92, the division bench had set aside the consent GO, which had accorded seniority to the diploma holders above the degree B.Ed holders. You have put them, those are put below. Show that. 153. Where are the petitioners?
153, serial number 1, my lord.
You are placed at the top.
60.
153. 153. You are at serial number 60.
60.
Who is which
70.
diploma holder appointed as on the date you were appointed is shown above you? Show that.
In that event, my lord, they should consider my case for
Where is the
promotion.
question of consideration?
On that basis,
But
because
the-
the persons, my lord, who were promoted on the basis of diploma qualification are ordered to be reverted.
ಅಲ್ಲಿ reversion ಎಲ್ಲಿದೆ ಆರ್ಡರ್?
ಇಲ್ಲಿದೆಯಲ್ಲ, redo the entire list, seniority list ಅಂತ.
Redo the entire list ಅಂತ ಹೇಳಿ.
ಅದು ಅವರೇ ಮಾಡಿದ್ದಾರೆ, ಬೇರೆ ಹಿಂದಿ ಕೇಸಲ್ಲೆಲ್ಲ ಅವರೇ ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ.
What was your prayer before the tribunal?
Tribunal, my lord, I have challenged the endorsement,
ಏನು endorsement saying?
saying that your case will be considered as per the existing seniority list.
Existing ಅಲ್ಲ. Existing ಅಂದ್ರೆ ಇದು
Yes, ಅದು ಹಳೆ seniority list.
by existing. What is meant by existing? Redrawn, it also was existing as in the date you approached the court, tribunal. What is meant by existing list?
16/10/2020 page.
But correct ಇದೆ. ಅದು
ಇಲ್ಲ.
correct ಇದೆ.
ಅದು ಕೊಟ್ಟಿಲ್ಲ, ಅದು ಆ ತರ ಅವ್ರು ಪ್ರಮೋಷನ್ ಕೊಟ್ಟು ನಮ್ಗೆ ಯಾರಿಗೂ ಪ್ರಮೋಷನ್ ಕೊಟ್ಟಿಲ್ಲ.
ನಿಮ್
ಹಿಂದಿ.
go to your prayer in the KAT.
Yes.
Go to your prayer. ಎಷ್ಟು ಪೇಜ್, ಎಷ್ಟು ಸಣ್ಣ ಮ್ಯಾಟ್ರಿಗೆ 26 ಪೇಜ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ಬೇಕಾ ನಮ್ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಲಿಕ್ಕೆ? 2 ಪೇಜ್ ಇರ್ಬೇಕು.
ಇಲ್ಲ, ಅಲ್ಲಿ ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಲ್ಲಿ ತಮ್ಮ ಮುಂದೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ನಾನು.
ಹಂಗ ಹಾಕೊಂಡೆಲ್ಲ ಹೋಗ್ತಾ ಟೈಮ್ ಇರಲ್ಲ ನಮ್ದು. ಇಂಥವೆಲ್ಲ ಓದ್ಬೇಕು ಅನ್ಸದೇ ಇಲ್ಲ ನಮಗೆ.
Page 60.
1.5 ಪೇಜ್ ಬರೀಬೇಕಾದ್ರೆ 26 ಪೇಜ್ ಬರೆದ್ರೆ ಹಿಸ್ಟ್ರಿ ಫ್ರಮ್ ಅಲೆಕ್ಸಾಂಡರ್ ಟು ಬಾಬರ್ ಟು
ಇಲ್ಲ, ಅದು ಹೇಳಿಲ್ಲ, ಇದನ್ನ ಹೇಳಿಲ್ಲ ಅಂತ ಬೇಡ ಅಂತ.
20 ತನಕ ಬರೆದ್ರೆ ಹೆಂಗೆ ನಾವು ಮಾಡೋದು? ಹಿಂಗೆ ಕೆಲಸ ಏನ್ ಹೇಳಿದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್? The pleading should be very, very concise. There is a judgment of the apex court. You can't go on writing the story. You will not. Supreme Court denied relief on that ground. Anyway, hereafter, if you do that, you will suffer that. Yes. Where is that? Huh? Show your prayer. What's your prayer?
Page 60, my lord.
16.
60.
60.
Call for the records, set aside the impugned endorsement dated 16/10/2010.
Endorsement said what?
16/10/2010, 8/21, my lord.
8/21.
Yes.
Show that.
Page
number?
83, my lord. I'm sorry, 248.
248. ಮೂರು ಪೇಜ್ನ ಬರೆಯೋದು. Yes. 248. This is
ನ್ಯಾಯಾಲಯದ ತೀರ್ಪಿನಂತೆ ತಮ್ಮ
2020. This is a redrawn list.
ಬರೋದಿಲ್ಲ ಅದು. ರೀಡ್ ಆನ್ ಲಿಸ್ಟ್ ನಮ್ಮ ಹೆಸರು ಅವರು ನಮ್ಮ ಮೇರೆಡೆ ತೋರಿಸಿಲ್ಲ.
60ರಲ್ಲಿ ತೋರ್ಸಾರ.
ಅಲ್ಲ 16 ಅಲ್ಲಿ ತೋರಿಸಿಲ್ಲ ಅವರು. ಹಂಗ್ ತೋರಿಸಿದ್ರೆ ಇನ್ ದಟ್ ಇವೆಂಟ್ ಮೇಲೆ ಐ ಶುಡ್ ಬಿ ಕನ್ಸಿಡರ್ ಫಾರ್ ಪ್ರಮೋಷನ್ ಫ್ರಮ್ ದಿ ಡೇಟ್ ವೆನ್ ಮೈ ಜೂನಿಯರ್ಸ್ ಆರ್ ಪ್ರಮೋಟೆಡ್.
ತೋರಿಸಿದ್ರೆ ಬೇಡ.
ಅಲ್ಲ ಅವ್ರು
ಇಲ್ಲ ಉತ್ತರ ಕೊಡಿ, ಮುಂದಿನ ನೋಡೋಣ.
ಪೇಜ್ 248 ಮೇಲೆ
248 ಅಲ್ಲಿ ತೋರಿಸಿ.
ನ್ಯಾಯಾಲಯದ ತೀರ್ಪಿನಂತೆ
60, serial number 60. You become at serial number 60 pursuant to order of the division bench at page 92.
ಬರೋದಿಲ್ಲ ಅದು. That is not correct, my lord. That is not correct. Because the endorsement at page 248 says that I will be considered for promotion only on the ಅವ್ರನ್ನ ಆಮೇಲೆ ನಮ್ಮ ಡಿಪ್ಲೊಮಾ ಹೋಲ್ಡರ್ಸ್ ನಾವು ರಿವರ್ಟೇ ಮಾಡೋದಿಲ್ಲ. ಅವ್ರನ್ನ ಎಲ್ಲ ಹಂಗೆ ಕೂರಿಸಿದ್ದಾರೆ. Without even reverting my persons who have been promoted on the basis of diploma qualification, they have been retained as they are. 12/9/2020 ಈ ಕಚೇರಿಯಲ್ಲಿ ನಡೆದ ಸರ್ಕಾರಿ ಪ್ರಾಥಮಿಕ ಶಾಲಾ ಶಿಕ್ಷಕರ ವೃಂದದಿಂದ ಪ್ರೌಢಶಾಲೆಗಳಿಂದ ಶಿಕ್ಷಕರಿಂದ ವೃಂದದ ಹುದ್ದೆಗೆ ಮುಂಬಡ್ತಿ ನೀಡಿದ ಕೌನ್ಸಿಲಿಂಗ್ ನಲ್ಲಿ ಅಂಜನಪ್ಪ KR, ವಳಗೋಡು, ಸಕಲೇಶ್ಪುರ ಇವರು CPZ ವಿಷಯದಲ್ಲಿ ಮುಂಬಡ್ತಿ ಹೊಂದಿ ಸರ್ಕಾರಿ ಪ್ರೌಢಶಾಲೆ ಅರಸೀಕೆರೆ ತಾಲೂಕಾ ಇಲ್ಲಿಗೆ ಸ್ವ ಇಚ್ಛೆಯಿಂದ ಸ್ಥಳ ಆಯುಕ್ತ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಯತೀಶ್ ಸಹ ಶಿಕ್ಷಕರು, ಹಿರಿಯ ಪ್ರಾಥಮಿಕ ಶಾಲೆ ಅರಸೀಕೆರೆ, ರಾಘವೇಂದ್ರ DK ಸಹ.
One second. Suppose if you operated a particular seniority list and promoted people, subsequently that seniority list is set aside with a direction to redraw a ranking. You draw the ranking. Those who have been promoted, they also need to be accordingly altered. Their position, that is what Kathe Gowda, where is that judgment? Kathe Gowda versus State of Karnataka.
ಇಲ್ಲ
ರಿಲೀಫ್ ಕೊಡಕ್ ಬರಲ್ಲ. ಅವೆಲ್ಲ ತೊಗೊಂಬರ್ಬೇಕು. ನಾವು ಹೇಳ್ಕೊಂಡು ನಿಮ್ಗೆ ರಿಸರ್ಚ್ ಮಾಡಿಸಿ ನೀವು ಜೋಬಿಗೆ ಫೀ ಹಾಕೊಂಡು ನಾವು ನಿಮ್ಗೆ ಆರ್ಡರ್ ಕೊಡಕ್ ಬರಲ್ಲ, ನೀವು ಕೆಲಸ ಮಾಡ್ಕೊಂಬರ್ರಿ. Bring that judgment. Bring that Kathegowda. Kathegowda says, where a particular seniority position is acted upon, Shanti Bhushan, which is that Kathegowda judgment? Ha, Prithvi. ಯಾವುದು? Correct. They are all great judgment. Service lawyers ಎಲ್ಲ ಓದ್ಕೋಬೇಕು ಅವನು. ನಾವು ಅದನ್ನೆಲ್ಲ ಹೇಳ್ಕೊತ ಕೊಡಬಾರ್ದು, ನೀವು ಎಲ್ಲ ಸೀನಿಯರ್ ಲಾಯರ್ಸ್ ಓದ್ಕೊಂಬನ್ನಿ. ಅದರಲ್ಲಿ ನಿಮ್ ಪರವಾಗಿದೆ, ಅದು ಓದ್ಕೊಂಬರ್ಬೇಕು. Justice Ramajay said dedicated 1/2 paragraph about Kathegowda. Citation ಕೊಡಿ, ಅದೊಂದು ಸೈಡ್ ನೋಡಿ, ಅದೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ. ಸರಿ, ಐ ವಿಲ್ ಆಲ್ಸೋ ರೀಡ್ ಅಗೇನ್. ಕಾಪಿ ಕೊಡಿ. ಆಲ್ ರೈಟ್. ಅಲ್ಲ, ಈಗ ಆ ರೀತಿ ಅಲ್ಟರ್ ಆಗಿದ್ರೆ ಮತ್ತೆ ಅದನ್ನ ರೀಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ನೀವು ಅವ್ರ ಕ್ಲೇಮ್ ಅನ್ನ ಮತ್ತೊಂದ್ಸರಿ ಕನ್ಸಿಡರ್ ಮಾಡಿ. Suppose if you have given position, if you have redrawn, court said redraw. Redraw has its own meaning. Redraw means when you redraw, there is another judgment, 78 KLJ. Once seniority is directed to be redrawn, and accordingly it is, the earlier seniority list goes, and the new seniority list will take its stead. The sentence, I am reproducing the sentence in the judgment. If that is so, whatever positions you have accorded based upon the Flossom seniority list, that has to be redone. ಆ ರೀತಿ ಮಾಡಿ, ಅದಕ್ಕೆ ಬೇಕಾಗುವಂತದ್ದು ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಡಿ, ಅಷ್ಟು ಮಾಡಿ ಹಾಕೋಣ ಬರ್ಕೊಳ್ಳಿ. The short grievance of the petitioners before this court, ಏನು ಇಷ್ಟೆಲ್ಲ ಅದು ನೀವು ಯಾರ್ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ರಿ ಅವ್ರಿಗೆ ಮೊದಲಿಗೆ? Now, if the seniority list is redrawn, placing the diploma holders below B.Ed holders, the consequences will follow. Maybe that you may not recover money from them, you may not give anything to them notionally also. But their case has to be considered for promotion based upon redrawn seniority list.
Page 153 is after redoing it.
After redoing it, he is
Yes,
at
my lord.
serial
After
number 60.
considering the division bench, Dharwad judgment, my lord.
Ah.
This 153, if my lords may kindly peruse it for a moment once again, my lord.
ನೋಡಿದ್ದೇನೆ ಮತ್ ಅಂತದ್ದು ಏನು ಅದ್ರಲ್ಲಿ ಅದೇನು ಋಗ್ವೇದ ಅಲ್ಲ ಏನು?
After redoing,
once you redraw,
yes, my lord.
that position which you had accorded based upon
Follow.
the list which preceded the redrawn one.
Yes,
You have to alter it. This is what Kathegowda says. ಅದಾದ್ರೆ ಪ್ಯಾರಾಗ್ರಾಫ್ ಓದ್ರಿ, ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಇದೆ ಅದರಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ.
ಈ 153 ಒಳಗೆ ಇಲ್ಲಿ ಕೆಳಗೆ ಡಿಪ್ಲೊಮಾದವ್ರದ್ದು ಎಲ್ಲಿದೆ?
ಡಿಪ್ಲೊಮಾದವ್ರನ್ನ ಎಲ್ಲಿ ಪ್ಲೇಸ್ ಮಾಡಿದ್ರಿ? ಅವ್ರು ಬಿಲೋ ಮಾಡಿದ್ರಲ್ಲ ಈಗ. ನೋಡ್ಕೊಂಬನ್ನಿ.
Yes, my lord.
ಎಷ್ಟು ಖುಷಿ ಆಗ ನೋಡ್ಕೊಂಬನ್ನಿ.
I'll just check whether the diploma holders do where they have
ನೋಡಿ,
placed them.
ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೇನೆ ನಾನು.
Please, my lord.
Service lawyers
Please, my lord.
should read at least 3 books.
Please,
One, Services under the State by Rama Joyce.
please, my lord.
Another is Service Law, name I do not know, by Samaraditya Pal. ಏನ್ ಹೆಸರು? ಹೆಸರೇನು? ಬುಕ್ಕಿನ ಹೆಸರು ಅದೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ. The one another is Service Disputes and Writ Remedies by Kulashrestha. These are 3 essential books like our Bible, Quran, Vedas, ಆ ರೀತಿಯ ಅದನ್ನ ತಿಳ್ಕೊಳ್ಳೇಬೇಕು, ಅವಾಗ ಆರ್ಗ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಅದ್ರ ಜೊತೆ ಬೇರೆ ಓದಬೇಕು, ದಟ್ಸ್ ಅನದರ್ ಥಿಂಗ್. ಅಟ್ ಲೀಸ್ಟ್ ಇಷ್ಟಾರು ಓದಬೇಕು, ಅದರ್ವೈಸ್ ಯು ವಿಲ್ ಬಿ ಕಟಿಂಗ್ ಸಾರಿ ಫಿಗರ್. ಯು ಆರ್ ಆಲ್ ಸೀನಿಯರ್ ಮೆಂಬರ್ಸ್, ನಿಮ್ ಕ್ಲೈಂಟ್ಸ್ ನೋಡ್ತಿರ್ತಾರೆ, ನಾವು ಈ ರೀತಿ ಹೇಳೋರೆ, ಸೀನಿಯರ್ ಇರಲಿ ಜೂನಿಯರ್ ಇರಲಿ, ವಿ ಡೋಂಟ್ ಕೇರ್. ಓದ್ಕೊಂಬಂದ್ರೆ ರಿಲೀಫ್, ಅದರ್ವೈಸ್ ನೋ. ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Obliged.
ನಾವ್ ಹಿಂಗ್ ನಮ್ ಕೈಯಿಂದ ಹಿಂಗ್ ಹೇಳ್ಸ್ಕೊಬೇಡಿ, ನಿಮ್ಗೂ ಹರ್ಟ್ ಆಗ್ತದೆ, ನಮಗೂ ಹರ್ಟ್ ಆಗ್ತದೆ. ಬಟ್ ನಾವು ಈ ರೀತಿ ನಿಮ್ಗೆ ಹರ್ಟ್ ಮಾಡ್ಲಿದ್ರೆ ಬಾರ್ ಇಂಪ್ರೂವ್ ಆಗಲ್ಲ. ನಾವು ಕಳಪೆ ಕೆಲಸ ಮಾಡಕ್ಕಾಗ್ತದೆ, ಅದರಿಂದ ಯಾರಿಗೂ ರಿಲೀಫ್ ಸಿಗಲ್ಲ. ವಿ ಆರ್ ವೆರಿ ಸಾರಿ ಟು ಸೇ ದಿಸ್ ಇನ್ ದ ಮಾರ್ನಿಂಗ್. ಎಸ್,
let them read.
ಓದ್ಕೊಂಬರ್ರಿ ಮೊದಲು, ಕಾಲ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Date fix.
Next week. Next week. Date ಕೊಡಿ. Yes.
I represent minute 5.2. Respond number 3.
Respond number 3. ಎಲ್ಲಿ ನಿಮ್ಮ friend?
And the respond number 4, my lord, she was even before the trial court of KT also not represented.
Steps ತಗೋಕಲ್ಲ.
I appear in 5.1, my lord. It is at my instance matter is listed. My lord, what has happened is, my lord, there is a dispute between.
Correct. ಅವ್ರು ಇಲ್ದಂಗೆ ಹೆಂಗೆ ಆರ್ಡರ್ ಮಾಡೋದು?
Now what has happened, my appointment is, my lord, stayed. Though, my
ಪಾಸ್
lord,
ಮಾಡಿ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ. ಅವ್ರ ಫೋನ್ ನಂಬರ್ ಏನಾರ ಇದ್ರೆ ಮಾಡಿ.
very well. I will.
ಫೋನ್ ನಂಬರ್ ಇದ್ರೆ ಕೊಡಿ ಅವರಿಗೆ. ಓಕೆ. ಪಾಸ್ ಓವರ್.
Great.
ಮತ್ತೆ ಇದನ್ನು ತಗೊಂಡಿಲ್ಲಲ್ಲ ಅವರು. ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು R4. ಯಾರು ಅವರು? R4.
R4 ಅಲ್ಲಿ my lord, even trial court also she has not, KT,
ಕೊಟ್ಟ.
KT she is not represented. She was placed expert even before there also.
ಶ್ವೇತಾ ಗಾಲಿ 31 years registration ಕರ್ನಾಟಕ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಥಾರಿಟಿ. ಅವರಿಗೆ ಸರ್ವ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳ್ಬೋಣ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಥಾರಿಟಿಗೆ. ಪ್ಲೀಸ್
KE has also filed writ petition.
Huh?
KE, Examination Authority has filed writ petition here.
They have also filed it.
Yes, ma'am.
Posted today.
Yes, ma'am.
5.1, 5.2 ಇದೆಲ್ಲ ಇದೆಯಾ?
Yes, ma'am.
5.2.
ಮೂರು ಅವರು
ಮೂರು ಅವ್ರದ್ದೇ.
3.
ಅವ್ರಿಗೆ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು ಅಲ್ಲಿ KT ಅಲ್ಲಿ? ಶ್ವೇತಾ ಗಾಲಿ ಅವರಿಗೆ.
But Shweta Gazi, she was absent now. I'll KT.
In the court below.
Below the, when there was an observation, the tribunal.
ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಇದೆ.
ತೋರಿಸಿ. ಇಲ್ಲ ಡೈರೆಕ್ಟ್ ಪೊಲೀಸ್ ನೋಟಿಸ್ ಟು registry to send police notice to respondent number 4 Srimati Shweta Gali by way of emergent notice. Full stop. Post immediately after service.
May I just one, my difficulty is, my lord, my appointment is not under challenge, my lord. Tribunal has granted me relief saying that irrespective of what happens to this litigation, you are eligible for appointment. Please give him appointment. Now, my lord, the Education Authority has challenged it. There's an interim order. Now, irrespective of the outcome of this litigation, my appointment, my lord, will still go ahead.
No, service act number.
Very
Next, no.
Please, very well.
Next. Post immediately after service. Okay.
My lord, the respondent was an officer under the Employee Provident Fund Organization, Lord, which is a statutory body under the Ministry of Labor and Employment. Lord, there were some disciplinary proceedings initiated against him, and the inquiry officer framed about 5 articles of charges. He did not find any evidence, and accordingly, he recommended closure. The disciplinary authority did not agree with that, issued a disagreement note in respect of Article 3. Then he gave an opportunity.
Charge of article number 3.
My lord, it is not so relevant. And then an opportunity was given to the officer concerned to have his say. He filed his representation. It was considered, and the officer passed an order imposing the penalty of deduction of 20% cut in the pension. Now that was challenged before the tribunal. The tribunal's order, my lord, if your lordships would kindly see, not at page number, it begins at page number 329. But what is relevant is just one para 21, which is at page 351. Lordship can straight away go to page 351. Para 21. Lordship got it? Keeping the above points in view, the penalty order dated 22/11/2019, having been issued without prior consultation with UPSC, is not in accordance with law as provided under CCS pension rules. The said order also suffers from being a cryptic and non-speaking order. So the tribunal found 2 errors. One, you did not non-consultation with the UPSC, and the second one, that it is being cryptic and speaking order. So therefore, the entire file was placed before the UPSC. The UPSC issued an order, which your lordships will find at page 256. They said this officer is not under the employment of the central government, but it is under a statutory body. They referred to the UPSC exemption rules called
UPSC exemption from consultation regulations 1958. And by referring to regulation number 5, they said this does not come to us. My lord, please have a look at page 256. The 256 where it begins, but what may be relevant at this point in time would be the last para in page 260.
Let us read the rule itself first.
Yes, my lord. So I have produced
Read
a
that
copy.
rule.
Yes, I have produced that regulation at page 245.
45.
In exercise of the powers conferred by the proviso to clause 3
Next.
of article so and so,
Apply.
Idrali 5, regulation 5 at page 247. It shall not be necessary to consult the commission in regard to the making of an order in any disciplinary case other than an original order by the president imposing any of the following. So in this case, the order was not passed by the president or in the name of the president, but it was by the highest body is the board of trustees. So citing this, the UPSC at page number 260,
It shall not be necessary to consult the commission in regard to any matters mentioned in subclause D of clause 3 of article 20. Let us read that.
Constitution. my lord.
Padi, Constitution. Clause 3 of article 320.
Yes. Article 320 deals with the functions of the Public Service Commission.
Correct. Central Public.
Yes, my lord. The article, sub-article 3 of under 320 says the UPSC
UPSC and
or the state commission as the case may be. Otherly C would be relevant, clause C.
be consulted on all disciplinary matters affecting a person serving under the government of India or the government of a state in a civil capacity, including memorials or petitions relating to such.
Now, in exercise of this power, the regulations of 1958 were framed. That is not in question. The validity of the regulation not in question. The UPSC, by relying on regulation number 5, has passed an order saying that you need not consult us.
But when Constitution says he should be,
Alla, but our government of India baradilla.
allela,
Our statutory body bartare.
now statute.
EPFO, Employee Provident Fund Organization, is a statutory body.
But
For Article 12 purpose, my lord, they may be
Not
state.
12.
Yeah.
there is a judgment of apex court. There is one judgment, I think 91 Supreme Court, which treated whether employees of Urban Development Authority, which is a statutory body, or civil servants or not. Correspondingly, it treated another statutory body of the central government supervision, saying they are civil servants. There is such a judgment.
No,
Justice Raman.
but now please have a look at what the
He
UPSC
is
says.
employee of which? He is employee of the Provident Fund Authority.
Organization.
Ah,
Yes,
there is such a judgment. Just verify. And
we'll
come
verify.
back.
Verify. We'll verify.
There
But
is
see,
such a
my lord,
judgment.
now, my lord, I am in a situation where the UPS says, don't consult me. And my lord, the tribunal says, I am initiating contempt against you. That is my difficulty. But I can't force the UPSC to consult. I have placed the entire file. They pass a detailed order. And they say, we are not liable to.
Shuvagide, contempt.
Allah, the contempt, my lord, I have produced the copy of
10-12.
Hmm?
10-12 ಇದೆ.
10-12 ಇದೆ.
Barkadi. Issue emergent, but we don't subscribe as of now to your idea that employees of PM
Allah, my lord,
are not
the-
civil
My
servants.
lord, that is,
UPSC may
that is
say
of the UPSC. That is of the UPSC.
UPSC ಗಾರ ಪೇರ್ ಹಾಕ್ತಾರೆ. Is it a party?
Amaresh.
Is it a party?
Idral party ಇಲ್ಲ ಅವ್ರು.
But the petitioners are directed to array UPSC as respondent number
2.
as second respondent. First, learned panel counsel, Shri so and so,
ಶ್ರೀಹರಿನ
Srihari, Mr. Srihari is requested to accept notice for the newly added respondent UPSC. First, petitioner to serve copy of the petition along with all the documents on him today itself. And file acknowledgement in the registry, first off. Issue emergent notice to the first respondent, first off. Interim order as sought for till next date of hearing, first off. This interim order will take effect after acknowledgement of service of the petition on the UPSC council is filed in the registry, comma, and not otherwise.
We'll do it. I'm grateful to you.
Simple illa, ad nodkon barbeku. Civil servant concept ne complete
I thought-
treated by, but
I
you
thought
ca-
the-
UPSC cannot, you
Alla-
have said, I have no control over
True, true, true,
UPSC. If they say we will not, you will
True,
not
true.
be,
My lord, I thought the ideal situation would have been the first respondent to challenge that UPSC order, to say that it is not in compliance with.
ಬೇರೆ ಅದನ್ನ ಮಾಡ್ಕೊತ್ ಕೊಡ್ಬೇಕಾಗತ್ತೆ employee.
I'm sorry.
Employee will has to go on challenging these orders.
ಹೌದಾಗುತ್ತೆ. But my lord, I as.
Of course, we understand your difficulty. Therefore, we gave that interim order. Yes.
I'm grateful.
ಅಲ್ಲಿ having heard learned ASG ಅಂತ ಬರಿಬೇಕು ಮೇಲ್ಗಡೆ. ಲಕ್ಷ ಇಟ್ಕೊ. Having heard learned ASG ಶ್ರೀ ಕಾಮತ್ so and so ಅಂತ ಮಾಡ್ಬೇಕು. Okay.
Grateful.
ಅಲ್ಲಿ office objection ಏನು? Overruled. Office objection being insignificant is overruled. Yes.
I'm grateful.
Okay. Which is that judgment, Mr. Prithvi, which said the employees of statutory authority can also become civil servants.
Duryodhan Sahu.
Duryodhan, easy to remember name also. Duryodhan Sahu. Yes, correct. Very, he's on his toes always, yes.
That's I'm for the petitioner. In
Ah.
both the matters, my lords, I'm for the petitioner.
Ah.
This is the matter where the tribunal has failed to read one government order in full sense, my lords. It has read the order in isolation. That is my submission. It is that matter, my lords. Both of them were to be connected and it is posted, my lords.
ಈಗಾಗಲೇ ಇದಾಗಿದೆಯೇನು? ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
Yes, my lords.
ಯಾರು appear ಆಗ್ತಾರೆ?
Yes, ma'am. I appear for respondent number 3.
All right. Office objection ಏನದು?
Dispensation of translation in both the matters.
All right. In the second week of January, we'll put this matter.
My difficulty is that in one first matter, there is an interim order, my lords. Second matter, interim.
ಫಸ್ಟ್ ನಲ್ಲಿ ಇದ್ರೆ ಇಂಟರ್ವ್ಯೂ ಸೆಕೆಂಡ್ ನಲ್ಲಿ ಕೊಟ್ಟಿಲ್ವಾ?
Kotila, because of the reason that I have been relieved. By the time it was posted before the court, I was relieved.
Relieved on which date?
My lords, before the court, I'm sorry, my lords, that exact date is not available. with me.
Premature transfer, my lord.
Premature transfer.
2 times he has approached the KAT. KAT has quashed 2 times also.
You appear for whom?
Respondent number 3.
3.
Yeah.
You support his
Yeah,
case? ಇಲ್ಲ ಅಪೋಸ್ ಮಾಡ್ತೀರಾ? ಅಲ್ಲ ಮತ್ತೆ ರಿಲೀವ್ ಈಗಾಗಲೇ ರಿಲೀವ್ ಆಗಿದ್ರೆ ಹೆಂಗೆ ನಾವು ಇದು ಮಾಡೋದು? ಮೇನ್ ಮ್ಯಾಟರ್ನ ತಗೋಕಾಗ್ತದೆ ಅಷ್ಟೇ.
That's why, my lords, that's the difficulty.
ರಿಲೀವ್ ಆಗಿದಾರನು?
In the connected matter, he's relieved. The first,
Instructions are lordship, one of the respondent, your lordship, has made a representation seeking Chitradurga to post him in.
Yes, my lord, I have made.
ಚಿತ್ರದುರ್ಗ.
Last time, your lordship, last time you have directed the respondent to
Kumar.
provide the posting. He was not he was without posting, my
It
lord.
was without posting.
Yes, my lord, your lordship have directed the respondent to provide the posting and he has made the representation. I'm producing that.
But is called. ಅಲ್ಲ ಈಗ he wants ಚಿತ್ರದುರ್ಗ. ಏನು ಮದಕರಿ ನಾಯಕಗೆ ಏನಾದ್ರು ಸಂಬಂಧ ಪಡ್ತೀರಾ ನೀವು?
ಎಲ್ಲಾದ್ರೂ ಪರವಾಗಿಲ್ಲ.
ಮದಕರಿ ನಾಯಕಗೆ ಏನಾದ್ರು ಸಂಬಂಧ ಪಡ್ತೀರಾ?
ಇಲ್ಲ ದಾವಣಗೆರೆಲ್ಲೂ ಕೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ದಾವಣಗೆರೆ.
ದಾವಣಗೆರೆ as well as ಚಿತ್ರದುರ್ಗ or any other place.
ಎಷ್ಟು ಚೆನ್ನಾಗಿದೆ ಅದು, that novel by ತರಾಸು, ದುರ್ಗಾಸ್ತಮಾನ, about ಚಿತ್ರದುರ್ಗ and ಇದು ಕನ್ಸಿಡರ್ ಆಗ್ಬೇಕಾ?
ತಾವು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ, ಅದ್ರ ಬೇಸಿಸ್ ಮೇಲೆ ಸಬ್ಮಿಟೆಡ್ ದಿ ರೆಪ್ರೆಸೆಂಟೇಷನ್.
ಕನ್ಸಿಡರೇಷನ್ ಈಗ ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಮಾಡಿ? Tuesday? Next week. Call this matter next week. To facilitate in the meanwhile due consideration of representation dated 13/11/2024 given by
Fifth
respondent.
respondent.
Huh?
Fifth.
Idne respondent.
In
Fifth
W-
respondent in second,
yes,
in
WP
Nodama, second.
28009.
Second WP. then. Full stop.
First double.
As on that date, as on the next date, the result of consideration should be intimated to this court without fail, after marking a copy thereof to the said respondent. Next native registry to share a copy, a carbon copy of this order with the learned AGA. All right.
My notes.
Next week, Bharat.
Very well. Once okay.
Entry more to continue. Yes.
I'm appealing for the petitioner, my lords. I'm filing memo for withdrawal. The petitioner herein is
You want
not.
to
interested.
withdraw petition?
Please, my lord. He has already joined to the transfer post, so this matter may be disposed as not.
Counsel for the petitioner has has moved a memo dated seeking leave of the court to withdraw the petition. First off, memo reads as under. It's CGP on request accepting notice for the respondents says that she has no objection.
AGA.
AGA,
Yes.
AGA has no objection. Signed. So first, in view of the above, petition is disposed of as having been withdrawn. First made easy.
Nice.
Next.
Much obliged.
Withholding of not annual increment, two
Ah.
annual increment with cumulative effect was challenged.
Two annual increments with cumulative effect.
Correct.
Charge in.
The charge is, my lord, there was a notification, public notification to cut and remove the standing trees in the school premises. By that notification issued by the SDMC president and the headmaster to the school, my lord. That notification issued. Subsequently, auction was conducted. 2,65,000 was the highest bidder. On
Felling and taking away.
Please, cut and remove all land, whatever the standing trees which are in the premises of the school, 2,65,000 was first bid. Subsequently, he has to deposit within 10 days, the entire amount. He has not deposited. Then he made a request to the school authority to reduce the amount, since he is saying, if he deposit 2,65,000, he's under loss, he's gone under loss. That is the reason, the SDMC president and the HM, they have reduced some amount, 2,35,000, they have reduced to 30,000, they have reduced 2,30,000, 35,000. He deposited. But in the resolution, while reducing the amount, but I have asked to put the signature.
Huh?
I have asked to put the signature. Resolution was passed to reduce the bid amount. I affix my signature. This is only role I have played.
Who are you?
I am education coordinator to the Srinivasapura Taluk. That instruction was to publish the notification by the DEO, and subsequently, as per the notification also, SDMC president and the HM only public the notification. They reduced the amount.
Correct. ಹೇಳಿದ ಆಯ್ತು ನೀವೀಗ. ಅಂದ್ರೆ ಅವ್ರದ್ದು ತಪ್ಪು ನಮ್ದು ನೀವ್ಯಾಕೆ ಸೈನ್ ಮಾಡಕ್ ಹೋಗಿದ್ರಿ?
Not it was instructed to put.
What is your job chart?
Not kindly sir.
Job chart ತೋರಿಸಿ. What is the designation? What is the gradation of your designation?
I am a middle school teacher.
You are a
On
teacher.
deputation, I was posted as education coordinator on deputation. And one inquiry was already conducted with department. In the inquiry, charges has not been proved. Subsequently, matter was entrusted to the Lokayukta. Lokayukta says charges proved. There is a judgment. Two inquiries are not possible.
It's all right. ಅದು ಆ ರೀತಿ ಅಲ್ಲ. ಹಂಗಲ್ಲ ಅರ್ಥಲ್ಲ.
Preliminary inquiry was conducted, no charges.
Preliminary inquiry ಇದ್ದಾಗ ಅದು second inquiry ಆಗಲ್ಲ. Justice Ramajoy says, it is always open to the employer to conduct preliminary inquiry. And you need not be heard in the matter.
But I was heard.
That is not, even if you are heard,
Please.
that will not bar the regular inquiry. Because preliminary inquiry is never treated as a due inquiry at all. It is for certain purposes.
One submission. The person who made the complaint before the Lokayukta himself also be a signatory to the resolution.
All right, but that is like saying,
he
ನನ್
say-
ಜೊತೆ ಕಳುವಿಗೆ ಅವನು ಬಂದಿದ್ದ ಅಂತ.
But he is
That
saying
makes no sense.
that even in the examination.
Brother, AGA, 2 appears to be too much. Decision is taken by whom? the concerned municipal body president plus school headmaster ತಗೊಂಡಿದ್ದಾರೆ. ಅವ್ರ ಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರಿ ನೀವು? ಏನ್?
Against the SDMC, no, president, there is no action.
ಪ್ರೆಸಿಡೆಂಟ್ ಮೇಲೆ ಏನಿಲ್ಲ.
ಇಲ್ಲ.
ಅವ್ರು ಇಮ್ಯೂನ್ ಫ್ರಮ್ ಆಲ್.
Only against HM and me only.
ಪ್ರೆಸಿಡೆಂಟ್ ಮೇಲೆ ಯಾಕೆ ತಗೊಳ್ಳಿ? ಪ್ರೆಸಿಡೆಂಟ್ ಹೂ ಹೆಡ್ಮಾಸ್ಟರ್ ವಿಲ್ ಒಬೇ ವಾಟ್ ದ ಪ್ರೆಸಿಡೆಂಟ್ ವಿಲ್ ಸೇ. ಈಗೆಲ್ಲ ಎಲ್ಲಿ ಅಷ್ಟೊಂದು ಗಟ್ಸ್ ಇರ್ತದ ಎಂಪ್ಲಾಯೀಸ್ಗೆ, ಮೇಲಿನವ್ರಿಗೆ ಇನ್ನೂ ಹಂಗೆ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಹೇಳುವಷ್ಟು. ಅವ್ರು ಹಂಗೆ ಹೇಳಿದ್ರೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ ಹಾಕಿಬಿಡ್ತೀರಿ, ಅಥವಾ ಇನ್ನೂ ನಮಗೆ ಯಾವುದೋ ಒಂದು ಜಾತಿ ನಿಂದನೆ ಕೇಸ್ನಲ್ಲಿ ಸಿಗಿಸ್ತೀರಿ, ಅವ್ರನ್ನ ಏನೋ ಒಂದು ಮಾಡ್ತೀರಿ ಮಿಸ್ಚೀಫ್ ಅನ್ನ. ಅವ್ರ ಮೇಲೆ ಯಾಕೆ ತಗೊಳ್ಳಿಲ್ಲ? ವೈ ನೋ ಆಕ್ಷನ್ ಅಗೇನ್ಸ್ಟ್ ದ ಪ್ರೆಸಿಡೆಂಟ್, ಎಲೆಕ್ಟೆಡ್ ಪ್ರೆಸಿಡೆಂಟ್? ಯಾವ ಪಾರ್ಟಿ ಅವನು? Selected president. Which party he belongs? He belongs to perhaps the party in power.
ಅಲ್ಲ, ಬಿಡ್ಡನ್ನೇ ಆಲ್ಟರ್ ಮಾಡಿದ್ದಾರೆ. ಬಿಡ್ಡನ್ನೇ ಆಲ್ಟರ್ ಮಾಡಿ.
That's all right. That's a great thing. You did it, whatever. But he is only, he says.
Signatory, he was also responsible officer to that, your lordship.
What is his job chart?
Otherwise, there was no occasion.
What is his job chart?
ಅಲ್ಲ,
Job chart ಏನು? ಒಂದು increment ಮಾಡಿ ಸಾಕು. ಒಂದು increment. ಯಾಕಂದ್ರೆ you have not taken any action against the president. You should have taken that action actually. ಬರ್ಕೊಳ್ಳಿ. ಒಂದು increment ಮಾಡಿ. ಒಂದು increment with cumulative effect.
ಅದು 15,000 ಮಾತ್ರ, ಮತ್ತೆ ಫೈನ್ ಬೇರೆ ಹಾಕಿದೆ. 30,000 ಮಾತ್ರ ರೆಡ್ಯೂಸ್ ಆಗಿರೋದು. ನಾನು 15,000 ಮತ್ತೆ
ಹೆಡ್ ಮಾಸ್ಟರ್ 15,000. ಪ್ರೆಸಿಡೆಂಟ್ ಏನ್ ತಗೊಂಡು ಅವನಿಗೆ ಅವನ ಕೈನ ಏನಿಲ್ಲ, ಮತ್ತೆ ಅದನ್ನ ಅಮೌಂಟ್ ವಾಪಸ್ ಕೊಡ್ಬೇಕು. ರಿಕವರಿ ಇಸ್ ಪ್ರೊವೈಡೆಡ್ ಅಂಡರ್ 8 ರೂಲ್ 1I. Recovery
only put the signature.
Why did you put signature? Signature is very dangerous. Though it's very small, it can create havoc.
ಅದರಲ್ಲಿ ಅವನು ಬಿಡ್ಡಲ್ಲೇ ಬರ್ತಿರ್ಲಿಲ್ಲ. ನಾನು ಬರಲ್ಲ ಅಂತ ಈ ಡಿಕ್ಲೈನ್ ಟು ಅಕ್ಸೆಪ್ಟ್ ದ ಬಿಡ್ ಆಲ್ಸೋ. ಸಬ್ಸಿಕ್ವೆಂಟ್ ರೆಡ್ಯೂಸ್ ಮಾಡಿ ಅಂತ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದಾಗ ಕಮಿಟಿ ಹ್ಯಾಸ್ ಟೇಕನ್ ಅ ಡಿಸಿಷನ್. SDMC president ಮತ್ತೆ HM. It was nothing to do that.
Why did you put your signature?
That is the mistake.
ಅದಕ್ಕೆ ಮತ್ತೆ ಪನಿಷ್ಮೆಂಟ್, ಮಿಸ್ಟೇಕಿಗೆ ಪನಿಷ್ಮೆಂಟ್ ಆಗೋದು. ಬರ್ಕೊಳ್ಳಿ. Allowed in part. Punishment is downwardly modified, confining it to withholding of 1 annual increment with the cumulative effect instead of 2. However, the order for recovery of rupees 15,000 from the petitioner is kept intact. This court is aware that ordinarily where the charges are proved, what punishment needs to be awarded is a matter left to the domain of employer or competent authority. First off, doctrine of proportionality. ಅದೊಂದು ರೆಫರ್ ಮಾಡಬೇಕು.
Grateful.
ಅಲ್ಲಿ ಇನ್ನೊಂದು ಸೆಂಟೆನ್ಸ್ ನೋ ಆಕ್ಷನ್ ಈಸ್ ಟೇಕನ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ಪ್ರೆಸಿಡೆಂಟ್ ಆಫ್ ಯಾವ ಪ್ರೆಸಿಡೆಂಟ್?
CMC president.
CMC president.
DMs.
Yes. Yes.
School development.
School development board president.
ಇಲ್ಲ ಎಂತದು ಎಂ ಅಂದ್ರೆ ಏನದು?
School development management.
School development management committee.
SDMC
committee. First off, had he been there in the decision making, some action ought to have been taken against him, and that would have eventually reduced the financial liability of other delinquents. First, that constitutes error apparent on the face of the record, warranting interference of this court. Okay. Please. Yes. Next. Look at R2, R3, personal city. Okay.
I appear for the counsel for the petitioner, my lords. The office objection, my lords, is with regard to translated copies.
Yes,
My lords,
dispensed.
please.
What is the
Lords,
matter?
Matter, my lords, pertains to the compassionate ground appointment. My lords, the petitioner's my lord's father was working as a constable and he expired, my lords, during the course of the employment. My lords, on 13/8/2014, he expired.
13/8/2014.
He expired, my lords. Within a period of 1 year, that is, my lords, nearly 6 months, my lords, within which the mother files an application seeking compassionate ground appointment.
The deceased's mother or widow?
My lords, the petitioner's mother or the widow.
Petitioner's mother. Widow had filed.
Widow, my lords. My lords, she files, my lords, application on 9/2/2015. My lords,
13/8/2014 is the date of death.
yes, my lords.
9 February 2015 is the application
Yes, my lords.
filed by widow.
Yes, my lords.
Ah.
That is within a period of 1 year, my lords, satisfying the requirement of the rules. My lords, the application, my lords, came to be considered by the authority, my lords, on 22/9/2018. That is after a period of 3.5 years.
13/8/14 is death in harness.
9/2/2015.
9/2/15 widow applied.
22/9.
Order dated
Lords, 22/9/2018.
2018. Order denying or granting?
What, my lords, the authority says, since the widow is at the age of 50, she cannot be considered for the employment. And accordingly, my lords, the authority says that let a communication be issued to the effect that if the application is filed by one of the, my lords, the legal head, then that could be considered. My lords, that they don't communicate, my lords, from 2019/18, my lords, then thereafter, my lords, the petitioner files an application, my lords,
They say
before the
time
tribunal.
barred. Time barred.
No, my lords,
Huh.
they don't say that it is time bar. In 2019, my lords, I file an application before the tribunal stating that since the mother was incapable of, my lords, being considered or holding the post, accordingly, my lords, the daughter should have been considered for the employment. My lords, the application was favorably considered and it was allowed, holding that, my lords, the petitioner's claim for employment should be considered by the authorities. A direction was also issued. Once again, my lords, the authority passes an order stating that the application is not filed within 1 year. And accordingly, the application is liable to be rejected. My lords, ignoring the fact that, my lords, there was already an order passed by the tribunal and one of the member, my lords, was a party to the order. And had the, my lords, application been considered, my lords, within a my lords, a reasonable time,
And
that
rejected.
then, my lords, I would have filed an application, my lords. 3.5 years, my lords, was taken to consider my application, my mother's application. And thereafter, my lords, they reject only on the ground that that particular aspect, my lords, was considered by the tribunal earlier, in the earlier round of litigation.
They have only given representation, my lord. They have not made any application. Let them give their application, my lord.
They give application, again you will say the same thing.
They have not made an
You
only
did not make the
representation, my
application
lord.
at all.
They
Mother
have
had
only
filed
given
an application.
representation.
All right, mother's application is
Yes.
rejected.
Yes.
Did you make an application?
Yes.
Saying that my mother's application is rejected on the ground that she is aged more than 50.
Yes.
That decision you have taken belatedly.
The tribunal.
Had you taken
Yes,
it on the same
my lords.
day, evening,
My lords,
I would have made
I must, my lords, my lords, fairly submit that no such application was made. However, my lords, my contention was that the application filed by the mother was to be considered, my lords, in my name or, my lords, the claim put forth by the legal head. And that was allowed, my lords, by the tribunal, stating
Correct.
that it should have been considered as the one filed by the legal head.
Section 19 of Administrative Tribunals Act.
Not my
ಸರಿ, ಹಂಗೆ
respect-
ನೋಡಿ ಇಲ್ಲಿ ಬೇರೆ ಯಂಗ್ಸ್ಟರ್ಸ್ ಇರ್ತಾರೆ,
Yes,
ಇಂಟರ್ನ್ಸ್ ಇರ್ತಾರೆ, ಸ್ಟೂಡೆಂಟ್ಸ್ ಇರ್ತಾರೆ.
yes,
Because some education should happen
yes.
at least to the judges, judge like me. ಕೊಡಿ, Administrative Tribunals Act ಕೊಡಿ.
Lords, only one.
Where you had the locus?
Rule 5, my lord, mandates for giving an application.
Application has to be filed because credentials ಇದೆ ಅಲ್ಲಿ. Those credentials have to ಅವ್ರಿಗೆ ಕೊಡಿ. I have read that.
Lord,
Let him read that.
Lords,
Read it loudly.
my answer, my lords, my answer to that particular question.
Earlier order.
Earlier order, my lords, which covers, there was a specific direction, my lords, that the application filed by the mother shall be considered as the one filed by the daughter. My lords, that they ignore, my lords, that they ignore. And once again,
Where
my
is
lords,
that order?
please,
ಅದೊಂದ್ ಸರಿ ಓದಿ. ಲಾ ಓದಿ. We want to refresh
Please.
our memory.
Please. Subject to the other provisions of this act, a person aggrieved by any order pertaining to any matter within the jurisdiction of a tribunal may make an application to the tribunal for the redressal of his grievance.
ಅಲ್ಲಿ
Then
ಆರ್ಡರ್
for the purpose of order means,
ಅಗ್ರೀವ್ ಆಗ್ಲಿಕ್ಕೆ
yes,
ಅದು ನಿಮ್ದಿರ್ಬೇಕು. ನಿಮ್
Not
ತಾಯಿಗೆ ಕೊಟ್ಟಿಲ್ಲ ಅನ್ನೋದು ಅದೇ ಒಂದು ಎನಿವೆ ಇಟ್ ಹ್ಯಾಸ್ ನೌ ಆಲ್ರೆಡಿ ಅಟೈನ್ ಫೈನಾಲಿಟಿ ಇಸ್ ಯುವರ್ ಆನ್ಸರ್ ರೈಟ್ ದೇರ್ ಇಸ್ ಒನ್ ಜಡ್ಜ್ಮೆಂಟ್ ILR 86 ಕರ್ನಾಟಕ
yes.
3900 ಇರಬಹುದು ತಗೊಂಡು ನೋಡ್ಕೊಂಡು ಹೇಳಿ ನಂಗೆ.
Please.
When you are said to be, whether the order is necessary or not, which kind of order it should be. Well, ಚಂದ ಬರ್ದಾರ ಅದನ್ನ. Yes, I don't remember the judge who authored that judgment. Yes. So there is a direction to consider mother's application as
Yes,
even.
my lord. Yes, my lord.
A strange order, but anyway, it's an order. Where is that order?
My lords, the order, my lords, is at page number 105, my lords. Lords, it commences.
Read
my
that
lords.
sentence.
Yes, my lords. Lords, para 6, my lords, is the very lengthy paragraph, my lords. I'll read, my lords, only one sentence.
Page.
My lords, page 113. Lords, last sentence. So far as the filing of the application within the period is concerned, when such application is already filed within 1 year by the mother of the applicant herein, which is admitted by the respondent authorities. In that application, while giving the details about the family of the applicant, she has mentioned that she is having 2 daughters and out of 2, 1 is unmarried. Therefore, looking into this aspect, the respondent authorities could have considered the very same application filed within 1 year, though the appointment is claimed by the mother of the applicant. But when the mother of the applicant is not eligible, the request of the family could have been considered, giving appointment at least to the second daughter of the deceased and Srimati Radhamma, who is stated to be unmarried. The respondent authority.
Yes, sir, there is an order. We may not, suppose if this order was challenged by you, perhaps without notice, issuing notice to the other side, we would have dislodged it. But this order remains.
Rule 5 mandates for giving a.
After that
application.
only they have made this order. Rule 5 was there when this order was made.
This order was made on April 2023. Yes, ma'am.
So the Rule 5 was very much
Yes,
there.
yes, ma'am.
This you should have
The
challenged.
endorsement, what they have stated, even that application, my lord, was not.
This, the tribunal says, application of mother to be treated as application by the daughter, unmarried daughter. Rightly or wrongly.
It was binding.
92 Supreme Court says,
Please, my lord.
AR 1992, page 111,
Please, my lord.
para 567, they refer to vide and forceit on administrative law. If an order is made, it may be a wrong order. It may have brand of invalidity on its forehead. Still, it is capable of, it's an order capable of legal consequences unless it is set aside by the courts. Pre-judgmentation.
Yes, ma'am.
So rightly or wrongly, there is an order which says mother's application to be treated as the application made by the daughter. If challenged, we might not have agreed with that. Well, number 1. Number 2, on 13/8/2014, breadwinner died. On 9 February 2015, application was made.
That was within.
And
that-
you made order after 3 years in 2019. Had you taken the order made within reasonable time, say 1 month, 2 months, because Supreme Court said within 3 months, the
Yes.
applications for compassionate appointment,
Should be. considered.
they should be treated within 3 months. Because family, that's the idea is family is in distress, financial distress, breadwinner having died. You took 3.5 years. Had you taken your decision earlier, daughter would have come with her application. All right, sir, take my application. You robbed away that opportunity by your laxity. Follow madbekadu. And you have suffered an order.
Lord,
You suffered.
request, my lord, next week. I'll just take instructions also, my lord.
Next week.
Next week. ma'am.
ಇಷ್ಟೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೊದಲೇ ಹೇಳ್ಬೇಕು. ಇದನ್ನೆಲ್ಲ ಯಾಕೆ ಹೇಳ್ತೀವಿ?
ಅಲ್ಲ, my lord,
We are structuring our order this way ಅಂತ.
My submission is that, my lord, giving her, yes,
Next week
yes, ma'am.
ಮತ್ ಕೇಳ್ಬಾರ್ದು time. Okay, AG requested to accept notice for the respondents. First, call next week. Call week after next ಹಾಕಿ. Yes.
Lords, any date, my lords?
Please, delay ಆಗಿದೆ, I understand, but wait. It will come. If it does not come, move a memo.
Since, my lords, the mother had filed within a period of 6 months, if it were to be decided, my lord,
Expected you would
within
have come out
immediate,
with another
now, if I make one more application, the.
Now they will
result
say
must-
it is time barred.
It is time barred.
That's right. So they want, somehow they are decided to, not to give you. Yes. ವ್ಯವಹಾರ ಆಗಿರಲ್ಲ.
I am her caveator, my lord.
Yeah?
Lord, the respondent, my lord, was a doctor, my lord, government doctor in service. He had, for
Yes.
super speciality, my lord, he had secured a seat in Apollo BGS hospital, my lord. This course is called as DNBSS cardiology, my lord.
TNB.
Yes,
related
yes,
to surgery, etc.
Yes, my lord, cardiology, it is a cardiologist related. DNBSS cardiology, super specialty course, my lord.
Say diploma course.
It's,
Is it a diploma course?
no, my lord, after PG, my lord, it is super speciality course.
Is it a post degree course or?
Degree course, my lord. May I take my lords to page 16, my lord? Page 16. The prayer sought by the respondent is that, my lord, mandamus or appropriate order to the first respondent to issue order granting study leave with salary to the applicant to prosecute higher studies in DNBSS cardiology for 3 years at Apollo BGS Hospital, Mysore, in terms of Karnataka Civil Service Rules 2008 by considering the detailed proposal submitted by second respondent, wide letter dated 3/4/2024, annexure A11. Now, my lords, may kindly peruse the order of the.
He wants a salary during that.
Yes, my lord, that is not permissible.
Rule, read the rule.
Please, ma'am. May I request my lord to kindly see the guidelines also, my lord.
Guidelines.
Yes, my lord.
ಯಾವ್ದು?
That is forthcoming in the order of the KAT itself, my lord. Lordships may kindly permit. In page 22, my lord, para 8, my lord. May I read, my lord? Admittedly, the applicant claims to have completed the 5 years of regular service.
Petition, all right. But payment.
Yes, my lord. If my lords may kindly see in page 23, ಕನ್ನಡದಲ್ಲಿದೆ, ಆರೋಗ್ಯ ಮತ್ತು ಕುಟುಂಬ ಕಲ್ಯಾಣ ಇಲಾಖೆ ತಜ್ಞ ವೃಂದದ ವೈದ್ಯಕೀಯ ಅಧಿಕಾರಿಗಳು ಒಂದು ವೇಳೆ ಸೂಪರ್ ಸ್ಪೆಷಾಲಿಟಿ ಫೆಲೋಶಿಪ್ ನಂತಹ ಸ್ನಾತಕೋತ್ತರ ಕೋರ್ಸ್ಗಳಲ್ಲಿ ವ್ಯಾಸಂಗ ಮಾಡಲು ಬಯಸಿ ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಗಳನ್ನು ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ನಿಯಮಾವಳಿ ಪರಿಶಿಷ್ಟ 11A ಪ್ರಕಾರ 2A, I beg your pardon, my lord, 2A ಪ್ರಕಾರ ಕಟ್ಟುನಿಟ್ಟಾಗಿ ಪರಿಶೀಲಿಸಿ ಅವರ ಸೇವೆ ಜ್ಯೇಷ್ಠತಾ ಆಧಾರದ ಮೇಲೆ ಅಭ್ಯರ್ಥಿಗಳು ಆಯ್ಕೆಯ ಕಾರಣಗಳನ್ನು ದಾಖಲೆ ಮಾಡಿ ನಿಯಮ ಅನುಸಾರವಿರುವ ಕ್ರೋಢೀಕೃತ ಅರ್ಜಿಗಳನ್ನು ಸಂಬಂಧಪಟ್ಟ ವೈದ್ಯಕೀಯ ವಿಜ್ಞಾನ ಕಾಲೇಜ್ ಸಂಸ್ಥೆಗಳಿಗೆ ರವಾನಿಸಿ ಸೂಕ್ತ ಶಿಫಾರಸಿನೊಂದಿಗೆ ಆಯುಕ್ತರು ಆರೋಗ್ಯ ಮತ್ತು ಕುಟುಂಬ ಇಲಾಖೆ ಕಲ್ಯಾಣ ಸೇವೆಗಳು ನಿರ್ದೇಶನಾಲಯ ಇವರ ಸರ್ಕಾರಕ್ಕೆ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುವುದು. My lord, this is very clear, my lord. It says that, my lord, they are allowed to pursue super speciality course, but my lord, they have.
Next ಓದ್ಲಿಲ್ಲ.
Please, my lord.
Next ಇದೆ ನೋಡಿ.
ಸೇವಾ ನಿರತ ಕೋಟಾದಲ್ಲಿ ಸ್ನಾತಕೋತ್ತರ ಪದವಿ ಡಿಪ್ಲೊಮಾ ವ್ಯಾಸಂಗದ
2 ವರ್ಷ ವಯಸ್ಸು ಸೇವೆಯನ್ನಾದರೂ ಸಲ್ಲಿಸಿದ ನಂತರವೇ ಆರೋಗ್ಯ ಕುಟುಂಬ ಇಲಾಖೆ ವಿದ್ಯಾರ್ಥಿಗಳು ಒಂದು ವೇಳೆ ಸೂಪರ್ ಸ್ಪೆಷಾಲಿಟಿ ಫೆಲೋಶಿಪ್ ಕೋರ್ಸ್ನಲ್ಲಿ ಅವರ ಹಕ್ಕಿನಲ್ಲಿರುವ ರಜೆ ಹಾಗೂ ಸ್ವಂತ ಖರ್ಚಿನಲ್ಲಿ ವ್ಯಾಸಂಗ ಮಾಡಲು ಬಯಸಿದಲ್ಲಿ ಅಂತಹ ಅರ್ಜಿಗಳನ್ನು ಕ್ರಮ ಸಂಖ್ಯೆ 1, 2 ರೀತಿಯ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ನಿರ್ದೇಶನಾಲಯವು ಸದರಿ ಅರ್ಜಿಗಳನ್ನು ಸಂಬಂಧಪಟ್ಟ ಕಾಲೇಜು ಸಲ್ಲಿಸುವ ಮಾಡಿದೆ.
My submission
ನಲ್ಲಿರುವ
They can do.
ಸ್ವಂತ ಖರ್ಚಿನಲ್ಲಿ ವ್ಯಾಸಂಗ ಮಾಡಲು.
Yes, my lord. Now they are seeking, their prayer is, my lord.
What is it?
My lord, this particular government order applies only to the person who have already passed an MBBS and recruited to the as a medical officer. And in service quota, if he has deputed first time for a PG course, and he is supposed to, after completion of the PG course, he has to work there for 10 years. Sometimes what happens, after completion of 3 years,
Quit and go.
he will again claim for the super specialty course after 3 years. Then the government say,
Where is your right to seek salary?
yes, ma'am. That your lordship may kindly come to page number 55. That is the appendix 2A of cases. That is the rule.
50?
55 mil. That's the rule. Appendix 2A.
Fine.
Rules regulating deputations of or grant of study leave to government servant for prosecutions of special course of study consisting of higher studies or specialized training within India. So either prakara, either
There is the right to receive
I will go
the
with-
remuneration.
Yes, it is here. So the person who has been deputed for the first time for the higher studies, he is entitled for that. This is here, my lord.
ಎಲ್ಲಿದೆ?
I just. During the period of deputations, the government servant shall be, page number 57, may kindly see. 57. 57 of the rule.
Para?
First para 8. During the period of deputation,
Para 8.
first para 8, yes. Para 8, my lord. Page number 57.
56.
57 mil. Oh, sorry, mil.
During the period 56.
During the period of deputation,
Government servant shall
the
be
government
eligible to
service
draw.
shall be eligible to draw salary ETC, basic pay, DNS allowance, ETC, so and so. Again, either stipend, it is not applicable to me. Then C, it is not applicable to me. D, the tuition fees, if any, is prescribed for the course of said training. My lord, this is the first time that I have been deputed for the super specialty course, my lord, number 1. I have not already used the
Read 8A.
8A. 8A, which is salary, my lord.
During the period, a government servant shall be eligible to draw salary.
Salary, that
basic
is-
pay DA.
Basic pay,
HRA.
HRA and city corporation
CA.
allowance, which is would have been drawn
Would
for
have
the
drawn,
dependent
but-
for higher studies or specialist training. During the period of extension, the government servant shall be eligible only for leave salary admissible.
Yes, it
under
is
this.
there, na?
If it is extension, I am in.
What do you say?
My lord, for pursuing PG course, my lord, they are entitled for this.
Therefore, I asked you, is it a diploma course or a PG course? You did not answer that point. I guess
TNBB.
this is how it case will go. Whether the course which you have chosen,
Please, my lord.
is it a diploma course which you will do after graduation or post-graduation? Or is it a PG course itself?
Lord,
That you are not
normally
answering.
DNBB is a diploma course. my
Now
lord.
you are coming
No,
out
my
with
lord.
that.
Diploma, my lord, but my lord, it is stated somewhere here, my lord, that it is a,
My lord.
ಇರಿ,
it is
ಇರಿ.
not a dip-
ಅವಸರ ಮಾಡ್ಬೇಡಿದ್ರಿ. ನಾವು ತಿಳ್ಕೊಬೇಕು. ನಾಳೆ ನಿಮ್ಗೆ ಕೊಟ್ಟು ಮುಂದೆ ಏನ್ರ ಎಲ್ಲರಿಗೂ ಕೊಡ್ಬೇಕು. The government may depute a government servant who has rendered not less than 5 years for a special course of study.
They
PG
can
course
avail-
ಅಂತ ಎಲ್ಲಿ ಹೇಳ್ತದೆ?
my lord, they can avail this, my lord, only once. That for the course of post-graduation, my lord, not for the super specialty course.
ಎಲ್ಲಿದೆ ಅದು?
That, my lord, if my lords may kindly see the appendix, my lord, what we have,
Appendix ನಲ್ಲಿ special course of study
Yes.
ಅಷ್ಟೇ. Consisting of higher studies or specialized training in a professional or technical subject having a direct or close connection with the sphere of his duty. Suppose psychiatry ಇದೆಯಪ್ಪ, ಅದಕ್ಕೆ ಸೈಕ್ಯಾಟ್ರಿಕ್ ಸಂಬಂಧಪಡದ ಸೂಪರ್ ಸ್ಪೆಷಾಲಿಟಿ ಇದ್ರೆ ಬರ್ತದೆ. ಇಲ್ಲ ನಾನು ಅಲ್ಲಿ ಕಾರ್ಪೆಂಟ್ರಿಗೆ ಹೋಗ್ತೇನೆ.
and well, it is, once they do their super specialty course, my lord, that sanctioned post should be available in the college, my lord.
ಅದೆಲ್ಲಿದೆ?
That, Lord, the KAT, my lord, on that ground only, my lord, has allowed the application.
ಅಲ್ರಿ, ಅವ್ರು ಅಲೋ ಮಾಡ್ಲಿ ಅದ್ರ ಮೇಲೆ ನಮಗ್ ತೋರಿಸಿ. may give some reason, wrong reason. If he is otherwise entitled to, how can we deny that? The object of this rule is to promote making value addition. One should become knowledgeable.
Please, my lord.
ನಾಲೆಡ್ಜ್ ಈಸ್ ಪವರ್ ಅನ್ನೋದಕ್ಕೆ ಆ ರೀತಿ ಫ್ರೇಮಿಂಗ್ ಆಗಿದೆ ಪಾಲಿಸಿ ಆಫ್ ದ ಸ್ಟೇಟ್. ಬಿಕಾಸ್ ಇಫ್ ಹಿ ಎಕ್ವೈರ್ಸ್ ಮೋರ್ ನಾಲೆಡ್ಜ್, ದಿ ಸೊಸೈಟಿ, ದ ಕನ್ಸ್ಯೂಮರ್ಸ್ ಹೂ ಹೈರ್ ಹಿ ಸರ್ವಿಸಸ್ ವುಡ್ ಬಿ ಬೆನಿಫಿಟೆಡ್. ಅದರ್ವೈಸ್ ಈ ಕಡೆ ಹೋಲ್ ಹಾಕೋ ಬದ್ಲಿ ಇನ್ನೊಂದ್ ಕಡೆ ಸುತ್ತ ತರ್ಕೊಂಡು ಇನ್ನೊಂದು ದೊಡ್ಡ ಹೋಲ್ ಹಾಕ್ತಿರ್ತಾನ. ಹಂಗ ಆಗ್ಬಾರ್ದು ಅನ್ನೋ ಕಾರಣಕ್ಕೆ ಹೈಯರ್ ಕೋರ್ಸ್
My lord, if this
education.
were to be allowed, my lord, it will be a floodgate, my lord,
ಫ್ಲಡ್
because
ಗೇಟ್ಸ್ ಓಪನ್ ಆಗ್ತದೆ, ನೀವು ಫ್ಲಡ್ ಕಡಿಮೆ ಮಾಡ್ಕೊಳ್ಳಿ. ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ? ನಿಮ್ ರೂಲ್ಸ್ ಇಟ್ಕೊಂಡು ಫ್ಲಡ್ ಗೇಟ್ ಓಪನ್ ಮಾಡಬೇಕು ಅಂತ ರೂಲ್ ಇದ್ರೆ ನಾವು ಓಪನ್ ಮಾಡಬೇಡದು ಅಂತ ನಾವು ಹೇಳಕ್ ಬರ್ತದ? ಯುವರ್ ರೂಲ್ ಪ್ರೊವೈಡ್ಸ್ ಫಾರ್ ಓಪನಿಂಗ್ ಅಪ್ ಆಫ್ ದಿ ಫ್ಲಡ್ ಗೇಟ್ಸ್.
my lord, I
ವೆರಿ
agree,
ಫ್ಲಡ್
my-
ಗೇಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇರೋದ 5% ನೋಡಿ, ರೂಲ್ ನಲ್ಲಿ 5% ಫಿಕ್ಸ್ ಮಾಡಿ. ಏನ್ ಫ್ಲಡ್ ಗೇಟ್?
ಅಲ್ಲ, normally
ಕಾವೇರಿ ಬೇಸಿಗೆಯಲ್ಲಿ ಕಾವೇರಿ ನದಿ ಆದಂಗ ಆಗಿರ್ತದೆ ಎಲ್ಲ ರೀತಿ ಎಂತದಿಲ್ಲ. ಫ್ಲಡ್ ಗೇಟ್ ಓಪನ್ ಮಾಡಿದ್ರು ನೀರ್ ಹರಿಯೋದ 5%. 5% ಅಂತಿದೆ ನೋಡಿ ರೂಲ್ ನಲ್ಲಿ. ವಾಟ್ ಫ್ಲಡ್ ಗೇಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್? You want to spoil your case?
No.
You don't want to spoil it?
No.
And keep quiet.
it says, my lord, a government servant shall not ordinarily be deputed for, but my lord, my submission is that, my lord, guidelines has to be looked into, my lord.
Guidelines have to be.
Yes, my lord,
Suppose
guidelines.
the guidelines run counter to your rules. These rules are made under either 309 or under the 1978 Civil Services Act. Is it not?
Lord,
How
we-
guidelines can override?
they may be permitted to pursue their super specialty course, my lord,
Yeah.
subject to, my lord, they have to avail their rightful leave and, my lord,
ನೀವು ಹೇಳೋದು ನೆಕ್ಸ್ಟ್ ಕ್ಲಾಸ್ನೇ ಬೀಳ್ತದೆ ಬರಲ್ಲ. ಅಲ್ಲಿ ಟ್ರೈನಿಂಗ್ ಡ್ಯೂರಿಂಗ್ ದ ಪೀರಿಯಡ್ ಆಫ್ ಎಕ್ಸ್ಟೆನ್ಷನ್, there is extension alone. The government servant shall be eligible only for leave salary admissible under these rules. Not a case of extension. You are sending him for a particular course so that he makes value addition, comes back,
this,
serves the society more efficient.
this rule has to be very specifically, my lord, only for higher.
Barkat. No grounds to interfere in as much as.
Lord, my
Rules-
instructions are that, my lord,
Huh?
insofar as super specialty sanctioned posts are there, my lord, except cardiology, my lord, there are no other course. If a person, my lord,
Where is
does it-
that?
Lord, this is the availability, my lord, availability of the post, my lord. If a person pursues post graduation in neurology, my lord, that sanctioned particular post should be available in the,
ಮತ್ತೆ ಎಲ್ಲಿದೆ?
otherwise, my lord, they will be holding the same post of PG, my
You
lord.
are not the rule maker. Is it not? We are only, I am a judge, you are a government advocate. Where is the rule? Rules are made here. What rules say? English judges used to say, there is a maxim, let heavens fall down, follow the law. ಕೇಳಿ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಕೇಳಿ. Yes,
This is
but-
insofar as there is no post sanctioned post. illa
Where
ಅಂತ
is the requirement of sanctioned post? ನೀವು ವ್ಯಾಲ್ಯೂ ಅಡಿಷನ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ಮೇಲೆ
Yes, my lord.
ಈ ವೈದ್ಯನಿಗೆ ಇಕ್ವಲೆಂಟ್ ಪೋಸ್ಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ನಮ್ಮಲ್ಲಿಲ್ಲ, ಹಾಗಾಗಿ ಹೋಗೋದು ಬೇಡ ಅಂತ ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಿ.
Yes, my lord.
That's very well.
Yes, my lord.
Where is the rule to that effect?
In the guidelines, they say that, my lord, ಕಟ್ಟುನಿಟ್ಟಾಗಿ ಪರಿಶೀಲಿಸಿ.
ಅಲ್ಲ, ಬರ್ಕೊಳ್ಳಿ. Dismissed on the following grounds. Rule 8. Enacted, promulgated wide appendix 2 capital A2 KCSR ಇದು.
Yes, my lord.
KCSR provides for deputation of a civil servant for making value addition. Semicolon. They do not prescribe that there should be a post, perhaps a vacancy also, which would match the value addition. First. right to pursue higher studies, especially being recognized and guaranteed, of course, subject to certain conditions and qualifications, cannot be curtailed on the basis of something which does not fit into the intent and policy content of rules of the kind. First, though this aspect of the matter has not been much articulately discussed by the KAT, comma, this court cannot turn Nelson's eye to the same. First, court has to do justice to the cause brought before it and not send the worthy litigant empty-handed back. First off, that would be disservice to the judicial process. Court, where is that, which is that judgment of Oliver Wendell Holmes? Courts exist for doing justice, not for jurisprudential theories. Davis versus, I will quote that one.
It's one submission. The KAT, my lord, has also said, my lord, that the commissioner has recommended for the sent a recommendation to the government, my lord. But, my lord, the annexure A11 clearly indicates he has sent a letter to the government stating that to take further action.
Further
That
action
finding
ಅಂತಂದ್ರೆ
is wrong,
ಅವ್ನು
my lord.
ನಾ ಕಲೀಲಿಕ್ಕೆ ಹೋಗ್ತಾನೆ ಅನ್ನೋದಕ್ಕೆ ಅವ್ರ ಮೇಲೆ ಡಿಸಿಪ್ಲಿನರಿ ಆಕ್ಷನ್ ತೊಗೊಳಿಕ್ ಬರ್ತದ. ಫರ್ದರ್ ಆಕ್ಷನ್ ಅಂದ್ರೆ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ಹಿಸ್ ರಿಕ್ವೆಸ್ಟ್ ಅಂತ ಅರ್ಥ. ಹಿಂಗ್ ಹೇಳ್ತಾ ಇದ್ದಾನೆ, ಅವನಿಗೆ ಪನಿಷ್ಮೆಂಟ್ ಕೊಡಿ ಅಂತ ಹೇಳಕ್ ಬರ್ತದ. ಆಕ್ಷನ್ ಮೀನ್ಸ್ ದಟ್ ವೇ, ನಾಟ್ ಎನಿಥಿಂಗ್ ಎಲ್ಸ್. ಎಸ್, ಆಲ್ ರೈಟ್. Employees, you should see what Siddhaya Puranic said. ಓದಿ ಬ್ರಾಹ್ಮಣನಾಗು, ಬಟ್ ಜನವರ ಹಾಕೊಂಡಲ್ಲ, ಓದ್ಬೇಕು. That helps people. ಕಾದಿ ಕ್ಷತ್ರಿಯನಾಗು, ಏನಾದರೂ ಆಗು, ಮೊದಲು ಮಾನವ. Government, people in government should become ಮಾನವರು first.
Fees is nearly 2 lakhs, my lord, and it will be a great loss to the state exchequer, my lord.
You are spending money for so many things.
And, my lord, moreover, my lord, after
You scrap the rules then.
That's what.
they pursue the super specialty course, and apparently, my lord, they leave the
You frame the rules and
ಮಾಡಿ
follow it.
ಇದು ಕಲ್ಕೊಂಡ್ ಬಂದ್ಮೇಲೆ ಬಿಟ್ಟು ಹೋಗ್ಬಾರ್ದು ಅಂತ ರೂಲ್ ಮಾಡಿ.
bond kotruve, my lord, they will pay the money and
After coming, you are not supposed to leave the institution.
No,
How many
not
years?
supposed to. We have given undertaking, that is there, my lord.
How many years you will?
For 10 years we have to serve, my lord. That is there.
Correct. We have also noted
That is there in the appendix.
that we have also noted assurance of the
Yes.
respondent employee that after making value addition, he would serve the government at least for a period not less than 10 years. 10 years. First off, this also has entered our decision making.
obligation.
Okay. Welcome. Yes, next. Yes, Lord.
The state in the matter, my lords. I'm sorry, my lords, copy ಕೊಟ್ಟಂಗಿಲ್ಲ ನಮ್ಗೆ. Copy
Serve
state
ಆಗಿದೆ.
ಸರ್ವ್ ಆಗಿಲ್ಲ.
ಸರ್ವ್ ಆಗಿದೆ.
ಇನ್ನೊಂದು copy ಕೊಡಿ.
Copy is not served is my instruction.
Without serving
Copy,
office.
copy.
ಇವಾಗ
ಕೊಡಿ.
ಕೊಟ್ಬಿಡಿ.
ಕಾಪಿ ಕಾಫಿ ಎರಡೂ ಕೊಡ್ಬೇಕು. ಕೊಡಿ. ಅಲ್ಲಿ ಮೊದ್ಲೇ ಹೇಳ್ಬಿಟ್ರೆ ಕೊಟ್ಬಿಡ್ತಿದ್ರು.
ಇಲ್ಲ.
ನೀವು ಇಲ್ಲಿ ಕರ್ಕೊಂಡಾಗ 1 hour ನೀವು ಸ್ವಲ್ಪ ಒಂದು ಕಣ್ಸನ್ನೆ ಮಾಡಿ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಕೊಡಕ್ಕೆ.
ಹೇಳ್ಬಿಟ್ಟಿದ್ರೆ
given half a dozen copies to you.
Additional AG was waiting also.
I was not sure whether it was.
ಕೊಡಿ please. ಬಾಣ.
Lord.
ಒಂದು ಅರ್ಧ ಗಂಟೆ ಬಿಟ್ಕೊಂಡ್ ಬನ್ನಿ, ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ನೋಡಿ.
ತೊಂದ್ರೆ ಇಲ್ಲ ಸ್ವಾಮಿ. I don't want my senior friend to wait. You argue.
ಕೊಡಿ.
Copy and ಕೊಡಿ sir.
ಬೇಕು ಅಂದ್ರೆ ಒಂದು ಅರ್ಧ ಗಂಟೆ, ಮುಕ್ಕಾಲು ಗಂಟೆ, 1 ಗಂಟೆ ಕೊಡೋಣ ಅಂತ.
I appeared before the trial court by the.
That's very
before
nice.
the
Yes,
state tribunal.
Yes, what is the matter?
Lord.
Before learned senior starts, may I make one? That my learned friend has filed caveat, my colleague. Would your lordships permit me to appear? My work.
All right. Yes.
So great. That's fine.
No issue. Great. Yes.
Lord, 12/9/24/9/23, my lord. I am posted as Assistant Commissioner, South Zone.
4/9/23.
23, my lord. AC, Assistant Commissioner, South Zone. Bank.
Revenue na?
Commercial taxes.
ACCT.
Yes, yes, CT, commercial taxes. Then, Lord, by virtue of Annexure B, for a moment, Annexure B may be seen. Lord.
Page?
Page.
Page number 24.
24.
Yes. 12/9/2024.
Yes.
Yes, Lord. By virtue of Annexure B, this is dated seal number 123.
12/23.
See the page.
9/23.
No,
Yes.
Name the 120 is correct. 120.
123.
This is a promotion.
No, my lord.
Huh?
128 officers in the state are transferred.
Transferred.
All of them
ಸ್ಥಾನ ಪನ್ನ ಬಡ್ತಿ ನೀಡಿ ಅಂದ್ರೆ ಏನು?
Regular promotion, substantive promotion.
Because of promotion, they are shifted to other places, sir.
That is only in so far as part 1 is concerned.
Part 1.
Page 22.
Part
ಕೆಳಗಡೆ
1 is
ಭಾಗ
concerned.
ಇದೆ.
Part.
You are
So,
right.
Yes. So far as part 2 is concerned, my lord, page 36 may be seen.
36 is part 2.
Part, yes.
Part 1 ಅವರಿಗೆ ಮಾತ್ರ promotion.
Promotion, yes.
Part 2 shifting.
Shifting. 123 is where I am.
123.
120, seal number.
ಶ್ರೀಮತಿ
Page
so
36,
ಶ್ರೀ
yes.
so and so.
120. So and so.
ನೀವೆಲ್ಲಿದೆ?
From ವಾಣಿಜ್ಯ ತೆರಿಗೆಗಳ ಸಹಾಯಕ ಆಯುಕ್ತರು ದಕ್ಷಿಣ ವಲಯ to ವಾಣಿಜ್ಯ ತೆರಿಗೆಗಳ ಸಹಾಯಕ ಆಯುಕ್ತರು ವಿಭಾಗೀಯ ಸರಕು ಮತ್ತು ಸೇವಾ ತೆರಿಗೆ ಕಚೇರಿ 3 ಬೆಂಗಳೂರು. This is
ದಕ್ಷಿಣ ಅಂತ ಎಲ್ಲಿದೆ?
Dakshina first one, 123 first column. Second column.
From that zone.
Yes. But one feature that stands out in this transfer order is, out of all the 128, all of them are transfers after the period of 2 years is over. Only one, mine is a premature transfer.
1 year.
1 year. Made within 1 year. Only mine out of 120.
Retention period ಎಷ್ಟು? 2 years.
2 years, but as per transfer guidelines.
Correct, ah?
Grade A, 2 years.
2 years,
2 years, as per the latest 2024. Now, Lord, on this I go to the K.
ಅದು 24/6/24.
Yes, Lord, 2020. On this I go to the KT, Lord. KT grant stay. And then while at the time of final disposal, till yesterday, at the time of final disposal, not yesterday, before yesterday, 26 till 26, the KT passes an order on a single ground that transfer inter se between Bangalore one office to Bangalore another office, though the offices are different,
Not a transfer.
is not a transfer. Now, Lord, on this, there are 3 division bench judgments and 1 full bench judgment interpreting 2002 transfer guidelines, 2013 transfer guidelines, and 2024. Yes, Chandru. And recent judgment of the Honorable Chief Justice in 2024, interpreting transfer guidelines itself of 2024.
Read last paragraph of 26/4.
Yes.
2024 order.
Order.
Transfer guidelines.
Yes.
Last paragraph.
Yes.
Post ಅಂತ ತೆಗೆದು place ಅಂತ ಏನೋ ಮಾಡ್ದಂಗಿತ್ತು.
ಅದೇ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ para 7 and 11 are almost the same lot of the order, impugned order of the KT.
Which is that Prithvi
Subclause three
judgment
of-
which
subclause-
we interpreted that particular provision.
Amaresh versus State of Karnataka.
copy?
Copy.
7 and 11, in para 7 and 11, the same. Shall I read para 7
of judgment?
of the page 20?
20.
Yes. From about line.
This is what is
Of records, para 7. And submission by state response. We find that the applicant has been working at Bangalore at various posts since her joining.
How long she has been in Bangalore?
From 2020, that's all. Not a long tenure.
May not be.
Not a long time.
How long
Suppose
she
she
has
was there
been in
from
Bangalore?
2010. That's a finding here, Lord. Applicant has been working as in the about the 10th line, it is there. Working as Assistant Commissioner Commercial Tax at Bangalore since 11/12/20.
2020.
Yes. As such, she has completed more than minimum prescribed tenure at a place. Now, Lord, then the tribunal court's MS Purushottam Reddy case saying it is Supreme Court judgment, it is actually Karnataka judgment. In MS Pushottam Reddy versus State of Karnataka, the Honorable Apex Court held that long-standing official in the same city, though worked in different posts, has to be considered as a culmination of tenure. But this was actually a Karnataka judgment, a division bench of Karnataka, not on a Supreme Court judgment. In this case, where applicant has been working as assistant commissioner within the city of Bangalore itself, and impugned transfer order has been. On this blood, Honorable Chief Justice, about a month ago, has passed, about 2 months ago, sir. Interpreting the 2000. Prithvi knows because he is the appellant.
Paragraph?
Not paragraph, the analysis of this point. 22.
ಇನ್ನೊಂದು ಒಂದು ಚಂದ್ರು, another is Gangadhar.
Gangadhar, yeah.
Also, she is working in Bangalore.
Correct. And now, Sudhakar. Para 20 minutes. Shall I read, no?
Para 20.
20. Respondent number 3 was transferred to the regional office, Sarjapura, Bangalore, as environment officer under office memorandum.
Has it taken charge?
320 days. As per clause 6 of the transfer guidelines 2024, respondent number 3 has the protection of a minimum period at a place for 2 years. There is no dispute that the appellant and respondent number 3 are group B officers. It is not in dispute that no reasons have been recorded for premature transfer of respondent number 3. Respondents number 1 and 2 have neither placed any material nor content that the premature transfer of respondent number 2 is in the circumstances contemplated under clause 7 of the transfer guidelines. It is a categorical statement of the learned advocate appearing for respondent 2 that no reasons are being recorded. The learned advocate for the appellant would submit that posting a government servant one office to another within the same headquarters in an urban area is not a transfer and is deployment. He submits that as per explanation in Kannada version, the transfer guidelines 2004 are made inapplicable to deployment. The transfer guidelines are not applicable in the present case. The submission of learned advocate or the appellant is appealable at the first blush. However, it is difficult to accept the contention or examination of the transfer guidelines 2004 to the fullest extent. The transfer guidelines 2024 provides a minimum period of tenure at a place of a government servant in case of transfer or deployment. Office memorandum dated 15/7/24 refers to transfer of officers. Impugned office memorandum posting respondent number 3 from regional office to head office states orders to be transferred, details of posting. The contention regarding the case of deployment is untraceable. As per clause 3 of the transfer guidelines 2024, the transfer process including deployment is mandated subject to conditions stipulated in transfer guidelines 2024 and on consideration of the interest of public servants and in a transparent manner. Clause 3, the applicability of transfer conditions in case of deployment.
26.
26 years. Another aspect needs to be noticed and relevant is the similar situation was provided in the government order dated 7/6/13. Clause 3D of the government order dated 7/3/16 defines transfer and follows a note for the definition of transfer. Same reads as under. Transfer means the posting of a government servant from one headquarter to another headquarters or from one office to another within the same headquarter to take up duties of a new post or in consequence of a change of headquarter. Movement of a government servant, note, within the same office or unit from one post to another.
Not notice the change.
Let's
Para
take,
26.
yes, they noted.
Gangadharaya.
Yes,
What was the text there? One office to another office
yes,
is also transfer.
yes.
Whether textually 26 guidelines have undergone change?
Yes, my lords, may I just point out rule 2(3), my lords, ಅದರಲ್ಲಿ ಅವ್ರು ಹೇಳೋದು ಚಲನವಲನ ಅಂದ್ರೆ ಅದಕ್ಕಿಂತ ಮೊದಲಿಗೆ ವರ್ಗಾವಣೆ ಅಂದ್ರೆ ಏನು ಅಂತ ಹೇಳ್ತಾರೆ. ಎಂದರೆ ಒಬ್ಬ ಸರ್ಕಾರಿ ನೌಕರ ಒಂದು ಹುದ್ದೆಯಿಂದ ಮತ್ತೊಂದು ಹುದ್ದೆಗೆ ಕರ್ತವ್ಯಗಳನ್ನು ನಿರ್ವಹಿಸಲು ಒಂದು ಕೇಂದ್ರ ಸ್ಥಾನದಿಂದ ಮತ್ತೊಂದು ಕೇಂದ್ರ ಸ್ಥಾನಕ್ಕೆ ಅಥವಾ ಒಂದು ಇಲಾಖೆ ಅಥವಾ ಕ್ಷೇತ್ರ ಇಲಾಖೆ ಆಯುಕ್ತರ ನಿರ್ದೇಶನಾಲಯ ಇತರೆ ಕಚೇರಿಗಳ ಪ್ರಸ್ತುತ ಇರುವ ಕೇಂದ್ರ ಸ್ಥಾನವನ್ನು ಬದಲಾಯಿಸಿ ಬೇರೊಂದು ಕೇಂದ್ರ ಸ್ಥಾನಕ್ಕೆ ಕಚೇರಿಯನ್ನು ಬದಲಾಯಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ಮಾಡುವ ಸ್ಥಳ ನಿಯುಕ್ತಿ ಇಸ್ ಟ್ರಾನ್ಸ್ಫರ್.
ಮೊದ್ಲಿನ ಡೆಫಿನಿಷನ್ ಹೆಂಗಿತ್ತು? ಗಂಗಾಧರಯ್ಯ ಅಥವಾ ಚಂದ್ರು ಕೇಸ್ ನಲ್ಲಿ ಇರುವಂತ ಟೆಕ್ಸ್ಟ್ ಆಫ್ ದ ಡೆಫಿನಿಷನ್.
I'll read that also, my lords. ಚಲನವಲನ ಏನೇ ಅಂತ ಒಂದು ಹೇಳ್ತಾರೆ in the 24
Aditya, we are asking whether
I
this is a
understand, but I'll just
duplication
read
of that or
I'll
a
just read
different
it.
text. How that chalana valana?
Madam, service manual is here. I'll just place for your lordship, the earlier guidelines also, it's available in the book itself.
Service manual ಇದೆ. Pulani of the service manual ಇತ್ತಲ್ಲ?
The blue color ಇಲ್ಲಿತ್ತು. Let's the earlier definition, my lord. May I just read it, my lord? The transfer means posting of a government servant from one headquarters to another headquarters or from one office to another within the same headquarters.
You are reading from judgment itself.
No, yes, madam. The earlier definition of transfer is
That
quoted.
I am doubting whether it was like that.
It was.
I read that actually.
Yes.
They only.
ಅದಲ್ಲ. ಇನ್ನೊಂದು blue colour.
ಇದಲ್ಲ.
Eh,
Grey
yeah,
color
that-
ಒಂದು ಯಾವ್ದೋ ಒಂದು
yes,
ಇತ್ತಲ್ಲ, ದಪ್ಪ
yes.
ಇರುವುದು.
Very well. 2013.
Is there textual difference in Chandru, in Gangadharaya,
And in the recent one.
and in June 26 guidelines? ಏನಿದು? Manual, ಕೊಡಿ ಅವರಿಗೆ. ಇತ್ತು ಪೃಥ್ವಿ ನೋಡಿ ಹೇಳಿ.
ಇಲ್ಲ, please, I don't have it.
There, my lord, 5(1) creates that departure. I'll just read, my lord, because say,
All India service.
5(1) of this 24
All India
guideline
service.
says,
5(1)
5(1),
of which guideline?
2024 guidelines,
24
page 15. Lord. It applies it to both transfer and deployment.
Place it. ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಿ ನೀವು?
5(1), but that is in the case of suspension, lord.
Suspension.
Suspension, where transfer should not be made beyond the period of general transfers except in the following circumstances.
Correct. But transfer ಅಂದ್ರೆ ಏನು ಅಂತ?
Ah.
That idea itself has undergone change.
Yes, yes, notion.
Now we give our judgment,
Let's
give that
Maresh
our
versus-
judgment, how
Maresh.
we held.
So this was culled out in the statement which was filed before the honorable tribunal. May I just read that minutes if what permits. Transfer means transfer of a government servant from one central post to another central post for performing the duties of another post, or in case of transfer of office to another central post by changing the present central post of a department or other office posts.
ಈಗಿಂದ ಹೆಂಗಿದೆ?
Even though I'm sorry, I don't have the English version notes.
ಕನ್ನಡದಲ್ಲೇ ಓದಿ.
ಪ್ಲೀಸ್ ವರ್ಗಾವಣೆ ಎಂದರೆ ಒಬ್ಬ ಸರ್ಕಾರಿ ನೌಕರನನ್ನು ಒಂದು ಹುದ್ದೆಯಿಂದ ಮತ್ತೊಂದು ಹುದ್ದೆಯ ಕರ್ತವ್ಯಗಳನ್ನು ನಿರ್ವಹಿಸಲು ಒಂದು ಕೇಂದ್ರ ಸ್ಥಾನದಿಂದ ಮತ್ತೊಂದು ಕೇಂದ್ರ ಸ್ಥಾನಕ್ಕೆ
ಹಂಗಂದ್ರೆ ಏನು?
ಅಥವಾ ಫ್ರಮ್ ಒನ್ ಹೆಡ್ ಕ್ವಾರ್ಟರ್ ಟು ಅನದರ್ ಹೆಡ್ ಕ್ವಾರ್ಟರ್ ಫಾರ್ ಟು ಕ್ಯಾರಿ ಔಟ್ ಇಸ್ ಅಫಿಷಿಯಲ್ ಡ್ಯೂಟಿ.
ಹೆಡ್ ಕ್ವಾರ್ಟರ್ಸ್ ಅಂದ್ರೆ ಏನು?
ಕೇಂದ್ರ ಸ್ಥಾನದಿಂದ ಮತ್ತೊಂದು ಕೇಂದ್ರ ಸ್ಥಾನಕ್ಕೆ ವುಡ್ ಬಿ ಫ್ರಮ್ ದಿ ಒನ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಹೆಡ್ ಕ್ವಾರ್ಟರ್ ಟು ಅನದರ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಹೆಡ್ ಕ್ವಾರ್ಟರ್.
ಅವ್ರು ಹಂಗೆ ಹೇಳ್ತಿದ್ರು.
ಅಲ್ಲ ಕರೆಕ್ಟ್,
ಹೌದು,
ಬಟ್
ಬೇಕಿದ್ರು.
ಕೇಂದ್ರ ಸ್ಥಾನ ಇಸ್ ವಾಟ್ ದೇ ಸೇವ್ ನೋಟ್ಸ್.
Therefore we are asking you,
Please,
what is
Vilas.
meant by ಕೇಂದ್ರ ಸ್ಥಾನ? ನೀವ್ ಹೇಳ್ದಂಗಿದ್ರೆ ಜಿಲ್ಲಾ ಕೇಂದ್ರ ಸ್ಥಾನ ಅಂತ
Yes.
ಇರ್ಬೇಕಿತ್ತು
Yes.
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಆದ್ರೆ.
ಅಥವಾ ತಾಲೂಕು ಅಂತ.
We have to interpret as they are, because these guidelines have statutory force.
Yes,
One-
Lord.
Because of full bench.
Please.
Chief Justice.
ಕೇಂದ್ರ ಸ್ಥಾನ ಅಂತ ಎಲ್ಲರೂ ಡಿಫೈನ್ ಕೇಳ್ರಿ ನಿಮ್ ಎಂಪ್ಲಾಯಿ ಗೊತ್ತಿರೋರು. ಕೇಂದ್ರ ಸ್ಥಾನ ಅಂದ್ರೇನು? ಒಂದು ಕೇಂದ್ರ ಸ್ಥಾನದಿಂದ ಇನ್ನೊಂದು ಕೇಂದ್ರ ಸ್ಥಾನಕ್ಕೆ ಹಂಗಂದ್ರೇನು ಅಂತ.
Head quarters is what he is saying, not the
Headquarters
district
really
headquarters.
list
ಈಗ ಒಂದ್ ಊರಲ್ಲಿ ಎರಡು ಆಫೀಸ್ ಇದೆ.
Please, not.
ಯಾವ್ದು
ಆಯ್ತಾ?
ಕೇಂದ್ರ ಸ್ಥಾನ?
ಇಲ್ಲಿ KR ಸರ್ಕಲ್ ಅಲ್ಲಿ ಒಂದಿದೆ, ಇಲ್ಲಿ GPO ಹತ್ರ ಒಂದಿದೆ. ಅವ್ ಎರಡು ಬೇರೆ ಬೇರೆ ಕೇಂದ್ರ ಸ್ಥಾನನ ಒಂದೇ ಕೇಂದ್ರ ಸ್ಥಾನ?
ಈ ಪ್ರಶ್ನೆ ಹೇಳು ಅದಕ್ಕೆ.
ಅದನ್ನ ಹೇಳಿ.
ಅವರು ಇಂಗ್ಲಿಷ್ ವರ್ಷನ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ನಮ್ಗೆ ಅರ್ಥ ಬೇಕು.
What do you mean by ಕೇಂದ್ರ ಸ್ಥಾನ?
ಜಸ್ಟ್ ನೋಡ್ರಿ ಸಣ್ಣ ಗೈಡ್ಲೈನ್ಸ್.
ಕೇಂದ್ರ ಸ್ಥಾನ generally translate of course to headquarters.
Correct.
ಇಂಗ್ಲಿಷ್
This is the headquarter or that is the-
ಹಂಗಂದ್ರೆ ಏನು ಅಂತ? ಹೆಡ್ ಕ್ವಾರ್ಟರ್ಸ್ ಅಂದ್ರೇನು?
ಏನು?
ಕೇಂದ್ರ ಸ್ಥಾನ ಅಂದ್ರೇನು, ಹೆಡ್ ಕ್ವಾರ್ಟರ್ಸ್ ಅಂದ್ರೇನು? ಎರಡು ಇಂಗ್ಲಿಷ್ ಮತ್ತು ಕನ್ನಡದ ಅರ್ಥ ಇದು ಆಗಿದೆ.
ಹೌದು.
ಅವುಗಳ ವ್ಯಾಖ್ಯಾನ ಏನು ಅಂತ ಬೇಕು.
Yes.
ಅವುಗಳ ಡೆಫಿನಿಷನ್ ವಾಟ್ ಚೇಂಜ್.
My
To
understanding.
some extent, para 34 has taken up that word, though not the question raised by your lordships. That it is not
34,
answered. Para 34 of the existing judgment, 34. It creates a distinction between transfer or deployment and says it is one identical. In view of the above discussion, there is no gainsaying that it has to be concluded. Transfer guidelines which are statutory in nature apply both whether the shifting of the employee is termed as transfer or deployment. In the instant case, there has been violation of the minimum period prescription. The view held that the conclusion arrived at deserves to be applied.
ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು ಅಂದ್ರೆ ಟ್ರಾನ್ಸ್ಫರ್ ಅಂತ ಕರೀರಿ, ಡಿಪ್ಲಾಯ್ಮೆಂಟ್ ಅಂತ ಕರೀರಿ.
It is the same, but not the question raised by your lordships now, which is
question
headquarter
raised
to headquarter.
Other day also we raised that question. Always you drop, there is one small poem by one Irish
Yes.
lawyer. I am the draftsman of all the laws which should contain all the flaws. ಹಾಗಿದೆ ಇದು.
The statutory
clarity
vacuum.
ಹೇಳ್ಬಿಟ್ಟು ಇಷ್ಟ ಸಮಸ್ಯೆ
The definition in English would say headquarters means a principal central administrative office where primary headquarters, related functions and services are performed. So insofar as the headquarters where any principal administrative officer would sit and perform his duties is what to be construed as a headquarters is what the definition.
ಎಲ್ಲಿದೆ ಅದು?
I would find it on the internet, notes. It wouldn't.
ಆ ರೀತಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. Anyway, there is a judgment now.
Please, my lord.
It appears it goes against you.
My lords,
By the bench headed by Honorable Chief Justice.
Yes, my lords. My lords posed me a question as to from when this officer is working in Bangalore.
Yeah.
My instructions are, my lords, from 99 to 2006, he was working as a commercial tax inspector and promoted as a commercial tax inspector from 22nd of July 2006 in Bangalore. And ever since then, she has been working in Bangalore.
Since 2006. All through in Bangalore.
99 also, I'm told, my lords, as a commercial tax inspector,
So he
19,
wants to-
1999.
She wants to be true daughter of Bangalore.
But my lord, out of 128, only I have been picked. That is the issue.
You have been in Bangalore city throughout.
But
Please
this
come
post
to
of
that,
assistant commissioner,
Yes,
this
whatever.
post of assistant commissioner,
Question is.
only from 2020.
Even Kempegowda did not live here. Kempegowda, who founded Bangalore
He came
city,
from-
after being released from the prison by Vijayanagara Empire, he was in prison for 9 years. After that, he came to Bangalore, built this Bangalore city and went out. That being the history, how can your client cling on to Bangalore city? We have to leave the places, na?
No, my lord, what has happened? Issue is this, my lord.
Kindly
As-
come to.
As assistant commissioner, I
come to
came
page
only in
20.
2020.
Your judgment,
Yes, my
20,
lord.
which you read.
Yes, yes.
2015 SCC online 5744.
Yes,
The pith and substance of that is,
yes.
nobody should cling on to one particular city throughout.
Yes,
That is the law.
yes, but not, now what has happened is, of course, I was in different positions as inspector and as various, so far as
Wow.
assistant commissioner is concerned, first time I came here in 2020.
You
as
have
assistant
been in
commissioner.
Bangalore throughout.
Not,
In Bangalore only, you are
Even
promoted to as an
assuming,
assistant
but
commissioner.
one thing.
And you want to be commissioner in the same place.
All that I seek is this, all that I seek
No,
is this.
You are
Out of
not being thrown out
128,
of Bangalore, no? No.
yes, Lord, if.
You are not being thrown out of Bangalore, no?
No.
Then what is the grievance?
But Lord, out of 128
Even
persons.
again in Bangalore only.
Please.
Even
Out
now
of-
also
yes,
in
my
Bangalore
lord.
only.
In Bangalore.
Now also Bangalore.
But issue is, out of 128 persons, I'm the only one picked. And that too for
How
premature.
You have transferred her to which place?
I may read it out, my lords.
Others are.
That of
others
course
are
is a
trans-
change of headquarters.
Notes, we have transferred her from
Within Bangalore, may I just say this, my lord?
Vanij.
ವಾಣಿಜ್ಯ ತೆರಿಗೆಗಳ ಸಹಾಯಕ ಆಯುಕ್ತರು.
She was working as
Cannot
Vanija Terike Ayukta, Sahayak.
Why so many years
Sorry,
she has been
Pattu.
kept in Bangalore?
ವಿಭಾಗೀಯ ಸರಕು ಮತ್ತು ಸೇವಾ ತೆರಿಗೆ ಕಚೇರಿ.
Why she has been kept in Bangalore for all these years? What is that? Nexus.
So nexus is what I would humbly submit, my lords. I would only want to bring my lord's notice that a show cause notice was issued for some dereliction of duty, for which he again has replied and we are yet to take action.
That is
during the
on election work.
Because
Lord.
many
No, no,
cases
I
are
only
coming-
wanted to
No,
say.
that is on election work, not related to this duty.
I'm
Election
saying that it is
deputation
not
work.
related. At that point of time, there was
And
some
the
dereliction of duty. a show
Tribunal
cause
has
notice-
negated that issue.
We want to know,
Please, my lords.
because many cases are coming before us.
Please.
We have enlisted certain cases in one judgment. We will do it again.
Please, my lords.
Why in Bangalore only? But why all others also should have access to capital of the city,
True, my lords.
the state?
True, my lords.
Why only one person in
Understand.
Bangalore throughout?
Please.
How is that?
2006. There has to be a reason for that, my lords, if at all. if
But
it's
you have to
possible.
give that. reason.
Please, no, I'll
We
get
do
some
not.
instructions to say as to why this person.
But many
if not
commercial
anybody
offices
else, was
are in
kept
Bangalore.
Bangalore since
Commercial
years.
tax offices.
1999.
Many commercial tax offices are in Bangalore.
Purushottama Reddy matter, the division bench said, it is not the prerogative of the chosen few to remain in Bangalore
That's
or
a-
Mysore.
That,
They should go out
that was intra
23 years
Kolar.
he has worked in Bangalore.
Where you,
at 2:30. 2:30.
where you will go?
But Lord, one thing stands out, Lord. This is what I place before your lordship for consideration.
Ah.
Out of,
At 2:30 ಬನ್ನಿ.
Ah.
2:30.
I'll get some instructions.
2:30 ಅಲ್ಲ, 1:30 ಗೆ ಹೇಳ್ಬೇಕು, ಯಾಕಂದ್ರೆ 2:30 ಅಲ್ಲ. Yes, at 2:30.
2:30.
2:30. You should say why she is retained
Please,
for 18 years in Bangalore.
23, my lord, 19. in the-
23 years.
19 to the,
What about other people?
I understand, my lord, so I will indicate.
Many aspirants are there who want to come to city on medical ground, education of the children,
I'll
this,
indicate.
that, etc. Why this lady here?
Whether it was on our own motion or anything else, I will.
Lord,
I
one
will
issue,
submit.
Lord, one issue of discrimination, Lord, I place it before your lordships for consideration. Out of 128 regular transfers.
Only one is done that way, you read that.
That, and
We will do it different.
out of 128, 127 are after 2 years. Only me,
No,
I am
we-
picked.
We are another thing. We are a writ court. Certain factors have come to our notice now. We have we cannot, turn our blind eye to all these things happening. We have to see that the things run fairly.
Please.
Be it in court corridors, be it in administration, subject to all just exceptions.
Please.
If we come across a glaring case, then others will feel something bad about this institution. That impression we will not give. Come at 2:30. Mr.
Lord, can it be,
I'll come back at
can it
2:30.
be,
Please.
Lord, can it be tomorrow morning?
Tomorrow morning, we have no sitting, na?
Or Monday? ke?
Monday, my lord.
Monday?
Please.
Matter having been heard at length.
But in the meantime, they'll
Come on.
report, Lord, that's all. Let them be hold on to the report.
They have already
Then your
taken charge
lordships
is my
can take a-
instruction. No? The contesting respondent has already taken charge today morning is,
Yes.
that's what I
But let there
understand.
be a status quo, because no charge is not
That's
taken.
thunder.
I'm still there, Lord. I'm not relieved.
My
I'm not relieved.
ಅಲ್ಲ relieved ಅಂದ್ರೆ charge is assumed in.
ಇಲ್ಲ,
your
ಅವ್ರು
absence.
ಹೇಳ್ತಾ
Relieve
ಇದ್ದಾರೆ.
ಮಾಡಿದ.
Charges
Relieve
assumed?
ಮಾಡಿ. Yes, my lord.
That-
Assume because my earlier post, my lords, is occupied by somebody else.
Okay, you cannot go back.
I cannot go back.
That will have cascading effect.
Yes.
Lord, till Monday, let there be a status quo, Lord. Afterwards, your lordship can take a decision.
ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. Okay. Call this matter on Monday for further hearing. First stop. Learned senior advocate, Mr. Vivek Reddy submits that the status quo should be maintained.
Lord, ಏನು ಬೇಡ 2:30ಗೆ ಇಟ್ಬಿಡಿ, I'll manage to.
2:30, ತೊಂಬರ್ರಿ.
Best, please.
So great.
Great.
Yes.
Appearing for.
Yes, sir. Ah,
It is
start.
secured.
Others perhaps we need at least half an hour. Start. You can go for a coffee round or just you can loosen your muscles. Yes. Ah.
Order dated that.
Immediately next 2-3 ಇದಾವಲ್ಲ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಅವ್ರಿರಿ ಇನ್ನು ಉಳ್ದವ್ರು ಹೋಗಿ ಯಾಕಂದ್ರೆ ಏನೋ ಅದ್ರ ಬ್ರೇಕ್ ಆಯ್ತು ಅಂದ್ರೆ therefore
Lordship kindly take up the order dated 14/9/2023, my lord.
14/8
14/9/2023.
14/9 ಏನದು?
On that day, we have placed a memo.
Ah.
Brought to the notice of the court that these are all sites are available for allotment in favor of appellants. On the memo filed by the appellant, this court has passed an order on 14/9/2023. So and so for the appellant has filed a memo of even date and submit that the appellant has identified sites number 893 and 901 or 909 for one.
Already not
allotment.
allotted.
893 has already been allotted. Now, 909/1 is available. Instead of 893, we are giving another site in another layout, my lord. What is taken in
Why
request?
if it is available, why can't you give available site?
893 ಬೇರೆಯವ್ರು allot ಆಗಿತ್ತು. 909/1 ಇದೆ. We have also filed an affidavit that we are ready to allot 909/1.
901/1.
/1. 893 ಬದಲು ಇನ್ನೊಂದು ಸೈಟ್ 1814 in ಕೆಂಪೇಗೌಡ layout is being allotted, my lord. The grievance of the
ಅಲ್ಲ ಈಗ ಅವೈಲೇಬಲ್ ಸೈಟ್ ಎಷ್ಟಿದೆ? ಒಂದ್ ಸೈಟ್ ಇದೆ.
ಒಂದ್
ಅದೇ layout ನಲ್ಲಿ.
ಅದೇ layout ಅಲ್ಲಿ ಒಂದ್ ಸೈಟ್ ಇದೆ.
ಮತ್ತೆ ಅದನ್ನ ಕೊಡಿ ಎಂತ?
ಅದನ್ನ ರೆಡಿ ಇದೆ ನಾವು ಕೊಡಕ್ಕೆ.
What is it?
For which we are ready to accept. Your Lordship may kindly say, as on that day, both the sites were available.
ಏನ್ ಗೊತ್ತಾ? ಈಗ ಎಷ್ಟು ವರ್ಷದ್ದು ಇದು? ಸೂಟ್ ಎಷ್ಟು ವರ್ಷದ್ದು?
2013.
ಸೂಟು
2013,
Ah.
2000.
ಇಲ್ಲ 13 ಆಲ್ಸೋ 13 11 ವರ್ಷ ಆಗಿದೆ ಈಗ.
Put for declaration.
ಕರೆಕ್ಟ್ 11 ವರ್ಷ ಆಗಿದೆ. ಇದೇ ರೀತಿ ನಾವು ಡಿಸೈಡ್ ಮಾಡ್ತೀವಿ, ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ಮತ್ ಬೇರೆ, ಅದ್ರ ಬದ್ಲಿ ಏನೋ ಒಂದು ಟ್ಯಾಂಜಿಬಲ್ ಬೆನಿಫಿಟ್ ಅಂತ ತಗೊಳ್ಳೋದಿದೆಯಲ್ಲ, that should be the object of litigation.
Like, it was the conduct of the Bengaluru Development Authority, my lord. As on that day, both the sites were available. Subsequently, they have allotted in favor of a politician. In the document executed by the BDA in favor of so and so person is very clear that subsequently it was allotted. As on the date of passing of the order by this honorable court, the site was.
ಯಾವಾಗ ಅಲ್ಲ ಸೂಟ್ ಹಾಕಿದಾಗ ಅವೈಲೇಬಲ್ ಇತ್ತಾ?
ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದಾಗ
ಅವೈಲೇಬಲ್ ಇತ್ತಾ?
Suit Agdaga is site I have to obtain as on instructions as on 2013. I am not aware whether the suit was available or not. As on the day of the passing of the interim order, that's 14/9/23.
ಲಿಸ್ಟ್ ಪೆಂಡೆನ್ಸ್ ಅಪ್ಲೈ ಆಗೋದು ಯಾವಾಗಪ್ಪ?
ಈ ಸೈಟ್ ಮೇಲೆ ಅವ್ರಿಗೇನು ಶೆಡ್ಯೂಲ್ ಈ ಸೈಟ್ ಆಗಲ್ಲ ಸ್ವಾಮಿ.
ಈ ಸೈಟ್ಗೆಲ್ಲ
suit schedule is not this site.
No, our suit is for declaration to declare 1 acre 38 guntas of land is belongs to plaintiff.
ನಿಮ್ ಕ್ಲೈಂಟ್ ಇದಾರ ಇಲ್ಲಿ? ನಿಮ್ ಕ್ಲೈಂಟ್ ಇದಾರ? ಇದಾರ? Your client?
Yes, my lord.
We want to talk to him. Career.
My father in.
Your father? In the case and decide ಮಾಡ್ತೀವಿ ನಾವು ಮತ್ ಬೇರೆ. ಅಕಾರ್ಡಿಂಗ್ ಟು ಲಾ ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ಅಕಾರ್ಡಿಂಗ್ ಟು ಲಾ ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಅವಾಗ ಅನ್ಯಾಯ ಆದ್ರೆ ನಮಗೂ ಸಮಾಧಾನ ಆಗಲ್ಲ, ನಿಮ್ಗೂ ಸಮಾಧಾನ, ನಿಮ್ಗೇಂಗೂ ಆಗೋದೇ ಇಲ್ಲ.
ನಾನು ಹೇಳ್ತಾ ಇರೋದು in this way they are dodging. Before the trial court, they have not accepted about the acquisition of land without notification. Subsequently, before this honorable court, they have accepted that they have acquired the land in the affidavit filed. On the affidavit filed by the commissioner of BDA, we have accepted the offer made by the Bengaluru Development Authority to give alternative site.
ಯಾವ್ದು?
Before this honorable court.
ತೋರಿಸಿ.
By order dated.
ಅದ್ ಬೇರೆಯವ್ರಿಗೆ ಯಾರಿಗೆ ಅಲಾಟ್ ಮಾಡಿರಿ ನೀವು?
1 month prior to the passing of the interim order, my lord, that particular site number 893, the board had resolved to allot it to one MLA whose allotment made in the year 2010 had to be cancelled for other circumstances. So 1 month prior to the interim order itself, that site had been, board had resolved to allot the site. I placed all the board resolution passed by the board along with my objections. So he was also, my lord, an earlier allotee whose site allotment got cancelled and.
Why it was cancelled?
That site, that land came under litigation, because of which that site was not available. Therefore, under Rule 11A, my lord, we are obliged to give an alternate site. This honorable court directed us to consider the case and give him an alternate site. Pursuant to the direction of this honorable court, we considered his representation and gave him an alternate site, 893, my lord.
In his writ petition?
Not in his writ petition, subsequent to the direction of this honorable court.
Which direction? Which PWP?
I filed my objections. In WP number 28060 of 2018, my lord, the commissioner was directed to issue an alternate site. Subsequent to that, my lord, we held an alternate site committee meeting on 18.
ಆ ಸೈಟ್ ನ ಅಲಾಟ್ ಮಾಡಿ ಅಂತ ಮಾಡಿಲ್ಲ. ಆ ಸೈಟ್ ನ ಅಲಾಟ್ ಮಾಡಿ ಅಂತ ಮಾಡಿಲ್ಲ.
Correct, ಸ್ವಾಮಿ. ಅದನ್ನ ಆ ಸೈಟ್ ಮಾಡಿ ಅಂತ ಮಾಡಿಲ್ಲ, alternate site ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರು. ನಾವು ಬೋರ್ಡ್ ರೆಸೊಲ್ಯೂಷನ್ ಅಲ್ಲಿ 1 ತಿಂಗಳು ಹಿಂದೆನೆ, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಪಾಸ್ ಆಗಿನ 1 ತಿಂಗಳು ಹಿಂದೆನೆ ಬೋರ್ಡ್ ರೆಸೊಲ್ಯೂಷನ್ ವಾಸ್ ಪಾಸ್ ಟು ಅಲಾಟ್ ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಸೈಟ್ ನಂಬರ್ ಇಟ್ ಸೆಲ್ಫ್ ಟು ದಟ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಜೆಂಟ್ಲ್ಮನ್. ಐ ಡು ನಾಟ್ ವಾಂಟ್. ಅಲ್ಲಿ alternate site committee report ಅಲ್ಲಿ several sites were considered for several people. ಇವ್ರು ಒಂದೇ ಸೈಟ್ ಸ್ವಾಮಿ. 893 ಅವ್ರಿಗೆ ಏನ್ ಕೊಟ್ಟಿದ್ವೋ ಅವ್ರು ಒಂದೇ ಸೈಟ್. As per the rules, only one site is entitled to, one site we have given to him. Now, what my learned friend wants to say, my lord, is that subsequent to the order passed by this honorable court, we have gone ahead and issued a formal allotment letter to that particular gentleman. All that, no, my lord,
was pursuant to earlier resolution.
Earlier resolution. That's all I want to say. It is not, my lord, a case that after an order was passed that we.
ಆ ಸೈಟ್ ಮತ್ತು ಈಗ ಆ ಸೈಟ್ ಏನ್ ಕೇಳ್ತಾ ಇದಾರ್ಲಿ ಇವರು, ಅಲ್ಲಿಂದ ಈ ಸೈಟ್ ಎಷ್ಟು ದೂರ ಆಗ್ತದೆ?
ಡಿಫರೆಂಟ್ ಲೇಔಟ್.
It must be.
Sorry, madam.
We are asking a question to you. If you know, answer it.
Sorry, madam.
Don't say something by your emotion. We get emotional. ಆ ಲೇಔಟ್ ಸೈಟ್ ನಿಂದ ಈಗ ನೀವು ಕೊಡಬೇಕು ಅನ್ನೋ ಸೈಟು ಎಷ್ಟು ದೂರ ಆಗ್ತದೆ ಅನ್ನೋದು ನಮ್ಮ ಪ್ರಶ್ನೆ. ಅದಕ್ಕೆ ಕ್ಲಿಯರ್ ಕಟ್ ಉತ್ತರ ಹೇಳ್ಬೇಕು.
ನಾವು ಕೊಡವೆ 893 7ನೇ ಬ್ಲಾಕ್ ವಿಶ್ವೇಶ್ವರ ಲೇಔಟ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
ಅಂತ ಮೊದಲಿತ್ತು, ಅದನ್ನೆಲ್ಲ ಈಗ ನೀವು ಕೊಡ್ತಾ ಇರೋದು.
909/1. 909/1 ಸಹ ವಿಶ್ವೇಶ್ವರ ಲೇಔಟ್ ಅಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ.
ಎಷ್ಟು ದೂರ ಇದೆ?
ಅಲ್ಲಿಂದ ಈಗ ಇನ್ನೊಂದು ಯಾವ್ದು ಕೆಂಪೇಗೌಡನ ಏನೋ ಹೇಳಿದ್ರಲ್ಲ, ಅದು ಎಷ್ಟು ದೂರ?
I'll just see. ನೀವು ಯಾರ್ಯಾರಿಗೋ ಸೈಟ್ ಕೊಟ್ಟು ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು ಅವ್ರಿಗೆ ಕೊಡಲ್ಲ. ಯಾವುದೋ MLA ಕೊಟ್ಟೆ ಕೊಡಿ, ಅವ್ರಿಗೂ ಪಾಪ ಅವ್ರು ಏನು ರೂಲ್ಸ್ ಇರ್ತದೆ, ರೂಲ್ಸ್ ಪ್ರಕಾರ ಕೊಡಬೇಕು. ದಟ್ಸ್ ಅನದರ್ ಥಿಂಗ್. ಬಟ್ ಕೇಸ್ ಈಸ್ ಪೆಂಡಿಂಗ್, ಯು ಶುಡ್ ಹ್ಯಾವ್ ಆಫರ್ಡ್ ಹಿಮ್ ದಟ್ ಸೈಟ್ ಈಸ್ ಹಿಸ್ ಗ್ರೀವನ್ಸ್.
ಒಂದು ನಾನು I am personally, my lord, not aware of the distances, but I can say, my lord, it is definitely not less than 5 kilometers. ಯಾಕಂದ್ರೆ ವಿಶ್ವೇಶ್ವರ ಲೇಔಟ್ is on this side of the nice road.
6 kilometers. More than 6 kilometers.
Vishweshwara layout is on this side of the nice road. Kempegowda layout is on that side of the nice road. Therefore, they fall under the shadow of the nice road. Access is going roundabout. As the crow flies, they may be near, but practically they are not near. If my learned friend says it's 6 kilometers, it would be 6 kilometers, my lord. I have no doubt about it. My lord, may I make this submission? I am conscious of your lordship's judgment in Belliyappa's case. I am conscious of the judgment passed by this honorable court in Arunachalam's case. Article 300A, several judgments of this honorable court saying that don't use land without acquisition. I am with my learned friend when he says that his property has been used without acquisition. It's an unfortunate situation. I am not in a position to put the clock back. The best thing that I have to do is to compensate him in accordance with law, my lords. We have given him 2 40/60 sites measuring 4,800 square feet, one site in the same layout, one site in another layout. My respectful request to my learned friend is please take what is given so that at least there will be some satisfaction to what for litigation that he has done for 20 years. Kindly reserve his rights or liberty may be given to him to agitate further if he thinks that he is entitled to more number of square feet and more compensation or damages. Let him take what is given to him. Because I have
ಮತ್ತೊಂದು ಕೇಸ್ ಫೈಟ್ ಮಾಡಕ ಮತ್ತೊಂದು ಕೇಸ್ ಹಾಕೊಂಡು
land ಯಾಕೆ ಅಂತ ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ, ಯಾಕೆ ಅಂತ. The reason why I am saying is this. ನಾನು 15 ಗುಂಟೆ ಉಪಯೋಗಿಸ್ಕೊಂಡಿದ್ದೀನಿ ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಅವ್ರು 19 ಗುಂಟೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. That is also one bone of contention here. Seriously, they are contending. 15 ಗುಂಟೆಗೆ ಗವರ್ಮೆಂಟ್ ರೆಸೊಲ್ಯೂಷನ್ ನೋಟಿಫಿಕೇಶನ್ ಪ್ರಕಾರ ಸುಮಾರು 4,800 4,900 ಚದರಡಿ 4,500 ಚದರಡಿ ಬರುತ್ತೆ. ಅದಕ್ಕೆ ನಾವು 40/60 ಕೊಡ್ತಾ ಇದ್ದೀವಿ. ಇನ್ನ 4 ಗುಂಟೆಗೆ ಬರ್ಬೋದಾಗಿರ್ತಕ್ಕಂಥದ್ದು ಬಹುಶಃ ಒಂದು 20-30 ಅಥವಾ 30-40 ಸೈಟ್ ಬರ್ಬೋದು ಅಂತ ಕಾಣುತ್ತೆ. ಫಾರ್ ದ ಸ್ವಲ್ಪ ಒಂದು 20-30 ಸೈಟ್ಗೋ 30-40 ಸೈಟ್ಗೋ they are missing out on the 4,800 square feet of land. I am not saying, my lord, that let him keep agitating, but let him at least take what is coming to him. If, my lord, if I have wrongfully allotted that site in favor of that other gentleman.
ಅಲ್ಲ, ಅದನ್ನು ಹೇಳಿಕ್ ಬರಲ್ಲ ನಮ್ಗೀಗ. ಯಾಕಂದ್ರೆ ಸೂಟ್ ಆ ಸೈಟಿಗೆ ಸಂಬಂಧಪಟ್ಟಂಗಿಲ್ಲ.
ಸೂಟ್ ಆ ಸೈಟಿಗೆ ಸಂಬಂಧ.
ಆಮೇಲೆ 1 ತಿಂಗಳು anterior to our order.
ಹೌದು.
Board has passed the resolution. Is your stand?
I've produced a copy of the resolution also. My lord, this litigation, my lord, what happened was survey number 50 is a suitable property. Survey number 50 nalli he wants to claim, my lord, that a certain portion 1 acre 38 guntas belongs to him. In effect, what he did was a portion of the land falling in survey number 51, he tried to take a claim title over a portion of survey number 51, my lord. 51 was also a part of acquisition by the BDM, my lord. His suit was dismissed, my lord. In the RFA, my lord, this honorable court said, all right, his land, what he is claiming is in survey number 51, but his land should be somewhere. Where is his land? Why his land is not available? Survey was ordered by this honorable court. Pursuant to the survey, we conducted a survey, and pursuant to the said survey in 2021,
You found 15 guntas.
We saw. Until then, we were not aware, madam. We were not aware that we had used this land without acquisition. It is pursuant to that, then this honorable court directed us, what are you now going to do? You have violated his valuable rights. That is how, my lord, we said that you either take 2 sites in Kempegowda layout. Then my learned friend said, no, we will identify sites in Vishweshwara layout. He identified 2 sites in Vishweshwara layout and gave the numbers before the honorable court. And I said, if they are available, we will allot. If your lordship may kindly see the order dated 49/23, it says, if it is available for allotment. I found out, my lord, and I found out that one site is available, but the other site was already reserved for allotment 1 month prior to the interim order, my lord. Now, my lord, a formal allotment letter, even though issued after the date of the interim order, it was pursuant to the resolution passed an earlier date. Now, the contempt petition that is now, application that is now being preferred is saying that the main litigation is now being given a complete miss. And now, my lord, I am being held on the issue of contempt for that one particular site number 893. And even in the past, my lord, past several hearings, I have requested my learned friend, with all due respect.
ಅದು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಏನೇನಾಗ್ತದೆ ಆ ಸೈಟದ ನೀವೇನು ಇವರಿಗೆ ಮೊದಲೇ ಕೊಡ್ಲಿಕ್ಕೆ ಬರ್ತಿತ್ತಲ್ಲ ಅದನ್ನ ಕೊಟ್ಟರೆ ಎಷ್ಟಾಗ್ತದೆ ವ್ಯಾಲ್ಯೂಯೇಷನ್? ಈಗ ನೀವು ಪ್ರಪೋಸ್ ಮಾಡಿದ್ರೆ ವ್ಯಾಲ್ಯೂಯೇಷನ್
So I mean, as on 15/2/2024 in my affidavit, I say site number 909/1 measuring 2,325 square
Site
feet measures 909/1 in
9/1.
909/1
909/1.
in 7th block Vishweshwaraya layout
Ah,
measuring 12 into 18 meters, my lord.
a feet head.
60/40. 60/40, commonly referred as 60/40, it's 76, 70, 60, 75 square feet less than that.
60/40 na?
12 into 18, if I may say that. Yakandre adu, we give it in meters.
ತಿಳಿಬೇಕಲ್ಲ ನಮ್ ಕಾನ್ಸೆಪ್ಚುಯಲ್ ನಾವು ಅರ್ಥ ಮಾಡಿಕೊಂಡು ನಾವು ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು.
2,325 square feet, my lord.
325. ಅದು ಬೇಕಿತ್ತು ನಮ್ಗೆ.
The valuation of that site, my lord, as on the day I filed the affidavit in February 24, my lord, it was 1,03,69,500, my lord. This is the guideline value, my lord.
1.03.
1.03
value.
at 4,460 per square feet guideline valuation. In B, my lord, the site number 1814, if I may say the particular.
4,900.
4,460 per square feet.
4,460 per
square feet.
All right. ನೀವು ಕೊಡಬೇಕು ಅನ್ನೋದ್ರದ್ದು ಎಷ್ಟು?
ಇದು ಎರಡು ಸೈಟ್ ಇದೆ ಸ್ವಾಮಿ. ಎರಡನೇ ಸೈಟ್ ನಾವು ಡೀಟೇಲ್ಸ್ ಹೇಳ್ಬಿಡ್ತೀವಿ. ಇದು 909/1 ಒಂದು ಕೊಡಬೇಕು ಅಂತಿದ್ವಿ. ಇನ್ನೊಂದು 1814
ಇವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾನೆ ಇದು.
ಇದು ಕೊಟ್ಟಿರೋದ್ರದ್ದೇ.
ಅದು 15 ನೀವೇನೀಗ ಸೈಟ್ ನಂಬರ್ 909/1 is given to him.
Proposed to be given to me is to take it.
Given to him. ಇದು ಒಂದು. ಮತ್ತೊಂದು ಸೈಟ್ ಯಾವುದು?
1814.
This is in a different layout.
This is in Nadaprabhu Kempegowda layout, my lord.
1814.
Nadaprabhu Kempegowda layout.
ಇದು 60/40.
ಇದು ಹೌದು ಸ್ವಾಮಿ. ಇದು 2325 ಸ್ಕ್ವೇರ್ ಫೀಟ್.
ಇದು 2325.
ಹೌದು. ಬ್ಲಾಕ್ 1 ಸೆಕ್ಟರ್ ಜೆ.
ಕೆಂಪೇಗೌಡ.
ಹೌದು ಸ್ವಾಮಿ. NPK layout ಬ್ಲಾಕ್ 1 ಸೆಕ್ಟರ್ ಜೆ. ಇದ್ರದ್ದು
ಎಷ್ಟಾಗ್ತದೆ?
ಗೈಡ್ಲೈನ್ ವ್ಯಾಲ್ಯೂ ಸ್ವಾಮಿ 3,474 per square feet.
ವೇರಿಯೇಷನ್ ಎಷ್ಟಾಗಿದೆ?
ಇದೆ ಎರಡು ಆಡ್ ಮಾಡಿದ್ರೆ ಸ್ವಾಮಿ 1,84,46,550 is the addition of these two numbers. This is the guideline value, my lord.
81 lakh.
1,84 lakh.
ಎರಡು ಸೇರಿಸಿದ್ರೆ
ಇದು ಸ್ವಾಮಿ ಕ್ಷಮಿಸಿ 1814 ವ್ಯಾಲ್ಯೂಯೇಷನ್ 80,77,050 ರೂಪಾಯಿ ಆಗುತ್ತೆ.
ಪ್ಲೀಸ್ ರಿಪೀಟ್.
1,84,00,000.
1.85 ಆಗುತ್ತಾ?
1.85 ಆಗುತ್ತೆ.
ಅದು 1.03.
ಅದು ಮೊದಲನೇ 1.03, ಎರಡನೇದು 0.8 ಆಗುತ್ತೆ. ಇದು ಎರಡು ಸೇರಿ 1.84 ಬರುತ್ತೆ. 1.84 1.85 ಎರಡು ಸೇರ್ಕೊಂಡು ಬರುತ್ತೆ.
ಇದು ಒಂದರದ ಎಷ್ಟಾಗ್ತದೆ?
80 lakhs.
80,77,050 rupees.
0.75.
ಅಲ್ಲ 80.77.
80.75 lakh.
75
ಎರಡು ಸೇರ್ಕೊಂಡು ಅಬೌಟ್ 1,85 lakh ಆಗ್ತದೆ.
ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ಇವತ್ತಿನ ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂ, ಬಟ್ ಮೈ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್
ವ್ಯಾಲ್ಯೂ ಬೇರೆ.
ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಇಸ್ around twice that is what I am not aware of the exact rate, but at least easily twice ಇದೆ. Vishweshwaraya layout twice ಇದೆ ಸ್ವಾಮಿ. Kempegowda layout I am not personally aware of what is the rate. As far as his land is concerned, my lord, 15 guntas solar, the valuation, my lord, the valuation as on today might match the number as for 4,460 per square feet in the first instance. But as far as the Kempegowda layout is concerned, it might be slightly more than that. Vishweshwaraya layout commands a better price than Kempegowda layout. But my lord, this has to be juxtaposed as against the development work that BDA has done in Vishweshwaraya layout, because of which there is an increase in the price, my lord. And the fact, my lord, that we have formed a 60 feet road abutting his land, my lord, which also is one of the reasons as to why there is an usage of the land, which is again, my lord, I'm not justifying my action because of that. I'm saying if you were to look at it in terms of valuations, my lord, there is some amount of benefit which, my lords, my learned friend's client also is receiving by virtue of the development work undertaken by the BDA, my lord. But fact remains, my lord, what we have done is not right.
ಇದು 15 ಗುಂಟಾ ನೀವು ತಗೊಂಡಿರಿ ಅನ್ನೋ ಪ್ರಿಮೈಸ್ ಮೇಲೆ ಮಾತಾಡ್ತಾ ಇದ್ದೀರಿ.
ಹೌದು ಸ್ವಾಮಿ, ನಾವೊಂದು ಅದಕ್ಕೊಂದು
19 ಗುಂಟಾ ಅಂತ
ಅಲ್ಲ, ನಾವೊಂದು ಅಫಿಡವಿಟ್ ಫೈಲ್ ಮಾಡಿದೀವಿ, ಕಮಿಷನರ್ ಅಫಿಡವಿಟ್ ಆನ್ 2/9/2021. ವಿ ಹ್ಯಾವ್ ಎನ್ಕ್ಲೋಸ್ಡ್ ಎ ಕಾಪಿ ಆಫ್ ದ ಸರ್ವೆ ಸ್ಕೆಚ್. ಇದು ಯಾಕಾಯ್ತು ಅಂತಾನು ಅದು ಸರ್ವೆ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ, ಬಹುಶಃ ಅದು ಸ್ವಲ್ಪ ದೇರ್ ಮೈಟ್ ಬಿ ಸಮ್ ಕ್ಲಾರಿಟಿ ಆನ್ ದ ಸರ್ವೆ ಸ್ಕೆಚ್, ಬಿಕಾಸ್ I interacted with the engineers when this sketch was prepared and I tried to understand why such a thing was done. This
ಮೇಡಮ್, ನಿಮ್ ಕ್ಲೈಂಟ್ ಅನ್ನು ಇಡಕ್ ಆಗ್ತದ ಮಧ್ಯಾಹ್ನ 2:30ಗೆ? ನಿಮ್ ತಂದೆಯವ್ರನ್ನ ಕರೀಲಿಕ್ಕೆ ಆಗ್ತದ ಕೋರ್ಟಿಗೆ?
He will take decision.
ಎಷ್ಟು ದೂರ ಇದೆ ಮನೆ ಇಲ್ಲಿಂದ?
13 ಕಿಲೋಮೀಟರ್.
17 ಕಿಲೋಮೀಟರ್.
14 ಕಿಲೋಮೀಟರ್.
ಅವ್ರು ಟ್ರಾವೆಲ್ ಮಾಡೋಂಗಿದಾರ?
ಸ್ವಲ್ಪ is not feeling good health.
ಕಾರ್ ಇದೆಯಾ ಮನೆಯಲ್ಲಿ? ಕಾರ್ ಇದೆ. ಕರ್ಕೊಂಬರ್ರಿ, ನೀನೇ ಹೋಗಿ ಕರ್ಕೊಂಬ. ನೀನೇ ಹೋಗು ಕರ್ಕೊಂಬ. ಕೋರ್ಟ್ನವ್ರು ಹೇಳಿದ್ದಾರೆ ಬರ್ಬೇಕಂತೆ. ಏನೋ ಒಂದು ನಮ್ಗೆ ಅನುಕೂಲ ಆಗ್ತದೆ ಅಂದ್ರೆ ಅವ್ರ ಜೊತೆ ಮಾತಾಡ್ಬೇಕು. ನಾವು ಬರೀ ಲಾ ಹಿಡ್ಕೊಂಡು ಹೋಗೋದ್ರಿಂದ ಅಷ್ಟು ಉಪಯೋಗ ಮುಟ್ಟಲ್ಲ. ಎಷ್ಟೋ ಸರಿ 2:30ಗೆ ಏನು ಬೇರೆ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ? ಆಲ್ಟರ್ನೇಟ್ ಸಜೆಷನ್ಸ್ ಇಲ್ವಾ?
ವಿಶ್ವೇಶ್ವರ ಲೇಔಟ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಸೈಟ್ ಕೊಡ್ಬೇಕು ನಾನು ಹುಡುಕ್ಸ್ದೆ ಸ್ವಾಮಿ. ವಿಶ್ವೇಶ್ವರ ಲೇಔಟ್ ಅಲ್ಲಿ ಸೈಟ್ ಇಲ್ಲ. ಇದ್ದಿದ್ರೆ ವಿ ವುಡ್ ಹ್ಯಾವ್ ಗಿವನ್ 2 sites in ವಿಶ್ವೇಶ್ವರ. ಅದು ಏನಾಗುತ್ತೆ ಸ್ವಾಮಿ, ಪೀರಿಯಾಡಿಕಲಿ ಯಾವಾರು ಒಂದು ಸೈಟ್ ಸ್ಟ್ರೇ ಸೈಟ್ ರಿಲೀಸ್ ಆಗುತ್ತೆ, ಲಿಟಿಗೇಷನ್ ಕ್ಲೋಸ್ ಆಗುತ್ತೆ. ದೇರ್ ಇಸ್ ನೋ ಕನ್ಸಿಸ್ಟೆನ್ಸಿ ಇನ್ ದ ಮ್ಯಾನರ್ ಇನ್ ವಿಚ್ ಸೈಟ್ಸ್ ಅಗೇನ್ ಬಿಕಮ್ ಅವೈಲೇಬಲ್ ಫಾರ್ ಅಲಾಟ್ಮೆಂಟ್. ಜನರಲ್ ಅಲಾಟ್ಮೆಂಟ್ ಆಗಿ 20 years ಆಗಿದೆ.
ಈಗ ಇದು ಇವೆರಡೂ ಸೈಟ್ ಇದೆ
ಸ್ವಾಮಿ, ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಹಾಕಿದೀವಿ, ಇಟ್ ಹಸ್ ಬಿನ್ ರಿಸರ್ವ್ಡ್.
ಮತ್ತೆ ಅದ್ಯಾರಿಗಾರು ಕೊಟ್ಟು ಕೂತಿದ್ರು?
ಇಲ್ಲ ಸ್ವಾಮಿ, we have given this number in the affidavit.
ನಿಮ್ ತಂದೆಯವ್ರು ಕರ್ಕೊಂಬನ್ನಿ.
Please, please.
ಇದೊಂದು ಕೇಸನ್ನ ಚೇಂಬರ್ ನಲ್ಲಿ ಹಿಯರ್ ಮಾಡ.
ಸರಿ,
ಚೇಂಬರ್ ಬನ್ನಿ, ಚೇಂಬರ್ ನಲ್ಲಿ ಹಿಯರ್ ಮಾಡ.
ಪ್ಲೀಸ್ my lords.
ಓಕೆ,
2:30 minutes. 2:30. Oblige my lords.
2:30. ನಿಮ್ ತಂದೆಯವ್ರು ಕರ್ಕೊಂಬನ್ನಿ, ಹೋಗಿ ಬೇಗ ಹೋಗು, ಲೇಟ್ ಆಗ್ತದೆ. 2:30 ಕಳಿಸ್ತೀಯಾ? ಆಗುತ್ತಾ? ಓಕೆ,
Oblige my lords.
ಲೇಟೆಸ್ಟ್ ಏನಲ್ಲ, ಓಲ್ಡ್ ಬುಕ್ಕೇ ಅದು. ಐಡಿಯಾ ಆಫ್ ಜಸ್ಟಿಸ್ ಬೈ ಅಮಾರ್ತ್ಯ ಸೇನ್. He wrote that book in contrast to John Rawls' 2 books. Justice as Fairness ಅಂತ ಒಂದು ಇನ್ನೊಂದು ಬುಕ್ ಇದೆ, ಅದು which I do not know because John Rawls was his professor. ಅಲ್ಲಿ ಅವ್ರು ಹೇಳೋದೇನು ಅಂದ್ರೆ, ನಿಮ್ಮ ಇಂಡಿಯನ್ ಲೀಗಲ್ ಸಿಸ್ಟಮ್ನಲ್ಲಿ ಜಸ್ಟಿಸ್ ಪಡ್ಕೊಳ್ಳುವಾಗ ಬೈ ಅಂಡ್ ಲಾರ್ಜ್ ಥಿಯರಿಯನ್ನ ಕಣ್ಮುಂದಿಟ್ಕೊಳ್ಳಿ, ಗಣಿತದ ತತ್ವಗಳನ್ನ ಕಣ್ಮುಂದೆ ಇಟ್ಕೊಳ್ಬೇಡಿ ಅಂತ ಹೇಳಿದ ನಾನು. ಶೇಕ್ಸ್ಪಿಯರ್ ಹೇಳ್ದಂಗೆ ಮರ್ಚೆಂಟ್ ಆಫ್ ವೆನಿಸ್ ನಲ್ಲಿ 1 pound of flesh, not even a drop of blood ಅಂತ ಹೇಳ್ತಾನ. ಸ್ಕೈಲಾರ್ಕ್ ಅದೇ ಉತ್ತರ. ಸ್ವಲ್ಪ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬೇಕು. ಹಂಗೆ ಅನ್ಕೊಂಡು ಇದು ಬೇರೆ ಎಕ್ವೈರ್ ಆಗಿದ್ರೆ ಮಾಡ್ತಿದ್ವಿ. You have virtually, it's a case of robbery, but you say we never intended all that. That's one aspect. But citizen has lost the land. And you have taken the land.
We have taken the lands.
Regardless of 4 guntas which he says we have lost, you say he has not. That's another thing. At least 15 guntas saman padange. Citizen has lost that land. Not in due process of acquisition.
Not due process.
Not in due process.
I asked the engineer, my lord, as to why they did this. Then what they told, engineer told me, my lord, was that there is already a stone compound put around. That's what he told me, lord, subject to what my learned friend says. That there's already an existing stone compound bifurcating the lands. Now, my lord, what happened was this total extent is around, I think, 4 acres, out of which only part was acquired by us, part was left out. What was left out, a compound wall had already been put by my learned friend's family. Then bit put now ತಗೊಂಡ್ ಬಿಟ್ವಿ. Subsequently, survey nalli it has now been found that we have exceeded. Possibly, my lords, what also has happened is over a period of time, the methodology adopted for survey has changed from chain link method to
that accuracy.
Now, that might also have been one of the reasons why, my lord, now they are able to say that we have exceeded the line. But this is how it has happened.
Chain link ನಲ್ಲಿ ಒಂದು 5% ಹೆಚ್ಚು ಕಡಿಮೆ ಆಗೋ ಪಾಸಿಬಿಲಿಟಿ ಇರ್ತದೆ. ಎ ಎಸ್ ಸ್ವಾಮಿ ಅವ್ರದ್ದು ಒಂದು ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಈಗ accuracy ಬಂದಾಗ ಇವೆಲ್ಲ ಸಮಸ್ಯೆ ಆಗ್ತಾ ಇದೆ.
ಸಮಸ್ಯೆ ಆಗುತ್ತೆ. Lordship, when I was preparing for the matter, my lord, when I read my lord's judgment in Belliyappa's case, Lordship has,
It was in writ appeal.
ಇಲ್ಲ ರಿಟ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ರು.
Correct, writ petition ದಲ್ಲಿ I ordered.
ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಅದನ್ನ ಲಾರ್ಡ್ಶಿಪ್ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಹೌದು, he wrote it, what he directed us to was either to compulsorily acquire the land, first put him back in position, failing which compulsory acquire the land in 2013 act anta. That has been taken to the Honorable Supreme Court. The Honorable Supreme Court has passed the order of stay on that order. Now, my lords, in another matter, where your lordships were sitting in a division bench along with the Lordship Chief Justice, and another matter, in light of the stay granted in Belliyappa's case, no further action was taken and said we'll await the finding to be given in Belliyappa. The reason, my lords, is that vide does not give compensation to the 13 Act, but gives under the 1894 Act. Now, so since we were directed to give under the 2013 Act, my lords, that there is possibly the reason why Honorable Supreme Court directed a stay in the matter. But my lords, when I was preparing, my lords, in Belliyappa's judgment, I was mindful, my lords, observations made at para 12, quoting Jeremy Bentham, in the theory of
Bentham,
legislation
where,
on morals, as to why we should differentiate ourselves from savages. I'm conscious of that. Therefore, I have accordingly amended my submissions to be made. And I'm trying to see if there could be some fair submissions to be made, keeping in mind this valuable right has been taken by us. I'll present myself at 2:30.
Just say that.
Please.
That's the reason I quoted Jeremy Bentham.
Yes, my lord.
Yes.
Obligation.
Pay for the respondents.
The advocate for the petitioner in 14.1.
Yes, sir.
Because I beg to appear for the respondent.
Yes, sir.
Lordship, Senior Counsel from Delhi, Mr. Abhinav Mukherjee is appearing from Delhi.
Yes.
Because before your lordships takes up this case, my lords, I had a preliminary objection on the maintainability. Your lordships may allow me to address on that, subject to whatever procedure your lordships desires.
Okay. Let him start. We will consider that aspect also, Mr. Mukherjee.
Yes, certainly.
Mr. Mukherjee, Mr. Mukhyopadhyay.
My lords,
Mukhyopadhyay became Mukherjee on the tongue of Britishers.
That's right, my lords. And my name, in fact, is a very anglicized version of that.
Okay.
Lord, I appear for the petitioner in 19135. I believe that is 14.1. 14.2.
Perhaps this will take some time.
5 minutes. Nothing very complicated.
Okay.
There is a decree against a company. The executing court has issued directions against the directors to personally make good the liability of the company under threat of arrest and summoning the police into the executing court to direct the directors to give a check for the amount owed by the company. More or less, that is the issue. Therefore, this honorable court has noticed.
Decree is against company. Your case is a Solomon versus Solomon.
Yes, your lordship.
Nothing further to us. No inquiry conducted.
Where is the decree? Let us
My
see.
lord, the decree is at
Decree.
in 19135, my lord, if my lord takes that petition.
Yeah, yes, petitions ಇದೆಯಲ್ಲ.
Three directors, 3 petitions. All directors, not just 3.
Page 29.
The decree is to be found.
Where is that decree?
My lord,
Page 29.
in 19135, page 26.
Identical question I treated about 4 years ago.
My lord.
Identical question, I believe. Can you Google out that judgment?
Certainly, my lord. We will just look it up.
On the same issue,
It
your
was
lordship.
argued by Mr. Krishnamurthy of Lawyers Link.
In fact, while granting an interim order in this matter, my lord, Justice Joshi was only present in the bench at that point of time. There is an order passed by my lord Justice Joshi granting an interim stay in the light of para 14 of the impugned order. In the meantime, my lord, while we look for your lordship's judgment, the decree is to be seen at ink page 26, annexure B. It is dated 28th March 2019. The dispute is between service providers in the telecom services area. Therefore, the authority is the Telecom Dispute Settlement and Appellate Tribunal, New Delhi.
This is treated as a decree.
This is treated as a decree under the provisions of the Act. Yes.
Under which Act?
The TRI Act. The
TRI Act.
The
So
TRI,
it's a
the
deemed
Telecom Regulatory Authority of India Act.
Deemed to be decree.
Deemed to be a decree, my lord. The section also I'll give, my lord. Section 19,
19.
19.
Where is,
My lord, the parties are, petitioner is one of the channels, Discovery Communication India, New Delhi. The respondent is All Digital Network India Limited. It's a company. The operative portion of the decree is to be seen at page 40.
if Discovery Communication India, New Delhi is a company?
Is the channel, Discovery channel in the TV ನಲ್ಲಿ ಬರುತ್ತಲ್ವಾ?
No, just we want.
That's the company.
It's a company.
It's a company. Discovery Communication India.
It's a company. Incorporated
Yes,
company.
yes.
Yes, my lord, it's a company. And the respondent, the judgment debtor, is also a company. At ink page 45, the liability is determined on the respondent company, para 22.
45.
Page 45, para 22. There is no other issue. Not other? There is no other issue to be determined on the basis of issues decided earlier. The petition is allowed, but not for the entire amount of so-and-so, which has been claimed for the period so-and-so. Since the agreement expired on so-and-so, the claim for a monetary decree in favor of the petitioner and against the respondent is allowed only for that period and a further period of 3 months from the date of expiry of the agreement, that is still so-and-so. From the accounts, the due and payable
9
amount.
lakh 82,000, 59.
59 lakh
lakh
82,891 is the decretal amount.
Decree against whom?
Against the respondent company.
You were not parties to that?
No, no. There is no reference to the liability of a director. The directors are
Where
not
is the
personally parties.
execution?
The execution is on the next, my lord, at page 48. In the execution application, at ink page 52, they set out the names of the parties and the parties are only the two corporate entities. At page 52, in the table, column B, name of parties, Discovery Communications India is described as a decree holder versus All Digital Network India Limited as described as a judgment debtor respondent. Whereas on the next page.
How decree against incorporated companies is executed?
By attaching the assets of the company.
Show that, which is that provision?
Under the.
I think there is a provision in CPC, na?
CPC, of course.
If there are
Order 21.
half a dozen judgments on that.
You know, it will, there may not be, to my recollection, we'll just. Well, I'll give this. So. But there may not be a distinction in terms of the person, but the distinction under Order 21 is in the mode of execution in respect of the nature of the decree. If it's a money decree, then by attachment and or arrest. If it is injunction, then by attachment, etc. The various modes of decree, of executing a decree. There is no.
Modes, we're not on
modes. Whether a person owes the money.
Is passed against a company. We cannot imprison the company.
That is.
We cannot arrest it either.
That is.
So in such a way, if the alternate mode provides for arrest and detention, who should be arrested and detained?
My lord.
Or mode itself is not available.
No. My lord has raised a very, very relevant question. What used to happen earlier is that in such cases, the persons behind the corporate entity would be summoned to demonstrate why the decretal amount is not paid. And often earlier, these kind of orders used to be passed, relegating them to detention in civil prison. My lord, there is a celebrated judgment of our Supreme Court, which I have produced by way of a citation, memo of citations. Jolly Varghese. My lord would definitely have heard of this.
Jolly George.
Jolly Varghese.
Jolly Varghese. Okay.
Justice Krishna Iyer's decision.
Jolly Varghese. 80 Supreme Court. 80 Supreme Court. 80 Supreme Court.
My lord's memory. 1982 SCC 360.
Correct. So it was in 80 also.
In 1980, where my lord Justice Krishna Iyer said that detention is not even available for the asking. Only when there is mala fides, when you can demonstrate that the judgment debtor in that case has.
That is another aspect. So in respect of a company, if law provides for going against directors, whether arrest and detention should be resorted to or not was considered by the apex court in the light of the Universal Declaration of Human Rights.
That's right.
That's all.
That's That's
It did not say anything. It did not exempt the directors
certainly.
from the execution process.
That's right.
Therefore, now at least the gap is reduced now between yourself, ourselves, and
The question would still, the
themselves.
question would still remain to the first poser, that for the liability of a company, without looking into the assets of the company or the status of the company or whatever it may be, can the executing court direct execution against the directors? Direct.
Question will be, we can frame that question this way. If the company has suffered a judgment and decree, can it be enforced against its directors or not?
That is the question.
That is the
That is the question.
What's your answer?
Certainly not under no circumstances possible, except where bona fides can be shown to enable the court to lift the corporate veil and look at the directors. If bona fides are there, certain.
Can doctrine of lifting the veil avails in execution proceedings?
In mala fides is what I would venture to say. I would have to do some further reading to test under what circumstances corporate veil can be lifted. Generally, under Companies Act, where corporate veil has to be lifted to examine the conduct, because at the end of the company being a juristic entity, there is some human being behind it. So to test the intentions of the human being, corporate veil can be lifted. Mala fides.
Next, understood. Whether this company has assets?
My instructions are no.
They do not. Company does not have.
From the beginning, it did not have, because it was always a service providing company. It is not a situation where the company, because
But
I took instructions.
Directors are rich.
Directors are also not rich. They are not. And disclosures can be made. The company, this is a situation, my lord, where this Discovery Channel was, that's what I was coming to say. This is a situation where it is a service contract, where Discovery Channel, which is a worldwide global channel, licenses its data for content broadcasting to various consumers in their houses. That is not done by that American company or the large global corporation. That is done through these cable service providers. This company is one such cable service provider for a particular locality, for a particular area. Its only asset
This
is...
company was incorporated in which year?
My lord, I'll have to take instruction.
Ask them.
2013 are my instructions.
2013.
1-3.
Who were the promoters?
No. They are all LLP and so the initial directors were the promoters. Initial directors were the promoters.
Directors happened to be the
Promoters.
Whether the directors have derived income from the company?
Lord, then would my lord then give me some opportunity? I'll take these complete instructions and come, because I can understand the nature of inquiry that is
They
going on.
answer, then it will be whether directors have derived income from the company?
Yes, your lordship.
They have derived.
Well, there will have to be material placed to that extent, because we don't know.
Because after that, Rahul Shah, we are not technical in execution of the decree. After the judgment of Apex Court.
I'm aware.
Court.
Even then, my lord, even Rahul Shah would not allow an executing court to just simply ignore the fact that there is a company and just directly go against the directors. That hurdle will still have to be crossed.
Rahul Shah gives broad guidelines as to how courts should make efforts, not only expedition, how all efforts should be made by the courts in executing the decree.
That is.
Yes. I quoted the
House
of Lords judgment.
And that was subsequently reiterated also.
The Raja of Manda versus 1870s judgment, where it said the difficulty of an Indian litigant begins after obtaining the decree.
Privy Council.
So they have derived income from the respondent, the petitioner, the judgment debtor.
Yes, sir.
Anywhere available? Any material available to say this? Anywhere?
I think there is a part of the order.
It is advisable to place all such submissions with material.
All right. Whether any foundation is laid for invoking the doctrine of lifting the veil in your execution petition?
Mr. Abhinav Mukherjee.
Mr. Mukherjee.
Yes, my lords. If your lordship, yes, I'll just show that, my lords. If your lordship would kindly have annexure D, my lords, which is the execution petition. Set page. Before that, my lords, I'll just tell your lordships without looking at any of the papers. The person who is the petitioner in this particular petition before your lordships is one Mr. G. Karyappa. He was the authorized signatory of the judgment debtor and the director who conducted these proceedings. All the affidavits, my lords, right up to the original decree of the learned tribunal were passed after considering the pleadings signed by him. Number one. Number two, in the course of the original proceedings, my lords, he filed an affidavit before the learned tribunal stating that, my lords, on 16th of March at the relevant time, 2022, that the company has sufficient assets to meet the liabilities if the judgment is ultimately against it. 4th of March 2016 was an affidavit, my lords. It's a sworn statement of Mr. G. Karyappa. Subsequently, my lords, when the decree is passed and the execution is filed, my lords, your lordship will now see page 48 in that light, my lords. And your lordships will just see, my lords, in the execution petition at page 50, paragraph 6, my lords. I have stated as follows, my lords. May I read that paragraph, my lords? Paragraph 6, at the bottom.
Yes.
It is further pertinent to mention here that the authorized representative of the judgment debtor, that is Mr. G. Karyappa, son of so-and-so, living so-and-so, while responding to the affidavit dated 22/2/2016 filed by the decree holder, has categorically stated in the affidavit dated 4th March 16, affidavit filed by the judgment debtor in compliance of the order dated 24/2/16.
Why this affidavit, Mr. Mukherjee, why this affidavit came to be? Did you seek attachment before judgment?
This came in the course of the proceedings, my lords, because I'll tell your lordships, there are a series of orders in the original proceedings where these people were not filing replies, they were not forthcoming before the learned tribunal. And that time, my lords, Honorable Mr. Justice Shiv Kirti Singh was heading this tribunal. He directed them to file certain affidavits. So these affidavits were filed at that particular point of time. This is prior to the original decree, my lords, during the course of the proceedings. So there were various applications being filed for discovery of assets, etc. So that in that discovery of people behind this company. So during the course of these proceedings, my lords, procedural orders were passed from time to time and replies, etc. were being filed. So this was one of the particular affidavits. Then this affidavit gets filed where the affidavit is quoted for reference, my lord. It's also part of my reply before the honorable court. It says, without prejudice to the rights and contentions of the respondent as raised in reply, I state that in the event the present petition is allowed by this honorable tribunal, respondent possesses sufficient means to satisfy the decree passed by this honorable tribunal. Hence, it is clearly evident that the above facts, that despite furnishing above undertaking affidavit, authorized representative of the judgment debtor who is in possession of sufficient means to comply with the final order passed by the tribunal, and the subsequent decree has chosen to commit willful default in not complying with the terms of the decree dated so and so. That's, my lords, first, my lords. Then your lordships will see, I've explained why in paragraph 7, why they have deliberately, my lord, suddenly the assets all supposed to have vanished. And then
whether Mr. Mukherjee, whether there is diminution of assets pendentility?
My lords, that is our case, my lords. That is what we understand. We don't have access to all the records of this particular company. But the affidavit in March says something else, and the reply to the execution was, we have nothing left. And they tried to justify it. My lords, then my lords, after that, what happens is, we have then at page 53 in the execution petition given the particulars of the entity or persons against whom execution is sought, where we have listed out the judgment debtor and the directors at page 53. Does your lordships have that J, serial number J, my lords, where we have listed out? First is Mr. G. Karyappa, who has been the deponent throughout in the original proceedings, as well as before your lordships in these proceedings. He was the deponent in the execution proceedings as well. And then the others, my lords, I have also set out. That is, my lords, to answer your lordship's query, where some foundational facts were laid. Now, what happens before the executing court, my lords, which is the TDSAT cell? Under the Act, my lords, the TDSAT is a specialized tribunal, my lords, set up in New Delhi. It deals with all these disputes between licensor, licensee, broadcaster, etc. It has the decree of the orders of the TDSAT, my lords, under section 19 of the Act. they can be executed as a decree of the civil court, and for that purposes, the tribunal has been given all the powers of the civil court. It's either headed by a retired judge of the Honorable Supreme Court or a retired judge of any Honorable High Court. That's number one, my lords. Number two, my lords, it's a tribunal situated in Delhi, and which is why I was telling your lordships, my lords, at the instant that there is an issue of territorial jurisdiction, my lords, which your lordships are aware, my lords, under Article 227. Your lordships would exercise jurisdiction over tribunals situated within the territorial jurisdiction of the Honorable High Court itself, my lords. This tribunal has no branches, my lords. It is subject to the territorial jurisdiction of the Delhi High Court, my lords. And there is, my lords, your lordships are well aware on this aspect, my lords, that your lordships would not interfere with the orders of the tribunal, which is situated outside my lordship's territorial jurisdiction.
So you want to, if you want to non-suit him on the ground of lack of jurisdiction, it's
Yes,
more
sir.
territorial jurisdiction.
Yes, my lord.
Then to avail that remedy before the jurisdictional court, you should
Yes, my
permit and you should not disturb him.
Lord, that's one, my
Because
lords. But
if you
yes.
pay, no, your relief you can get from X entity. And when he cycles to basically, if he wants to go to that X entity, you should not pull down from the bicycle.
My lords, I have not pulled him down. He himself has got himself pulled down. Please see what the tribunal was doing, my lords. There is an order which has to be executed. The deponent before your lordships today is the same individual who leads the tribunal up to a certain conclusion after adjudication.
That's one aspect.
Objection.
Yes.
Apex court, explain. You said that judgment, I think of 1960s Supreme Court judgment it is, which
Yes.
said why discusses. But thereafter Apex court said, ordinarily the writ court within whose jurisdiction some court or authority has caused injury. Now he has suffered an order of arrest and detention. Arrest and detention. Therefore, its validity has to be by this court only. This court also.
No,
Not
certainly.
necessarily.
May I just tell your lordships, the order which is impugned before your lordships today is not an order where he suffers arrest and detention on the first day. There is a series of events leading up to that order. What happens is he does not disclose the assets. He does not file affidavits on time. These are all part of the execution, my lords. I'm just telling your lordships. I don't want to take your lordships to each and every page. Subsequently, he appears on this particular date. The tribunal is of the view that he has misled the tribunal. Tribunal then, my lords, has been giving him ample opportunities. Tribunal then, my lord, says that I think you should now be detained in civil prison because this is an execution proceeding going on. And you are the person in charge of the affairs of this particular company. You are being the AR and the deponent before the tribunal and all the affidavits. Thereafter, my lords, my learned friend's client makes through his lawyer makes a statement to the tribunal that please don't detain me. I will make good this payment. I will undertake to pay and give a payment schedule to the tribunal. And not only that, my lords, I will also give the names and addresses of the other directors who are in charge of the affairs of this particular company, which is the judgment debtor. The tribunal then defers the proceedings. It doesn't say that arrest and detain him then and there. When the proceedings are deferred, my learned senior colleagues' clients rush to your lordships, and your lordships then grant him the benefit of the interim order of your lordships. That is how the matter is unfolded.
No settlement possible?
My lords, it's a question of money. He pays the money. We are happy, my lords. It's after all, my lordships.
That was my first question when I was briefed in the matter.
Are you
The party
agreeable
says
for
that
because otherwise we have to make some other order. We do not know what kind of order we are going to make, but there is a decree now in their favor that you can, whether your clients are ready to.
I will certainly advise them to avail this opportunity and work out some remedy if possible.
Ask them to come here by 2:30.
Are they present in force? They're present.
Ask them to, they're present before the court. Ask them whether they are agreeable or they want to, want us to pass some order. Ask them.
petitioner. Can you come at 2:30? Well, the petitioner here is not present. Somebody else is speaking. I would rather that he comes.
Where is he?
ಎಲ್ಲಿದ್ದಾರೆ ಅವರು ಇವತ್ತು ಬರಕ್ಕಾಗತ್ತಾ?
Can he come at 2:30?
Out of station ante tomorrow or day after. In fact, that may also enable me to also collect instructions in respect of the assets of the company, assets of the directors.
No, as on that date, when you said.
That
the
affidavit
company
was
has
filed.
sufficient- As on that date, what was the asset position and how it depleted?
Exactly.
That you have to. state.
That is
We'll call it tomorrow.
Note.
Tomorrow,
Tomorrow
we're sitting in.
Note.
Your lordships are giving certain time tomorrow, my lords, or will come in the regular course of the day?
Tomorrow. No, it appears Joshi's client is out of station.
Certainly, my lord, I heard that.
So can we have this matter next week? Can we have this matter?
Certainly.
Next week. Which date?
Whatever date.
Mukherjee, can you come to Bangalore?
My lords, certainly, my lords, it will be my great privilege.
No, we do not know how you are placed. Otherwise, you can argue from.
My lords, I'll come, my lords, lordships desire, I'll certainly come.
Next week, Mr. Mukherjee, anytime.
Next week. Correct.
My lord, I can never
Mr.
say
Joshi, you tell your client also.
I'm aware of where we stand, my lord. We not.
That's very important.
That's.
My lords, if
I'm
it
really anxious to see if there have been any malafidis. If not, then we are just helpless. Malafide is the test.
Can you
Perhaps,
tell Mr. Mukherjee which is the latest decision on invocation of doctrine of lifting the veil, so that we will read and come back.
Lords, what I will also do, I made a note on a case compilation, lords. I will ask Mr. Shibu.
I'll submit that. Yes, your lord.
Right.
Yes, yes.
Okay. We'll read and come so that
Who's
we
my
can save your time.
Great.
Yes. 4th of December. Call this, whether 4th is all right, Mr. Mukherjee, for you?
Acting counsel to tender it to the court master today for your.
4th is
Lords,
okay.
could it be on the 3rd, my lords, or the 2nd? If it could be on the
2nd
2nd,
of,
if it could be
December.
on the 2nd, my lords, 2nd of December. 2nd of December, my lords.
Now, we have another matter that day. Therefore, we said that.
My lords, or 3rd, if not 2nd, on 3rd, my lords.
2nd December. 2nd December, all right. 2nd December.
Grateful to your lordships, my lords. I'm grateful.
Interim order is there?
Yes, ma'am.
Interim order to continue till 2nd of December.
My lords, and I will also have
Call
this
this matter.
compilation tendered today.
Call
Yes,
this
I'll-
matter
I'll
on
submit.
that day
Great.
for
Grateful
further,
to your lordships, my lords. I'm deeply
for further hearing. Yes. And in the meanwhile, please.
I will assist the
Ah.
court. I'll bring the relevant decisions also.
ಅವರಿಗೆ ಚೇಂಬರಿಗೆ ಕರ್ಲಿಕ್ಕೆ ಹೇಳಿ. ಪ್ರಕಾಶ್ ಏನು?
57.
57. 27, huh? In the second week of January, February, January, 3rd week of January. All. ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ನಿಮ್ಮ ಫ್ರೆಂಡ್. Saukar, you are waiting for which case? 28. We do not know whether today it will be. Can you have it in January? December last week?
First week of December, or second week.
First week perhaps it's already jam-packed, our calendar is jam-packed.
Second week.
Second week. We are in the mid of.
In fact, my lord, the other side is a bit anxious to see that the
Matter is
disposed of on that. So an earliest date that this sort of report can give.
the second week na hakiri ನೋಡೋಣ. We'll take a chance. Okay. Anna?
But into the. ಚೀಟಿ ಕೊಟ್ಬಿಡೋದು. ಓಕೆ ಓಕೆ ಓಕೆ. ಓಕೆನಾ? ನೀವು ಇಷ್ಟೊಂದು ಸೈಡ್ ತೊಳ್ಬಿಟ್ರೆ ಇಲ್ಲಿ ಪಾಪ ಅವ್ರು ಹೆಂಗ್ ಹೋಗ್ಬಿಟ್ಟು ಯಾರು ಏನಕ್ಕೆ
ಚೀಟಿ ಕೊಡುವಂತದ್ದು ಏನು ಅದು ಯಾವ್ದು ತೆಗೆದುಕೊಳ್ಳುವಂಥದ್ದು
ಬರ್ತಾರಲ್ಲ ಎಲ್ಲಿ ಹೋಗ್ತಾರ
ಇವಾಗ ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ
ಅವ್ರು ಊಟಕ್ಕೆ ಹೋಗ್ತಾರವಾಗ
ಊಟ
ಬ್ರಾಂಚ್ ಅವರು
140 ಹಂಗೆ ಹೋಗುತ್ತದೆ 140ಗೆ ಹೋಗೋದು.
ಆಯ್ತು. ನೀನ್ ಹಿಂಗ್ ಇಷ್ಟೊಂದು ಇಟ್ಬಿಟ್ರೆ ಸಿಗಲ್ಲ ಕಣ ಇಲ್ಲಿ ಚೇರ್.
ಮೈಕಿಂದ ಒಂದು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಆಗುತ್ತೆ. ಮೈಕ್ ಯೂಸ್
ಒಂದು ಊಟ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತೀನಿ. ಫೈನಲ್ ಗೊತ್ತಾ ನಿಮ್ಮಲ್ಲಿ 230 ಇದೆಯಾ ಅಂತ ಇವಾಗ ನೋಡು.
ಯಾವ್ದು ಇದೆ ಅಂತ
Oh, he's risen.
Sorry. That's it. Externally out.
ರೀಚ್ ಆಗಲ್ಲ 42 ರೀಚ್ ಆಗಲ್ಲ.
Last but one. ಅದು ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲೇ ಇದೆ. ಇದು 230 matters fast.
ಫೈಲೇ ಇಲ್ಲ ನೋಡಿ, ಅದು ಎಲ್ಲ ಮಾರ್ಕ್ ಮಾಡಿ ಅಂಡರ್ಲೈನ್ ಮಾಡಿ ಎಲ್ಲ ಮಾಡಿಟ್ಟಿದ್ದು ಫೈಲೇ ಇಲ್ಲ. ಏನ್ ಈಸಿ ಆಯ್ತು, ಮುಗಿಸ್ಕೊಳ್ಳಿಕ್ಕೆ ಈಸಿ ಆಯ್ತು. ಇಲ್ಲ ಇಲ್ಲ ಚಾನ್ಸೇ ಇಲ್ಲ, ಅದು ಇಲ್ಲೆಲ್ಲ ಇದ್ದದ ಆ ತರ. ಆ ರೀತಿ ಕೊಟ್ಟಲ್ಲ ಆಗೋದಿಲ್ಲ. ಆ ರೀಸನ್ ಕೊಟ್ಟು ನೀವು ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ.
ಸ್ಲೋ ಇದೆ. ಒಂದರಿಂದ ಫೈನಲ್
ಇಲ್ಲ, ಒಂದು ಮ್ಯಾಟರ್ ಕಚ್ಕೊಂಡು
ಈಗ ಏನ್
ಯಾವ್ದು ಸರ್ ಕಾಸ್ಟ್?
ಟೈಮ್ ಆಗಲ್ಲ.
ಒಂದು 31 ರೆಡಿ ಇದೀನಾ? ಯಾಕ್ರಿ ನನಗೆ ಕ್ಲೈಂಟ್
ಎಷ್ಟು ಹುಷಾರ್ ರೇಟ್?
ನಾನು ರೆಡಿ ಇದ್ದೀನಿ. ಬೇಗ ಎತ್ಕೊಂಡು ಹೋಗ್ಕೊಂಡ್ ಬರ್ತೀನಪ್ಪ, ಬೈತಾರೆ ಅಂತ ಹೇಳಿ.
ಹುಷಾರ್
ನಾನು ಮಾಡ್ತೀನಿ, ನಾನು ರೆಡಿ ಅಂತ 34
ನನಗೆ ಊರ್ ಬಂದಿರಲಿಲ್ಲ.
31 ಕಾನ್ಸಿಕ್ವೆನ್ಷಿಯಲ್ ಬೆನಿಫಿಟ್ಸ್. ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟ್ರು ಕಾನ್ಸಿಕ್ವೆನ್ಷಿಯಲ್, ಅದು ಕಾನ್ಸಿಕ್ವೆನ್ಷಿಯಲ್ ಬೆನಿಫಿಟ್ಸ್, ಅದು ಡಿಇ ಮ್ಯಾಟ್ರು. ಬ್ಯಾಕ್ ವೇಜಸ್, ಬ್ಯಾಕ್ ವೇಜಸ್.
ಈವೆನ್ ಸರ್ ಒಂದೊಂದು ಎರಡು ಫೈಲ್.
ಅಲ್ಲ, ನಾನು ಅಲ್ಲಿದ್ದಾಗ ಮಾಡ್ತಿದ್ದೆ. ನಾನು 100 ಫೈಲ್ ತಿಂಗಳಿದ್ದೆ. ನಿಮ್ಮಷ್ಟು ಜನ ಇರಲಿಲ್ಲ. ಒಂದೇ ಊರು, ಒಂದೇ ಗೋಕರ್ಣ ಎಲ್ಲ. ರೆಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ಮಾಡ್ಲಿಕ್ಕೆ ಹೋಗ್ಬೇಕು, ಯಾಕಂದ್ರೆ ಬೈಕ್ ಈಗ ಮೊದಲೇ ರೆಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ಮೈ ಮೇಲೆ ಬೀಳ್ತದೆ ಏನು 34 maybe more simple. 31 is different. 31 let it be interpretation. 34 will be PW1 sorry trap ಆಗಿತ್ತು. shadow witness ಹೊರಗಡೆ ಬರ್ತಿದ್ದ ಅಂತ honorable ಮಾಡಿದ್ದಾರೆ. Everyone is held in our favor. Neither local challenge nor government has challenged. I am reinstated. But back wages system. Rule 99. Rule 99. 99 है रुद्रमणि जजमेंट अलो कर सर वापस आ सकते हैं एक दो मैं आगे मार दिया अंदर टाइम
ಮಾರ್ಕ್ ಮಾಡಿ ಎಲ್ಲ ಮಾಡಿ
ನೋಡಿದ್ದೀವಿ they can't do specialty course because PG, not specialty course. Did I do it? They are claiming salary. What we say, only one time they will pay. This rule is not entitled one time. They say for PG or super specialty or fellowship. This person is pursuing the. Then I told him this what the specialty is doing. Sanction post is not there. I would have one time they will do for super specialty until they will. But however, they are not very clear that so far as salary and not they are but they're in there. The permission to it can be given. What we are saying, we give permission, but they have their expenses. But we are trying to say. I did search yesterday, but print depend card on city lab. I had to be very
Bachchan. Site number 909/1 is available.
It's available.
It is in Vishweshraya layout. Measures 2,325 square feet.
Correct, my lords.
All right. Where is your client? ಕರೀರಿ ಅವರು. ಅವ್ರು ಕೂರ್ಸ್ಕೊಳ್ಳಿ, ಮುಂದೆ ಕೂತು. ಬನ್ನಿ ಇಲ್ಲಿ ಕೂತ್ಕೊಳ್ಳಿ. ಕೂತ್ಕೊಳ್ಳಿ, ಕೂರ್ಸಿ. And site number 1814. That also it measures 2,325 square feet.
Please, my lord.
That is in Kempegowda, Nadaprabhu Kempegowda layout.
Please, my lord.
This site you are giving and this site also.
Please.
The guideline value of the second site, that is site in Kempegowda Nagara,
Please, my lord.
is 3,474 per square foot.
Please.
And the first site in Vishweshraya Nagar, Vishweshraya layout, is that is 4,460 per square foot.
Please.
Okay. These two sites you are giving.
Please, my lords.
Any condition for that?
Lordship, we have filed our affidavit of the commissioner
ಯಾವ್ದು?
on 15/2/2024,
ಕೊಡಿ.
my lords.
ಕೊಡಿ, affidavit ಕೊಡಿ.
15/2 ಕೊಟ್ಟಿದ್ದೀನಿ.
15/2. 15.
Yes, sir.
23.
24. 15/2/24.
15/2/24. 24.
24. Open court. Open court.
ನಿಮ್ಮ ಕ್ಲೈಂಟಿಗೆ ಒಂದ್ಸರಿ ಕೇಳಿ. ಕೇಸ್ ಹಂಗೆ ಉದ್ದಕ್ಕೆ 11 ವರ್ಷ ಆಗಿದೆ ಈಗ ಆಲ್ರೆಡಿ. 11.5 ವರ್ಷ ಆಗಿದೆ. ಆಮೇಲೆ ನಾವು ಇದನ್ನೆಲ್ಲ ಮುಗಿಸ್ಲಿಕ್ಕೆ ಮತ್ತೊಂದು 7, 8, 10 ವರ್ಷ ಬೇಕು. ನಮ್ಮ ಸ್ಪೀಡ್ ನೋಡಿದ್ರೆ ಬೇಕು. ಪ್ಲಸ್ ಅದು ಇಲ್ಲಿಗೆ ನಿಲ್ಲಲ್ಲ. ಮತ್ತೆ ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ಹೋಗಬಹುದು. ಹೌದಾ? ಆ ರೀತಿ ಮಾಡೋ ಬದ್ಲಿ 2 ಸೈಟನ್ನು ನಾವು ಕೊಡ್ತಾ ಇದ್ದೀವಿ. ನಿಮಗೆ ಅರ್ಥ ಆಗ್ತಾ ಇದೆಯಾ? ಅರ್ಥ ಆಗ್ತಾ ಇದೆ. 2 ಸೈಟ್, ಒಂದು ಸೈಟು ವಿಶ್ವೇಶ್ವರಯ್ಯ ಲೇಔಟ್ನಲ್ಲಿ, ಇನ್ನೊಂದು ಸೈಟು ನಾಡಗ. ಕೂತಳಿ ಕೂತಳಿ ಕೂತಳಿ. ಇಟ್ ಈಸ್ ಯುವರ್ ಫಾದರ್, ಡೋಂಟ್ ಟ್ರೀಟ್ ಹಿಮ್ ಲೈಕ್ ದಟ್. ಪ್ಲೀಸ್ ಬಿ ಸೀಟೆಡ್. ಇನ್ನೊಂದು ಸೈಟನ್ನು ಇನ್ನೊಂದು ಲೇಔಟ್ನಲ್ಲಿ ಕೊಡ್ತಾರೆ. 2ರದ್ದು ಮಾರ್ಕೆಟ್ ಪ್ರೈಸ್ ಸ್ವಲ್ಪ ಬೇರೆ ಬೇರೆ ಇದೆ. ಅದಿರತ್ತೆ, ಅದೇ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಇದನ್ನು ನಿಮಗೆ ಅವರು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿ ಕೊಡ್ತಾರೆ. ನಿಮ್ಮನ್ನು ಪೊಸಿಷನ್ ಆಗಿಡೋ ಜವಾಬ್ದಾರಿ ನಿಮ್ದೆ. ವಚನ್ ಪೊಸಿಷನ್ ಕೊಡ್ತೀರಿ.
ಪ್ಲೀಸ್.
ಈ ಉಳಿದಂತ ಗ್ರೀವನ್ಸ್ ಏನಿದೆ ಅವ್ರದ್ದು,
ಪ್ಲೀಸ್ ಮೇಡಮ್,
4.5 ಗುಂಟೆ ಹೋಗಿದೆ ನಮ್ದು, ಅದಕ್ಕೂ ಕೊಡಬೇಕು, ಇದೆಲ್ಲ ಇದೆಯಲ್ಲ, ಅದಕ್ಕೆ ಸಂಬಂಧಪಡಂಗೆ ಅವ್ರು ಇನ್ನೊಂದು ಸೂಟನ್ನು ಹಾಕ್ಕೋತಾರೆ.
ಪ್ಲೀಸ್.
ಆಯ್ತಾ?
ಪ್ಲೀಸ್.
ಆ ಸೂಟ್ನಲ್ಲಿ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಏನಾಗಿದೆಯಲ್ಲ, ಇದನ್ನ ರೆಸ್ಟ್ ಜುಡಿಕೇಟ ಅಂತ ಇಡಂಗಲ್ಲ.
ಆಯ್ತು ಸರ್.
ಅದು ಇಂಡಿಪೆಂಡೆಂಟ್ಲಿ ಟ್ರೀಟ್ ಆಗಬೇಕು.
ಪ್ಲೀಸ್.
ಆ ಸೂಟನ್ನ 1 ವರ್ಷದಲ್ಲಿ ಮುಗಿಸ್ಬೇಕು. ಆ ಸೂಟ್ನಲ್ಲಿ ನೀವು ಲಿಮಿಟೇಷನ್ ಬಾರ್ ಅಂತ ಹೇಳಂಗಿಲ್ಲ, ಜುರಿಸ್ಡಿಕ್ಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳಂಗಿಲ್ಲ ಕೋರ್ಟಿಗೆ.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
ಆಯ್ತಾ?
ಪ್ಲೀಸ್.
ಲಿಮಿಟೇಷನ್ ಇಶ್ಯೂ ಎತ್ತಲ್ಲ, ಜುರಿಸ್ಡಿಕ್ಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ.
ಪ್ಲೀಸ್.
ಎರಡೂ ನೀವು ಎಕ್ವೈಸ್ ಮಾಡಿಬಿಟ್ಟು 1 ವರ್ಷದಲ್ಲಿ ಕೇಸ್ ಮುಗಿಸ್ಬೇಕು. ಆ ರೀತಿ ನೀವು ಕೋಆಪರೇಟ್ ಮಾಡಬೇಕು.
ಪ್ಲೀಸ್.
ಆ ಸೂಟ್ನಲ್ಲಿ
ಆಯ್ತು ಸರ್.
ಎಲ್ಲ ಕಂಟೆನ್ಷನ್ ಅನ್ನು ಓಪನ್ ಇಡೋದು. ನಂತರ ಈಗಾಗಲೇ ಆದಂತಹ ಜಡ್ಜ್ಮೆಂಟ್ ವಿಲ್ ನಾಟ್ ರೆಸ್ಟಿಡಿಕೇಟ್ ದಟ್ ಸೂಟ್.
ಪ್ಲೀಸ್. This issue has not even been
ಈಗ ಇದನ್ನ ಪಡ್ಕೊಂಡು ಅದ್ರಾಗೆಲ್ಲ ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್ ಆಗಿ ಮಾಡುವ ಈ ಡಿಫರೆನ್ಷಿಯಲ್ ಆಫ್
or else to the extent,
ಅಮೌಂಟ್ ಇದು ಎಲ್ಲದನ್ನು ನೀವು
or else to the extent of adjudication of that 4.5 guntas. This matter may kindly be remanded better.
ಹಂಗ ಉಪಯೋಗ ಮುಟ್ಟಲ್ಲ.
ಅದು I think, my lord, if I may say, I think it will come to the writ jurisdiction rather than the civil suit, my lord.
ಮತ್ತೊಂದ್ ಸರಿ
Writ ಹಾಕೊಂಡ್ರೆ it would be.
ನಿಮ್ಗೆ ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಕೊಟ್ಟು ಟರ್ಮ್ಸ್ ಆಫ್ ನಾವು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡ್ತೀವಿ, ಆ ಅಬ್ಸರ್ವೇಷನ್ ದಲ್ಲಿ ಆ ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಕೊಡ್ತಾರೆ, ಇದನ್ನೆಲ್ಲ ಇಗ್ನೋರ್ ಮಾಡಿ ಆ ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಫ್ರೆಶ್ಲಿ ನೀವು ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು. ಅದು ಅದರ ಮೇಲೆ ಏನಾಗತ್ತೆ ಅದು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಇದನ್ನ ಕೊಡ್ಬೇಕು, ಡಿಸಿಷನ್ ಕೊಡ್ಬೇಕು ನೀವು ಏನೋ ಒಂದು. ಬಟ್ ನೀವೇನ್ ಕೊಡ್ತೀರಿ ಅಂದ್ರೆ ನೀವು ಈಗಾಗಲೇ ಹಿಂಗಾಗಿದೆ ಅದು ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಕೊಡ್ತೀರಿ. ಅಷ್ಟು ಉಪಯೋಗ ಮಾಡಿಲ್ಲ ಅದು. ಇಲ್ಲ, ಸಚ್ ಎ ಸೂಟ್ ಈಸ್ ಮೇಂಟೈನಬಲ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಯಾವ್ದು ಧೂಳಾಬಾಯಿ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ MP 5 ಜಡ್ಜ್ ಬೆಂಚ್ ಡಿಸಿಷನ್ ಇದೆ, AR 1969 page 74, 79 something like that. ಅವ್ರು ಹೇಳಿದಾರಂತ ಸೂಟ್ ಮೇಂಟೈನ್ ಆಗ್ತದೆ ಅಂತ. ಜಸ್ಟಿಸ್ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಹಿದಾಯತುಲ್ಲಾ ಜಡ್ಜ್ಮೆಂಟ್.
The lordship may kindly peruse the para 7 at page 3 of the commission's affidavit, my lords. Some of the conditions may have to be.
ಅವರು ರಿಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಎಲ್ಲ ಮಾಡ್ಬೇಕು. ಬಿಡಿ, ಯಾವ್ದು ಕೊಟ್ಟರು ಮಾಡ್ಬೇಕಾಗ್ತಿತ್ತು, ಮಾಡ್ತಾರೆ ಅವರು. ಇವತ್ತು ರಿಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
Admitted position, my lord, is that
5,48,000.
5,48,892. According to us, my lord, what we have to give is 4,492. But by virtue of these two sites, we would be giving 4,650 square feet.
ಎಕ್ಸ್ಟ್ರಾ ಕೊಡ್ತಾ ಇರ್ತೀರಿ.
Additional 158 square feet ನಾವು ಅವ್ರಿಗೆ ಕೊಡ್ತಾ ಇದೀವಿ ಸ್ವಾಮಿ. So 150
ಸಂಬಂಧಪಟ್ಟಂಗೆ 5,48,891.
ಅದನ್ನ ಕೊಟ್ಬೇಕಾಗತ್ತೆ.
ಅದು ಎಲ್ಲಿ ಸೈಟ್ ವ್ಯಾಲ್ಯೂ ಹಾಕಿರಿ ನೀವು ಇದಕ್ಕೆ?
ಅದು
ಯಾವ ಸೈಟ್ ಅದು ವ್ಯಾಲ್ಯೂ? ಅದು
ಎರಡು ಸೈಟ್ ಸೇರಿ.
because
we have not taken it. Okay, I understand, my lord. Whether it's for Visheshwara layout site or the Kempegoda layout. Kempegoda layout site is a lesser cost than.
ಲೆಸರ್ ಕಾಸ್ಟ್, ಇದು ಜಾಸ್ತಿ ಕಾಸ್ಟ್. ಅದಕ್ಕೆ ಯಾವ್ದು ವಿಚ್ ಒನ್ ಯು ಹೌಸ್ ಚೋಸನ್? ಆ ಲೆಸರ್ ಇರೋದು ಚೂಸ್ ಮಾಡಿ.
ಅದು ಲೆಸರ್ ಚೂಸ್ ಮಾಡೋದು.
ಹೌದು.
It is 3474, that's Kempegoda layout, into 158 is 5,48,890.
ಲೆಸರ್ ತಗೊಂಡು.
ಲೆಸರ್ ತಗೊಂಡಿ.
ಕೂತ್ಕೊಳ್ಳಿ.
The application of contempt that has been filed against me may kindly be dismissed.
ಅದನ್ನ ಇದು ಮಾಡಿ.
Please, my lords.
ಬರ್ಕೊಳ್ಳಿ. This appeal by the plaintiff calls in question the judgment and decree dated 31/3/2015 entered by the learned 16th additional city civil judge, Bangalore City, CCS number 12, whereby his title suit in OS number 5028 of 2013 having been tried is dismissed. First stop. Next paragraph. After service of notice, the respondent BDA has entered appearance through its senior panel counsel and opposed the appeal, broadly making submission in justification of the findings on which the impugned judgment and decree are constructed.
Next paragraph. A coordinate bench of this court, wide order dated 14/9/2023, has observed as under. Has inter-alia observed as under. ಇಷ್ಟ ಇದೆಯಲ್ಲ? ಈ affidavit ಈ ಆರ್ಡರ್ ಮುಖಾಂತರ ಹಾಕಿದ್ದ? ಈ affidavit ಹಾಕಿದ್ because of this order.
Please, madam.
Okay. In compliance with this order, ಇದೇ ಪ್ಯಾರಾದಲ್ಲೇ ಕಂಟಿನ್ಯೂ ಆಗ್ತದೆ. The Commissioner of BDA, Shri N. Jayaram, as he then was, has sworn to an affidavit dated 15 February 2024, wherein Para 7 reads as under. Next paragraph. Learned senior panel counsel appearing for the respondent BDA, having resisted the appeal, drew our attention to the stand consistently taken by his client as reflected in the extracted paragraph of the said affidavit. First, he, in all fairness, now submits that his client is ready and willing to allot to the appellant the following two sites, viz. Visera, Roman small one. Site number 909/1, comma, 7th block, Vishweshraya, Saram Vishweshraya, another, Saram Vishweshraya layout, kutukonde heli. Layout. Bangalore,
Seventh block.
Huh?
Seventh block.
7th block, comma, Vishweshraya layout, Bangalore. South End, Bangalore ಇಷ್ಟೇನಾ?
Bangalore ಅಷ್ಟೇ.
Bangalore. 2. Site number 1814, comma, Nadaprabhu Kempegowda layout.
ನಾನು ಸ್ವಲ್ಪ ಚಿಕ್ಕದು
Bangalore.
ಇಷ್ಟ ಇರೋದು.
ನೋಡಿ ಯಾರು ಮಾತಾಡ್ತಾ ಇದ್ದಾರೆ, ನಮ್ಮ ಸರ್ ಕೊಟ್ಟಿರ್ಲಿಕ್ಕಿಲ್ಲ. Bangalore. Full stop. He submits that the form, both the sites admeasure 2,325 square feet each, semicolon. The guideline value of the former is rupees 4,460 per square foot. And that of the later is rupees 3,400, 3,474 per square foot. Semicolon. Together, the arithmetical value of these sites would work out to rupees ಎಷ್ಟಾಗ್ತದೆ?
1 crore.
1 crore
84
lakh
46,000
46,550.
550.
ಅಲ್ಲಿ ವರ್ಡ್ಸ್ ಅಲ್ಲಿ ಹಾಕೊಂಡ್ಬಿಡಿ. Full stop. Further, he says that the allotment is subject to the condition that the appellant should execute and register a relinquishment deed in respect of 15
guntas of land.
guntas of subject land as is the norm, and further should pay a sum of rupees
5 lakh
48,892 and 892 towards the differential of the value. First off, he furthermore submits that these sites are free from any litigation or claim of any kind whatsoever, and that the BDA has got absolutely transferable title and possession thereto.
Declaration to that effect if he gives, my lord.
And a declaration to that effect would also is also made here. No.
It's not, he let him give it to us, my lord, at the time of giving the relinquishment.
For his this
For his
first
15 days.
delete ಮಾಡ್ಬೇಕು. A last line delete. However, he insists that the appellant being allotted the subject sites has to vouchsafe his title to the 15 gunta land subsumed in the layout in question. Other identity established ಆಗಿಲ್ಲ.
ಸರ್ವೆ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಗೊತ್ತಾಗುತ್ತೆ ಸ್ವಾಮಿ.
To this proposal, the counsel for the appellant and appellant who is personally present before the court this day are agreeable. Are you agreeable? So ಜೋರಾಗಿ ಹೇಳಿ ಇಲ್ಲಿ ರೆಕಾರ್ಡ್ ಆಗಲಿ.
Yes, we are agreeable.
They are agreeable.
Overall, we are.
All right. But confuse ಮಾಡಬೇಡಿ.
5,20,000.
We have seen. Next. Learned counsel appearing for the appellant at this stage submits that the claim of the appellant to the remainder of his land, which according to him it measures 4.5 guntas, should be kept intact for being adjudicated at the hands of appropriate court, tribunal or authority. And in that connection, all contentions be kept open. Full stop. He also states that his client would be accepting the offer made by the BDA in terms of what has been stated above, provided that in the next level of litigation, whichever be its nature, wherever be it fought, the BDA should not raise the issues of limitation, jurisdiction, ಮತ್ತೇನು? And that the impugned judgment and decree shall not rejudicate such a claim. Full stop. In our view, this is acceptable. And the learned panel council, though initially opposed the same, now on our instruction agrees with the same. Let's say, last line, sir, very heavy. This is acceptable to us, but first stop. An argument to the contrary, if countenanced, would rob away the elements of justice apparent in the case in contemplation of the appellant. Full stop. Therefore, the said issues shall not be raised, nor permitted to be raised, nor any evidence to that effect would be permitted to be allowed, adduced, you're right, adduced. Full stop. Next paragraph. In view of the above, keeping the appeal pending, we make the following order. First, one, the respondent BDA. First, the respondent BDA shall allot 2 sides as mentioned herein above, and execute and register due conveyances within a, 1 second, I know that what you want to say.
Please, madam.
Within a period of 2 weeks, subject to the condition that the appellant shall relinquish 15 guntas of subject land, prima facie vouchsafing title thereto, and making the payment of adjustment price, that is rupees 5,48,892 to the BDA. Within 2 weeks from this day. Please. Next point.
Overall, appellant has already paid court fee of rupees 5,26,935.
ಅದು ಈಗ ಲಾಸ್ಟ್ ಇದನ್ನ ಮಾಡಕ್ಕೆ ಕೊಡೋಣ ಅಂತ ನಿಮಗೆ ರಿಫಂಡ್ ಮಾಡಿ ಸೆಟಲ್ಮೆಂಟ್ ಟೈಪ್ ಮಾಡ್ದಂಗೆ ಮಾಡಿ ರಿಫಂಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿಬಿಡೋಣ. ಆಲ್ ರೈಟ್, read that what you have written now. No, first. Conveyances in favor of the appellant or his nominee within a period of 2 weeks from this day. So within 2 weeks, you will do. From there, 2 weeks, that will be reckoned. Vouchsafing title, executing relinquishment deed, payment of this amount. All right, next paragraph.
ಅದು ಆದ್ಮೇಲೆ ಸೇಲ್ ಲೀಡ್ ಮಾಡ್ತೀವಿ. ಅದಾದ್ಮೇಲೆ ಸೇಲ್ ಲೀಡ್.
ಹೌದು.
ಪ್ಲೀಸ್.
Relinquishment is a precondition.
ಪ್ಲೀಸ್. ಫಸ್ಟ್ ರಿಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಆಮೇಲೆ ಸೇಲ್ ಲೀಡ್ ಮಾಡ್ತೀವಿ.
ಆಮೇಲೆ ಸೇಲ್ ಡೀಡ್, ದುಡ್ಡು ಕೊಡೋದು ಇನ್ನೊಂದು.
ಹೌದು ಸರ್.
ಅದು ಎರಡು ಆದ್ಮೇಲೆ ಮುಂದೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿ.
ಪ್ಲೀಸ್.
ಇದನ್ನೆರಡೂ ಮಾಡ್ತಾರೆ, ನೀವು ಸೇಲ್ ಡೀಡ್ ಮಾಡಿ ಕೊಡಲ್ಲಪ್ಪ, ವ್ಯವಹಾರ ನಡೆಸ್ತೀರಿ, ಮುಂದೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅವ್ರು? Because we have very bad experience with the
I understand, my lord.
BDA, KIDB, BBMP.
My lord, this
They're all, we don't have good opinion about. There are judgments, not just ಹಂಗೆ ಇದು ಅಲ್ಲ, ಇದು ex cathedra ಅಲ್ಲ. The statement is reproduction of what is recorded in half a dozen judgments.
I understand. This, my lord, this order passed by your lordships is pursuant to the affidavit filed by the commissioner, my lords.
Correct.
So there is no question of us going back on this
We
order.
do-
Anyway,
no,
we
it's
will not
not
do
that
it, my
way.
lords.
You are not commissioner there. We have believed your words.
Allah.
You are their
Correct.
counsel
Correct,
and
my
very
lord.
efficient counsel.
Thanks, my lord. My lord, it's the same commissioner who's still there now.
Is there.
It's still there. He's the same commissioner. So since the time limit has been set, my lords, we will meet with the timelines and
Next paragraph. On the appellant complying with the conditions subject to which the BDA has to do its part, comma, should it fail to do, comma, the jurisdictional officer of the BDA shall be liable to pay a sum of rupees 1 lakh for each day's delay. Not attributable to the appellant. All right. Suppose if he does delay, you are right.
And may I request, my lord, 3 weeks, my lord. Just in-
Malin 3 weeks ಮಾಡಿ ಅಂದ್ರೆ BDA shall execute the sale deed 3 weeks.
Date may kindly be fixed by my lords so that
ಇಲ್ಲ 3 weeks ಕೊಡ್ತೇವೆ, ನೀವೇ ಇಂಟ್ರಾಕ್ಟ್ ಮಾಡ್ಕೋಬೇಕು.
3 weeks ಮಾಡಿ
ಹಾ.
ತಾವು ನೆಕ್ಸ್ಟ್ 3 weeks ಆಮೇಲೆ ಒಂದು ಡೇಟ್ ತಾವು ಅಸೈನ್ ಮಾಡಿದ್ರೆ ಸ್ವಾಮಿ on that day we will report. So
ಈಗ 2 weeks ನಲ್ಲಿ ಅವ್ರ ಎಕ್ಸಿಕ್ಯೂಷನ್ ನಿಮ್ಗೆ ಇದನ್ನ ಮಾಡಿಕೊಡ್ತಾರೆ ಈಗ.
ಮಾಡ್ಕೊಡ್ಲಿ.
ಕರೆಕ್ಟಾ?
2 weeks ನಲ್ಲಿ ಮಾಡ್ಕೊಡ್ಬೇಕು. 5,48,892 ಪೇಮೆಂಟ್ ಮಾಡ್ಬೇಕು.
ಪೇಮೆಂಟ್ ಮಾಡಬೇಕು.
Then next 3 weeks ನಲ್ಲಿ they will execute the sale deeds in respect of these 2 sites.
ಅಲ್ಲ ಅಲಾಟ್ಮೆಂಟ್ ಆರ್ಡರ್
Allotment order ಮತ್ತು
ಅಲ್ಲೇ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಕೆಳಗಡೆ ಬರ್ಕೋ. It hardly needs to be stated that the allotment order shall precede execution and registration of the sale deed.
ಆಗತ್ತೆ.
Sale deed. Full stop. ಅದಕ್ಕೆ ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಎಲ್ಲ ಯಾರು ಪೇ ಮಾಡ್ಬೇಕು? ಇವರೇ ಪೇ ಮಾಡೋದು.
ಅವರೇ ಪೇ ಮಾಡೋದು.
ಎಕ್ಸಂಪ್ಷನ್ ಇಲ್ಲ.
ಎಕ್ಸಂಪ್ಷನ್ ಇಲ್ಲ.
ನಿಮ್ ರೂಲ್ಸ್ ಅಲ್ಲೇ ಪೇ ಮಾಡಿ. ಸಾಮಾನ್ಯವಾಗಿ ನೀವೇ ಮಾಡ್ಬೇಕು.
ಕರ್ನಾಟಕ ಸ್ಟಾಂಪ್ ಆಕ್ಟ್ ಪ್ರಕಾರ.
Yes. The stamp duty and the registration fees payable for the conveyances shall be borne by the appellant. ಒಂದ್ ಕಡೆ ಮೇಲ್ಗಡೆ ಎಲ್ಲ ಒಂದ್ ಕಡೆ ಮೇಲ್ಗಡೆ ಹಾಕಿ.
Please, please.
ಈ ರೀತಿ broadly our order will come this way.
Please, madam.
All right.
Please.
ಸ್ವಲ್ಪ linguistic variation ಎಲ್ಲ ಇದು. Paraphrasing it may undergo some change.
Please, madam. May I request my lords to kindly dismiss the application for disobedience, my lord, that's been filed against me.
We will keep it in abeyance now.
Then may I
Because
kindly.
we will use that also against.
Yes, my lord, no. I understand, my lords.
ಹಾ.
Then may I request this indulgence, my lord, may I request this indulgence.
ಸೆನ್ಸಿಬಲ್ ಆಫೀಸರ್ಸ್ ಇಲ್ಲ ಈಗ ಅವ್ರು ಅಂದ್ರೆ ಸೆನ್ಸಿಬಲ್ ಇರಕ್ ಬಿಡಲ್ಲ, ಸಿಸ್ಟಮ್ ಹಂಗಾಗಿದೆ. ಎನಿವೆ ಬರ್ಕಡೆ the application seeking contempt action against the
BDA, Commissioner of the BDA.
Commissioner of BDA is kept under suspended animation in abeyance till next date of hearing, and non-compliance of this order shall add merits to the subject application in favor of the appellant.
Please, madam. May I then
And
kind-
contra contention, if any, of the respondent shall not be entertainable.
Please. May I kindly request your lordships to treat this matter as part heard, my lords?
ಮಾತಾಡಲ್ಲ ಇದು ಫುಲ್ಲಿ ಹರ್ಡ್ ಇದೆ ಆಲ್ಮೋಸ್ಟ್.
So that
ಮುಂದಿಗೆ ಏನು ರಿಟರ್ನ್ ಆಫ್ ರಿಫಂಡ್ ಆಫ್ ಕೋರ್ಟ್ ಫೀ ಪ್ರಶ್ನೆ ಬರ್ತದೆ. ಆಮೇಲೆ ಮ್ಯಾಲಿನ ಇದ್ರ ಪ್ರಕಾರ ನಾವು ಮುಂದೆ ಜಜ್ಮೆಂಟ್ ಡಿಗ್ರಿ ಮಾಡಿ.
ರೋಸ್ಟ್ ಪಾರ್ಟ್ ಹೆಡ್ ಅಂತ ತಾವು ಪಾರ್ಟ್ ಹೆಡ್ ಅಂತ ಮಾಡಿದ್ರೆ
ಪೋಸ್ಟ್ ದಿಸ್ ಕೇಸ್ 2 ವಾರ ಯಾವಾಗ ಮುಗೀತದೆ? 28 ಅಲ್ಲ ಇವ್ರದ್ದು 2 ವಾರ 12th of December. ಅಷ್ಟರಲ್ಲಿ ನೀವು ಮಾಡ್ತೀರಿ ಅದನ್ನ. ಮುಂದಿನ 3 ವಾರ ಯಾವಾಗ ಮುಗೀತದೆ? 19 December. ಅದಕ್ಕಿಂತ ಮೊದಲೇ ಮಾಡಿಕೊಟ್ರೆ 19ಗಿಂತ ಮೊದಲೇ ಬಂದ್ಬಿಡ್ತದೆ.
ಹೌದು.
ಇದು ಔಟರ್ ಲಿಮಿಟ್ ನಾವು ಇಟ್ಕೊಂಡಿದ್ದು.
ಹೌದು.
ಸೊ ವಿಲ್ ಹ್ಯಾವ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 20th. ಯಾವ ಡೇಟ್ ಆಗ್ತದೆ? ಫ್ರೈಡೆ 20th.
19th ಕೊಡಿ ಸರ್.
19th ಇಟ್ಕೊಂಬ ಅಲ್ವಾ?
ಹಾ.
ಅಲ್ಲೇ 10 days ಮಾಡ್ಬೋದು. 2 weeks ಬದಲಿ ನೀವು ಮಾಡ್ಲಿಕ್ಕೆ ಮಾಡ್ಬೋದಾ? 2 weeks ಇತ್ತಲ್ಲ ಇವ್ರಿಗೆ 10 days ಮಾಡಮ್ಮ. 10 days ಅವಾಗ ಯಾವ ಡೇಟಿಗೆ ಬರುತ್ತೆ? ಇದೆ ಅವರಿಗೆ. ಐ ನೋ ಹೌ ಟು ಹ್ಯಾಂಡಲ್ ದೆಮ್. ಬಿಡಿ ಐ ಆಮ್ ಎಕ್ಸ್ಪರ್ಟ್ ಇನ್ ಹ್ಯಾಂಡ್ಲಿಂಗ್ ದೆಮ್. 8 December 8, 18, 19 ಹಾಕೋಬೋದಾ? Call for further hearing and for reporting compliance. I'll call for reporting compliance and further hearing on 19/12/2024. Full stop. A carbon copy of this order shall be shared with the panel counsel appearing for with the counsel appearing for the parties immediately. ಇಷ್ಟು ಮಾಡಿ ಇಷ್ಟ ಏನಾದ್ರು ಆಡ್ ಮಾಡ್ಲಿಕ್ಕಿದೆಯಾ? ಅಲ್ಲಿ ಇನ್ನೊಂದ್ಸರಿ ನೆಕ್ಸ್ಟ್ ಬರ. If any difficulty arises in giving effect to the intent and content of this order, it is open to concerned parties to move the court by a memo. ಮತ್ತೆ ಅಪ್ಲಿಕೇಶನ್ ಇವೆಲ್ಲ ಬೇಡ, ಮೆಮೊ ಹಾಕಿ ಮತ್ತೆ ಅಲ್ಲೇ ಮಾಡಿಕೊಟ್ಬೋದು.
Posted for further hearing. My lords, it's posted for further hearing, my lords.
Further hearing.
Greatly obliged, my lords.
All.
Thankful, my lords.
That's good.
The extra amount payable by the applicant.
ಮೆನ್ಷನ್ ಮಾಡೇವಲ್ಲ 5 ಲಕ್ಷ. ಅದನ್ನ ಸೆಕೆಂಡ್ ಸೈಟಲ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಇಟ್ಟಾರೆ. ಆಕ್ಚುಲಿ ಫಸ್ಟ್ ಕೊಟ್ಟಿದ್ದು ಅರ್ಧ ಇಡ್ಲಿಕ್ಕೆ ಬರ್ತಿತ್ತು. ಎನಿವೇ ದೇ ಹ್ಯಾವ್ ಸೇಡ್ ಇನ್ ಅಫಿಡವಿಟ್ ಅಂಡ್ ದೇರ್ಫೋರ್ ಇಟ್ ವಿಲ್ ಹ್ಯಾಪನ್.
ವೇವ್ ಮಾಡಿದ್ರೆ ಚೆನ್ನಾಗಿ. ವೇವ್ ಮಾಡಿದ್ರೆ
ನಾವು ನಮ್ಗೆ ಆ ಪವರ್ ಕೊಡಿ. ಇವತ್ತ ಮಾಡ್ತೇವೆ ಎಲ್ಲರಿಗೂ ವೇವರ್. ನಮ್ದು ವೇವರ್ ಮಾಡಿ ಮ್ಯಾಲ ಇರೋದು ಸ್ವಲ್ಪ ಅಮೌಂಟ್ ಕೊಡ್ತೇವೆ. ಎಲ್ಲಿದೆ? ನೀವು ನಮ್ಮನ್ನ ಜಡ್ಜ್ ಮಾಡುವಾಗ ಎಷ್ಟೊಂದು ಲಿಮಿಟೇಷನ್ ಇಟ್ ಮಾಡಿರಿ. ಜಸ್ಟಿಸ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಲಾ ಅಂತ ಹೇಳಿ ಓದ್ ಕೊಡಿಸಿರಿ ನಮ್ಮ ಕೈಯಿಂದ. ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ? ಎಸ್.
You will get the refund later.
Publish.
ಕೋರ್ಟ್ ಫೀ ರಿಫಂಡ್ ಆಗೋದು ಅಷ್ಟಾಗತ್ತೆ. ಇದನ್ನ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಟ್ರೀಟ್ ಮಾಡ್ಬೇಕು. ಅಲ್ಲಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಬರೀಮ್ಮ. Whether this arrangement should be treated as the settlement at the stage of pre-hearing and therefore entire court fee needs to be refunded will be considered on the next date of hearing. So at least on foundation ಹಾಕಿಟ್ಟು. Otherwise you will not get that also.
I understand.
ಆ ಜಡ್ಜ್ಮೆಂಟ್ ತೊಂಬರ್ಬೇಕು. ಮಂಜುನಾಥ್ ಸಾಹೇಬ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ತರಬೇಕು. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು. ಕೊಡಿ.
Lord, one submission, Lord, after your lordship said, even I was curious to know why since 20 years or 25 years, she's been in Bangalore. Then it appears that there are 3 cadres, Lord, DCs, CTOs and ACs, Assistant Commissioners of Commercial Tax. It appears in these 3 cadres, that is
Only in Bangalore?
No, what has happened is, it is an unwritten policy of the department, unwritten, but very strictly adhered to. Ladies are accommodated in the same place from past 20, 30 years. It so happened that once I'll be able to point out not. I said, if this is the situation, show me from the existing transfer order. Once it appears somewhere when Mr. Sudhir or Suresh, one of the commissioners was there, he said, I want to change this policy about 10 years ago. When he changed this policy and shifted them to other places, everyone went to the CM, the ladies, because these are 200 ACs, CTOs and DCs. Then immediately they restored back that policy. It's an unwritten policy. It's not that anybody has had an influence to have them here. For that, my lord, kindly see this present transfer order for a moment.
ಅಲ್ಲೇ ಮೈಕ್ ಆನ್ ಮಾಡಿಕೊಳ್ಳಿ.
Yes. ಈ present transfer order ನಲ್ಲಿ page number 25. We have cross-checked with all the ladies officers in this present transfer order. Kindly see, my lord, page 25.
ಎಲ್ಲರೂ ಬೆಂಗಳೂರ?
ಎಲ್ಲ ಬೆಂಗಳೂರು, ಕಾರವಾರ, ಈ ತರ.
ಎಲ್ಲೆಲ್ಲಿದ್ದಾರೆ ಅಲ್ಲೆಲ್ಲಿ?
ಅಲ್ಲಲ್ಲೇ kindly see 6 my lord. ಒಂದು ತೋರಿಸ್ಬಿಡ್ತೀನಿ ನಿಮ್ಗೆ to convince your lordships ಅಂದ್ರೆ. 25 ನಲ್ಲಿ serial number 6, page 25 ನಲ್ಲಿ ಸ್ಮಿತಾ ಪಾಟೀಲ್, ಬೆಂಗಳೂರು. 12 next. Only the ladies.
ಯಾರಿಗೂ ಶ್ರೀಮತಿ ಶ್ರೀ ಹಾಕುವಂತ ಒಂದು ಸೌಜನ್ಯ ಇಲ್ಲೇನು ಗೌರ್ಮೆಂಟ್?
ಕರೆಕ್ಟ್.
ಅಲ್ಲಿ ಮೇಲೆ ಹೋದ ಕಡೆ ಹಾಕೊಂಡ್ರು. ಪ್ರತಿಯೊಂದು ಹೆಸರಿನಿಂದ ನಮ್ ಕಲ್ಚರ್ ಏನು?
DCs and
ಒಂದು ಶ್ರೀಮತಿ, ಕುಮಾರಿ, ಶ್ರೀ, ಮತ್ತೆ ಒಟ್ಲ ಏಕವಚನದಿಂದ ಕರೆಯೋದು ಎಲ್ಲಾರನು ಇಲ್ಲಿ.
ಆಮೇಲೆ 26 ನಲ್ಲಿ seal number 12. 6 ಬೆಂಗಳೂರು. 12 ಬೆಂಗಳೂರು ಆಶಾ MN, ಬೆಂಗಳೂರು. 15 ಬೆಂಗಳೂರು. 17 ಬೆಂಗಳೂರು. Then Lord, kindly see 22 next page.
22 is a good name. Yes.
ಬೆಂಗಳೂರು.
24
ಬೆಂಗಳೂರು. 26 ಬೆಂಗಳೂರು. And then 34 ಬೆಂಗಳೂರು. And then 31 ಕಾರವಾರ. 41 sorry.
41
Dalini Gaonkar, Karvara. If they are in that city only. Then 47 PS Pushpakumari, Bengaluru. And then 53 sorry.
53
Bengaluru. For 30 years she's been here. 33 senior officer. 64 Kavya, Bengaluru. 66 Bengaluru. And then 67 also Bengaluru. Sridevi Shrimantateli. And then 93 Tumkuru.
76 also.
Yes, 76 also. Nipani Belgaum, same district. Yes. And then Asha Kumari, Tumkuru.
93
Tumkuru.
ಅವ್ರು ಹೇಳ್ದಂಗ
This pattern.
Thing also, my lord, kindly permit me to read the memo which I just furnished.
And Lord, Itara.
It appears that way.
Yes.
I just point out only two other things. 1999, she was appointed as a commercial tax inspector, Bangalore. This would continue till 2023, which is the last which my lord could see. ಇದರ ಮಧ್ಯದಲ್ಲಿ ಎರಡು serial number 10 and 12 minutes, she had availed study loan, study leave. So only on those two occasions, there seems to be a break. What I would only point out is the very next page which I produced there. It is not that
This is 3 copies.
she
3 copies.
she would get a minute from the Honorable Chief Minister to say that ನನಗೆ ಇಲ್ಲೇ ಇಟ್ಕೊಳ್ಳಿ ಅಂತ. The next page. What you indicated by page number 2, ಪರಸ್ಪರ ವರ್ಗಾವಣೆ ಪ್ರಸ್ತಾವನೆ ಕುರಿತು ಪರಿಶೀಲನೆ ಅಂತ. Minutes is there. And the very next thing, again she would say that ಕೌಟುಂಬಿಕ ತೊಂದರೆಗಳಿರುವ ಕಾರಣ ಹಾಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುವ ಸ್ಥಳದಲ್ಲೇ ಮುಂದುವರಿಸುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. With that, whatever limited time I had, I could get only these two, but my instructions are there are several other, maybe some minutes where she had requested for her to be kept in Bangalore itself.
But you agreed with that?
Yes, Manoj, we have agreed, Manoj.
Now, what is her fault?
No,
How we will ask for moon? Why you give that?
Manoj,
ಇಲ್ಲಪ್ಪ ಕೊಡಕ್ ಬರಲ್ಲ, ಎಲ್ಲರಿಗೂ ಇರೋದೇ ಒಂದದು.
Right
ಹಂಗ್
now
ಮಾಡಕ್-
also, my lords, I would only want to bring it to my lord's notice to say, ಇವತ್ತಿಗೂ ಬೆಂಗಳೂರಿಂದ ಬೆಂಗಳೂರಿಗೆ ಹಾಕಿರೋದು. It is not that she has been displaced from Bangalore to
Anyway,
somewhere. Please,
anyway, she is before this court
Please.
ventilating her grievance.
please.
She has not come here to get larger injury at our end.
Of course, my lords,
She cannot be worse off.
please.
Now he has shown how things have happened. Alva. So we cannot hold that she is clinging on to Bangalore city.
Yes.
It's you all know that the honorable chief ministers in succession have made those orders.
Yes.
Maybe she may be a good officer also. We don't know. Because
she's
it's a
even
question of
availed
raising of revenue.
study leave ತಕೊಂಡು ಹೋಗಿದ್ದಾರೆ. Maybe some higher studies she has
Higher
kind of
studies.
completed.
Maybe that maybe we can't
school.
say.
Please, my lords. My only-
ಮಧ್ಯಸ್ಥರಿಗೆ ನಾವು knee jerk reaction ಮಾಡ್ಕೊಂಡು ನಾವು
ಇಲ್ಲ, my only submission to my lords was to say, ಬ್ಯಾಂಗ್ಳೂರಲ್ಲೇ ಆಗಿದೆ, and this officer who is in Bellary for.
But ಅದೇನಾಗಿದೆ, in Bangalore, yes, I agree. But out of 128 officers who are being transferred, ನಾನು ಒಬ್ಬನೇ ಪ್ರಿಮೇಚರ್. ಆಯ್ತು, ಆಗ್ಲಿ. Suppose,
ಪಾಲಿಸಿ
suppose ನೆಕ್ಸ್ಟ್ ರೆಗ್ಯುಲರ್ ಟ್ರಾನ್ಸ್ಫರ್ ನಲ್ಲಿ ನನ್ನ
ಸಿಎಂಸ್ ಅಪ್ರೂವಲ್ ಎಲ್ಲ ತಗೊಂಡಾಗಿದೆ ಏನು?
Please, my lords, produce that.
ಆಗಿತ್ತಾ?
lords. Yes, my lords.
ಏನ್
no
reason
reasons.
ಏನ್ ರೀಸನ್ ಕೊಟ್ಟಾರೆ?
The reasons, my lords,
Administrative reason, general reason will be there. No specific reason for picking me from the
What is
120.
the reason? ಅಲ್ಲ, injustice ಆಗಿಲ್ಲ. You are only one in the list is true.
Yes.
ಅದು ಒಂದೇ ಕಾರಣಕ್ಕೆ injustice ಆಗಿದೆ ಅಂತ ಹೇಳಕ್ ಬರಲ್ಲ.
ಅಂದ್ರೆ ಏನಾಗಿದೆ, there may be some reason why only I am picked.
ಏನಾಗಿದೆ? ಏನ್ ರೀಸನ್?
That reason, Lord, there is some thing, difference of between the higher officer and me. That is the issue.
ಏನ್ ಮಾಡಿ?
ಅದೇ ಆ ಒಂದೇ ರೀಸನ್ ಇಂದ they have, but otherwise, Lord, the the fact of picking me, and suppose they had 6 or 7 officers who have been transferred premature, it's okay.
ನಂಗೆ
ಈಗ
ನಾಲ್ಕೈದು
Moral of the employee.
ಏನು ಅಂದ್ರೆ,
ಹಾ.
ಇನ್ನು 4-5 ಜನರಿಗೆ ನೀವು ಗಾಯ ಮಾಡಿದ್ರೆ ನಾನು ಒಪ್ಕೋತಿದ್ದೆ.
ಹಾ.
ನಾನು ಒಬ್ಬಳಿಗೆ ಗಾಯ ಮಾಡಿದ್ದೆ.
ಅಂದ್ರೆ ಏನಂದ್ರೆ ಮೊರಾಲ್ ಆಫ್ ದ ಎಂಪ್ಲಾಯೀಸ್ ಏನಾಗುತ್ತೆ ಇಂಥ ಸಮಯದಲ್ಲಿ ಎಲ್ರು
ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಆಗಿದೆ ಇವ್ರದ್ದು?
she's aged 50, my lord, she has another 10 years of service is my.
ಆಸ್ ಅನ್ AC 2020 ಇಂದ
ಫ್ರಮ್ ದ ಬಿಗಿನಿಂಗ್
99 she joined, sir.
23 years, my lord.
23
years.
ಏನಾದ್ರು ಡಿಸಿಪ್ಲಿನರಿ ಎನ್ಕ್ವೈರಿ ಏನಾರ ಇತ್ತು?
ಒಂದು, we have issued a show cause notice indicating that she had shown dereliction of duty. The election time nalli some materials were being supplied, and on instructions to go and intercept also she would not do it.
ಆಮೇಲೆ ಏನಾಯ್ತು? ನೋಟಿಸ್
She
ಕೊಟ್ಟರೆ
has issued reply to that, my lords. I think it is at that
And not
stage.
only me, my lord, me, DC and another officer, CTO. 3 officers.
not connection in connection with
No.
Of course, not connected.
duties.
No,
as
no.
23 years she has done.
She has done 23 years. From
Blemishless.
1st of September 99 till 6th of September 23.
Ask her if there is-
Yeah, how many
Sir,
promotions
blemish.
she has earned?
2 promotions.
2 promotions.
Commercial tax inspector in the commercial tax officer, and then assistant commissioner of commercial taxes.
But ನಾವ್ ಅಂದ್ಕೊಂಡ್ ಇಂಪ್ರೆಷನ್ ಡೈಲ್ಯೂಟ್ ಆಗ್ತದೆ ಈಗ ಅವರ ಕಂಟೆನ್ಷನ್
Please,
ಇಂದ,
Manoj.
because he says this is your unwritten policy. It appears to be that way.
True, my lords.
Prima facie.
True, my lords.
ಆಮೇಲೆ CM award ಗೆ my name is recommended in 2022. It is recommended by the department only. No
Is it true?
intercede
If
from.
he is of such distinguished service, may I just permitted me to say this. Her requirement in another district could also be looked into by my lords to say that a person of such distinguished, if at all, if it is made to say so, that she could work in other districts also. But here, now Bengaluru ಕೊಟ್ಟಿದ್ದೀವಿ. ನಾನು enforcement ನಲ್ಲಿ ಇದ್ದೀನಿ, enforcement ಇಂದ ತೆಗೆದು we have transferred elsewhere. I would want to be retained in enforcement. It seems to be our contention to say that.
Premature ಯಾಕೆ ಅಂತ? Premature.
ಏನ್ ರೀಸನ್ ಕೊಟ್ಟಾರೆ ನಿಮ್ಗೆ?
ಇಲ್ಲ, reason ಏನಿಲ್ಲ. I would only submit, can pass it across, my lords. This was part of the records before the honorable tribunal, my lords. ಅಷ್ಟೇ, administrative reasons is what? ಮೇಲ್ಗಡೆ ಸಾಲಿನಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಅನುಮೋದನೆಗೆ
The new transfer guidelines prescribe that reasons must be given as to why they did it. And particularly when they pick, there's so much of arbitrariness. Anna Sahib judgment also prescribes that reasons have to be given specifically.
Justice H. Ramesh's judgment.
Yes, yes. That's the only, that's the severe hurt. Lord. that only there are 128 officers who are being taken after the period, 2 years period is over.
Anyway, the highest functioning executive has looked into the file and he has said, just transfer
Andre,
it.
blood,
There should be some,
ಅಲ್ಲ, ಏನಾಗಿದೆ?
we can't expect that the reasons should be given even by the Chief
ಅಲ್ಲ,
Justice
ಅಲ್ಲ,
of India,
even if
Chief Minister of the state.
ನಾನು ಒಂದು,
We have to confide in them because we have elected them.
Yes, now on that I am not finding fault. Suppose the whole transfer order goes, he may not be aware that this one is one out of the 128. He would have signed it. The chief minister, not the highest executive, we can't impute any motivations to the highest executive.
We cannot.
He would have signed it as part of the entire.
And
128.
government has been kind to you all through.
Yes.
You have given so many requests and government has acceded to your
ಅಲ್ಲ,
requests.
ಏನಾಗಿದೆ, this out of this 128, the chief minister general ಆಗಿ 128 ಹೋಗಿರುತ್ತೆ. He would have acceded to it.
We assume Chief Minister has looked into the,
Yes,
see,
yes,
the,
yes.
in Shankara Narayanan versus Bangarappa,
Yes.
the apex court said,
Yes.
when Chief Minister says and writes something,
Yes.
it has got presumptive value. We
Yes.
can't say.
The highest constitutional
Ah.
authorities ಅನ್ನೋದು ಇದೆ. ಅಲ್ಲ, but when a bulk of 128 go through, ಇದರಲ್ಲಿ what the division bench says, Honorable Chief Justice's order in the last paragraph, I just take your lordships to that. What it is more, this totally relates to such a situation. Chief Justice.
Hello, what is
Division.
that apart? What is the prejudice caused to you?
Not
Except that and we will be going in the car, government car only.
ಅಲ್ಲ,
Whether
prejudice-
this office or
ಇಲ್ಲ,
that
ಅದೇನಿಲ್ಲ.
office.
Unfair treatment to me,
Yeah.
where arbitrariness is there.
Hang arbitraries. Chief
I am-
Minister has looked into the file and said, all through we have been treated very, very with soft
No,
gloves.
the new transfer guidelines say, even if the CM passes the order, it has to be a speaking order. Kindly see,
Any other-
ಇದೊಂದು ತೋರಿಸ್ಬಿಡ್ತೀನಿ.
That's.
Para 35 of the division bench order.
There are 35 of.
Of Honorable Chief Justice order.
Petition number.
Writ appeal number 1146. The
Page
one
number?
which the Supreme Court,
Page.
page 32, not page 21. Not petition, the judgment which I supplied, the division bench judgment.
32.
Because my lord, ultimately, my lord, the law that has been developed.
Employees ಸ್ವಲ್ಪ ಏನೋ consider ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದಾ?
ಪಕ್ಕದ ಜಿಲ್ಲೆ on request ಆಗಿದೆ.
ಮೈಸೂರು.
ಅದೊಂದೇ. ಅದು ನಿಪ್ಪಾಣಿ is within the district, lord. Within. No, lord, what happens is, within the district only they regulate it for women. For women.
Law will pass judgment, we know how to write judgment is one thing. ಈಗ for last 23 years she has worked. And except that notice which also withers away because you accepted her explanation, no action is taken.
Yes.
Is it not? Appears to be good officer. Now she is saying somewhat she is hurt. Okay, call her to, the government should call her and ask her, why are you hurt?
Yes.
Speak to her that you are a good officer. We want you to work in this office. Please work. Next time we will consider your request. Can't you do that? Bari ist madire saku or efficiency level just ಆಗ್ತದೆ. Now employees ಅಂದಾಕ್ಷಣ not at the beck and call of the
Yes,
government. We are
please.
very often we say we are not East India Company.
I will request the commissioner to have a word with her.
Have a word. Ask her, call to the chamber, offer a cup of tea and tell that you are a good officer. She is. That is that is the reason you have favored her request to retain her. Otherwise, without productivity, who will retain the
Yes.
employees?
Absolutely.
Next date, no, Monday ಹೇಳ್ಬೇಕು. ನಾವು ಹಂಗ sometimes we also feel ಏನಪ್ಪ ಇಷ್ಟು ವರ್ಷಗಟ್ಟಲೆ ಬೆಂಗಳೂರಲ್ಲಿ ಒಬ್ಬರೇ ಇರೋದು.
Even I thought,
ಅನ್ಸುತ್ತೆ ನಮ್ಗೆ.
even I thought, because I was defenseless on
Now
that
he has
point.
given a plausible explanation with which broadly you are in agreement. That's because facts are like that. That's all.
Intra.
That's right. Now ask your commissioner to
call her to chamber and ask as to what is her difficulty. Sometimes, ಹೇಳ್ಲಿಕ್ಕೆ ಆಗದಂತ ಡಿಫಿಕಲ್ಟಿ ಇರ್ತದೆ. ಎಲ್ಲ ಈ ಸರ್ವಿಸ್ ಇದರಲ್ಲಿ ಇದೆಲ್ಲ ಆಗ್ತಿರ್ತದೆ. ಅಂಡ್ ಲೇಡಿ ಒಂದ್ಸರಿ ಕೇಳ್ಕೊಳ್ಳಿ.
Yes.
ಏನಾರ ಡಿಫಿಕಲ್ಟಿ
accommodation.
ಸ್ವಲ್ಪ ಏನೋ ಸ್ಮಾಲ್ ಅಕಾಮಿಡೇಷನ್ ಮಾಡಿದ್ರೆ ಹಾರ್ಟ್ ಬರ್ನ್ ಹೋಗ್ತದೆ ಮತ್ತು ಗೌರ್ಮೆಂಟ್ ಬಗ್ಗೆ ರೆಸ್ಪೆಕ್ಟ್ ಜಾಸ್ತಿ ಆಗ್ತದೆ.
Yes.
ಅವರ್ ಎಂಪ್ಲಾಯರ್ ಈಸ್ ಟ್ರೀಟಿಂಗ್ ಅಸ್ ವಿತ್ ಆಲ್ ಡ್ಯೂ ರೆಸ್ಪೆಕ್ಟ್. ವಿ ಹ್ಯಾವ್ ಟು ಬಿ ಮೋರ್ ಪ್ರೊಡಕ್ಟಿವ್ ಇನ್ ಅವರ್.
ಹೋಗಿ ಅಲ್ಲಿ ಮತ್ತೆ
ಹಾ
ಇಲ್ಲ.
ಇಲ್ಲ
We are not of such a nature. ಇಲ್ಲ. ಈಗ more than previously, now I am totally under their heels. I will have to.
ನೋಡ್ಕೊಂಡು ಮಾಡ್ಕೊಂಡು ಈಗ ನಾವು ಏನೋ ಒಂದು ಡಿಸ್ಕಷನ್ ದಲ್ಲಿ ಆ ಕಡೆ ಈ ಕಡೆ ಎರಡು ಕಡೆ ಮಾತಾಡ್ತೀವಿ. ಅದ್ರದ್ದು ಆರ್ಡರ್ ನಾವು ಬರೀಬೇಕಾದ್ರೆ ಏನ್ ಆರ್ಡರ್ ಬರಿತೀವಿ ಅವಾಗೇ ಗೊತ್ತದು. ಡಿಕ್ಟೇಷನ್ ಕೂತ್ಕೊಂಡಾಗನೆ ಹಂಗ್ ಮಾಡೋ ಬದ್ಲಿ
In the meantime, can there be status quo? ಅಷ್ಟು ಬಿಟ್ರೆ ಏನು?
ಅಲ್ಲ, I have the document.
You are a very efficient lawyer. Somehow you have dislodged our opinion. We thought that our opinion would have become more stronger
Yes.
after eating lunch. But it did not happen. You dislodged that. We acknowledge your standing at the bar.
Yes,
but
please.
not a case for stay.
Please. Aye, Monday morning.
Call on Monday. Matadri, age.
I'll today.
Something could be worked out. That's
We do not know. We have said.
yes.
How do we difficulty anything?
I'll request him today itself.
Anyway, please.
Obliged.
But don't be under impression that we have said any wrong thing
Illa.
against your client.
Illa.
Our observation was a general
So
observation.
when I went out, there was tears in her eyes and she said, this is the pattern.
We agree with that. Because
said,
even age is standing
Objectively,
very tall
court
and
will
very fair.
consider it. Court will consider it objectively.
Yeah,
And
objectively.
initially, we were also defenseless for the question.
Because we did not know.
We
We
don't.
gathered that impression after seeing appointment, a number of placement in
Yes.
Bangalore, these things. But there is a plausible explanation.
Yes.
Anyway,
Please, obliged.
she appears to be good officer.
Yes.
Also. It appears that way.
Yes.
Okay.
Obliged.
ಮತ್ತೆ ಇದು ಹಿಂಗೆ ಹೇಳಿವಿ ಅನ್ಕೊಂಡು ಆ ನೋಟಿಸ್ ಇತ್ತಲ್ಲ ಅದನ್ನ ಪ್ರೊಸೆಸ್ ಮಾಡಿ ಮತ್ತೊಂದು ಗಾಯ ಮಾಡ
Will not.
ಅದನ್ನೆಲ್ಲ ಮಾಡ್ಬಾರ್ದು. ಓಕೆ
Great.
Application for early hearing has been filed.
early hearing.
Because the respondents are
Ready na?
Date may be fixed.
All right, in the third week of January, IA allowed and disposed of.
Any interim order is there?
Entry more to continue. Next. Kashinath, ಏನಿದೆ?
This is, my lord, in respect of departmental inquiry, my lord, initiated against the petitioner. My lord, in respect of the allegation, my lord, her husband, my lord, has secured certificate, caste and income certificate.
Husband executed,
Husband has applied on behalf of the minor girl.
minor girl,
Girl
girl
child,
ಅಂದ್ರೆ daughter.
daughter.
Ah.
And then, my lord, he produced it before the some institution for securing some to be benefits.
Was it argued before us at any point of time?
Yes, my
Some
lord.
vague memory about this?
Yes, my lord, I only.
You had argued this?
Yes, my lord, but they are in kind.
Entry ಮಾಡಿದೇನೋ?
ಇಲ್ಲ.
ಇಲ್ಲ? ಏನ್ ಮಾಡ್ತಾ ಇದಾರೆ ಈಗ?
Now, my lord, she is working as a police inspector and promotions are going, my lord. My only case, my lord, may be left out from the department. Here, my lord, the charges are framed by an inquiry officer.
Only remand.
Enquiry absolutely permissible. Now we have it that way.
No, my lord.
Remanded, you know.
Matter is remanded.
6 months it is remanded.
Relegation is concerned, my lord.
ಅಷ್ಟೇ ಹೇಳಿದ್ರು.
She is sub-inspector, your lordship. And her daughter's certificate, she produces a fake certificate.
Who procured that?
Husband only, but the DD is paid by the petitioner lords.
You have seen
Second.
Madhuri Patil versus Maharashtra, 1995 Supreme Court. The caste of the children shall be caste of the father. And father will be entitled to procure the social status certificate.
It's not regarding caste, your lordship.
Caste and income. Caste
and income.
Income, Muslim
Only
only.
income.
Caste and income.
Eradu
Not the
income.
caste. Caste and income.
He has shown,
One person could fall under 2B, must, my lord,
he has shown
caste
mother
and-
as a housewife. Income is shown as 17,000 rupees. To avail the benefit. And she being the police officer, lordship I kindly appreciate. She
that
being the
appears,
police officer,
pays 149 ಅವ್ರು ಹೇಳ್ತಾರೆ.
No, but you have declared your,
I am not declared. my lord.
he has declared.
He has declared.
You, in English law, do you know, Kashi,
That, my lord.
till 1891, the wife was part of the husband, Ardhangini. And if the husband were to kill her, that was considered as half suicide. But law did not provide for punishing half suicide. Therefore, in 1891, they changed law. At least we have not to that extent. You have produced the caste and income verification, though it was obtained by the husband, you produced it.
No, I am not produced.
You were you not aware of that?
I'm aware of it, my lord, only when it is produced and noticed by the department.
All right. Afterwards, what did you tell your husband?
That, my lord, I have informed.
Where is that? Where have you stated?
That is not stated.
I can't put you through the box to cross-examine. You
That-
should say from the pleadings of the parties. Otherwise, you have to enter the box and you have to cross-examine you. That will be,
They are,
cannot happen.
wife is working, my lord, in Davangere. And this husband was staying and working in Bhadravati. He
Yes,
secured
ನಿಮ್ಮ-
certificate from Bhadravati, my lords.
ಅದು
He is
ತೋಳಿಕೆ ಮಾಡಿ-
permanent resident of the Bhadravati.
You are a police inspector, not some,
Kindly word.
ಇಲ್ಲ.
ಅಲ್ಲ ಅದೇ
Fortunately,
ಅದನ್ನ I am not able to.
ಏನಿಲ್ಲ.
ಅಲ್ಲ, it is
Friend ಆಗಿ
only, my lord,
6
this.
months ಅಲ್ಲಿ disposal ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಅಷ್ಟೇ. 6 ತಿಂಗಳು ಮಾಡ್ಲಿದ್ರೆ
ಅಲ್ಲ, ಮಾಡೇ ಇಲ್ಲ ಈಗಲೂ ಇಲ್ಲಿ ತನಕ.
ಪ್ರಮೋಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
ಇಲ್ಲಿ ತನಕ ಮಾಡಿಲ್ಲ.
You agree for this proposal? That if inquiry is not completed within 6 months,
They are not even initiated, my lord.
have not completed us
Yes,
to
I'm-
complete our sentence. You are not permitted.
I'm
Suppose in the event promotion DPC meets, you have to consider her case for promotion because you have not done anything. ಎಷ್ಟಿದೆ ನಿಮ್ದು ಇದರಲ್ಲಿ ನಿಮ್ಮ ಸರ್ಕ್ಯುಲರ್ ಇದೆಯಲ್ಲ, your circular says all disciplinary proceedings should be completed within a period of 6 months. Maximum outer limit 1 year. When you served Shokas notice.
2014, my lords.
Huh?
2014. It's in
2014.
2018. Matter is remitted.
Proceedings ಆಗೇನಾಗಿ ಇದೆಲ್ಲ.
ಇಲ್ಲ. Proceedings concluded.
ಏನಾಯ್ತು ತೋರಿಸಿ.
The punishment is imposed. That is set aside on the ground of technicalities, my lord. He is, my lord.
Technicalities ಮೇಲೆ ಅದನ್ನ set aside ಆಗಿರೋದು.
Within-
Enquiry officer himself has framed the charges ಅಂತ ಹೇಳಿ.
Kindly.
That was their ground before the.
Anyway, within 6 months ಅಂತ ಆರ್ಡರ್ ಆಗಿತ್ತಾ?
ಹೌದು.
ಈಗ ಮುಗಿಸಿದಿರಾ ನೀವು?
ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, ಈಗ ಆಗಿರೋದು ಈಗ.
ಏನಾಗೋದು? November 2023. 18 November 2020. ಈಗಲ್ಲ. Not 24, it's 23.
Yes.
ಮತ್ತೆ? ಏನು ಮಾಡಿಲ್ಲ.
Not even.
ಇದು ಗೊತ್ತಿಲ್ಲ.
Then consider for the, if DPC moves, consider for case for promotion.
ಅಲ್ಲ, 3 months time ಕೊಡಿ. We will
ಯಾಕೆ 3
complete the
months?
inquiry.
6 months
ಅಲ್ಲ,
ಕೊಟ್ಟಿದ್ದು
subject
ಮುಗಿದು.
ಅಂತ ಮಾಡು.
ಆ?
3 months ಕೊಟ್ಟು subject to the DP.
ಅಲ್ಲ, ಈಗ 6 months ಹೇಳಿದ್ರು 1 ವರ್ಷ ಆಗಿದೆ, ಅದನ್ನ ಮಾಡಿಲ್ಲ. ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳಿಲ್ಲ. ಹೆಂಗ್ ಕೊಡ್ಬೇಕು? You want to just harass a litigant or employee.
ಏನಾಗಿದೆ ಗೊತ್ತಿಲ್ಲ. Proceedings ಅಲ್ಲಿ ಏನಾಗಿದೆ ಗೊತ್ತಿಲ್ಲ ಸರ್. I have to verify that.
Call this matter Monday. Monday ಹೇಳ್ಬೇಕು.
Please.
ಗೊತ್ತಾಗ್ತದೆ ಅವಾಗ. Otherwise you can't. ಒಂದಷ್ಟು ಏನೋ ಒಂದು ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ. All right. Please. Notice. Okay. ವೆನಸ್ಡೇ ಹಾಕೋಣ. ವೆಡ್ನೆಸ್ಡೇ ಕಾಶಿನಾಥ್ ವೆಡ್ನೆಸ್ಡೇ ಬರ್ತದೆ. ಓಕೆ. ಎಸ್ ಮಿಸ್ಟರ್ ಫಾರೂಕಿ.
For the petitioner.
Yes.
I'm submitting that memo of documents, including the judgment of your lordship passed on 11th of.
Blindness?
100% blindness.
Covered by the judgment?
Yes, sir.
Padi.
One copy is given. The last document.
The challenge in these two petitions is to the state
May I
administrative.
make one submission, my lord?
Yes.
The present notification which they have challenged is at page 52. What has happened in this matter, my lord? KT has dismissed their application on ground of delay.
Round of delay.
Yes, my lord. Kindly peruse in page 26, my lord.
ಎಷ್ಟು ಡಿಲೇ ಇದೆ?
Actually, there is, they had approached the Honorable High Court and that period has not been excluded. So if we exclude the time when the writ
Be within 1 year.
yes, it will. I have a calculation for that as well.
And section 19,
Yes, my lord.
21 now. Which is that section which says 1 year, ordinarily 1 year. Award ordinarily. Justice Shivshankar Bhatt's judgment is there.
The second page I have given.
Read the section of the Administrative Tribunals Act. What do you read? Completely blind, Ibru?
Yes, 100% blind ID card is.
Read 19 or 21. The limitation ಇರೋದು ಯಾವುದು? ಎಲ್ಲಿಯೋ ಪೃಥ್ವಿಯಲ್ಲಿ 21. 21. I think word ordinarily is there, na?
The tribunal shall not admit an application.
21, my lord.
21.
The tribunal shall not admit an application first in a case where the final decree order such as is mentioned in clause A of subsection 2 subsection has been made in connection with the grievance unless the application is made within 1 year from the date on which such application final order has been made.
Did you explain delay at least?
Yeah, the delay actually I have given
Not
the
arise if that period is
yes, if it is excluded in the second page, the page behind I have given the rejection order was on 5/12. The two matters are there. In 17.1, rejection order was on 5/12/2022. Challenged in the High Court by a common writ petition. That was notice was issued on 22/3/2023. The writ petition came to be dismissed on 1st September 2023. That is a period of 158 days. So from date of
relegated you to the tribunal.
yes, they had asked me to. That order is there.
Where is that?
At page number 172, Your Lordship.
ಅಲ್ಲಿಗೆ vacancies ಇದೆಯಾ?
Process is not completed. It is
Not
there.
yet complete.
Not yet complete.
Process is not yet.
Yes, my lord.
Then consider. ಅವ್ರಿಗೆ ಪಾಪ ಕೂರಿಡ್ರು ಎಲ್ಲಿ ಪಾಪ
Let it go back to KAT. my lord.
they can't read sections also. Your sections, your
Yes,
law
ma'am.
does not sing.
And moreover, my
Solicit
lord,
eyesight. Sight.
this notification which they have challenged, my lord, nothing is forthcoming regarding reservation, anything, my lord.
Alla, you can't.
It is
In
based
that
on the
decision, which is
previous
our- which is our
notification.
decision, we said the ocular disability will not exclude blinds being in the fray. That's the law declared.
Yes, my lord.
They should remain in the fray. Rest of the things, whatever happens, happens. We do not know. You also do not know, we also do not know. They will be in the fray. What we decided in that ladies matter. which is that matter-
Lata's case,
on
199.
Lata's case,
Yes,
what we said was the object of 1995 Act,
yes, my lord.
And 2000.
repealed in 2016,
16.
new Act.
Yes, my lord.
The object is to mitigate the hardship of persons suffering disability. Is it not?
Yes, my lord.
That disability level, if it is more, then they need more protection of the state. Do you have more disability? Therefore, we will not give you any facility. Runs counter to the policy content of that legislation. That's how we have structured. Maybe wording some different here.
I have produced it, Your Lordship.
You have produced that?
I have
judge?
produced
Where
it
is that? judge?
in my memo, today's memo that I filed.
Okay,
The last document at page number 88.
you are right. I come to 14. That way we have said actually. Read 3.3.
3.3
Is
and
93.
3.4. 3 points.
Before that also, there is some observation we have made.
Yes, sir.
Said John Milton was a blind man
Yes, my lord.
and Braille was Helen Keller, Shrikant Balla of CEO of Bollant Industries. Okay. And we have mentioned about Homer.
Yes.
Homer who wrote EDC, Odyssey and Iliad, the
Yes,
great epics of Greek epics. He was a blind man. Is it not?
Yes, my lord.
In fact, we did not refer to our certain Maharshis who had made written commentaries on some Upanishads.
There was one Maharshi who just pierced some needle into the eyes, saying that as long as I am having eyes, my mind will go outward. I become more extrovert. That comes in the way of my spiritual attainment. Therefore, I don't want that eyesight. There is another story
Yes, my lord.
where the Lord came and asked, I want to give that your brother some award. So what you want? He said, take out one of my eyes. And he said, God had said, whatever you will seek, I will give twice to that man. Therefore, he said, remove my one eye so that both eyes will be removed. There's such a.
There was a recent movie also, my lord,
Sanskrit literature.
is an entrepreneur.
Covered by judgments. Very good.
Here they are seeking for social studies.
Same subject.
Social studies.
Notification ಅಲ್ಲಿ music teacher.
Therefore, we asked, read that 3.6,
Yes, your lordship.
3.3.
3.2.
3.2. Read. We have answered your question.
Yes,
You have
ma'am.
said that.
The submission, may I read your lordship?
Ah,
The submission of the learned HCGP that the kind of work which a graduate primary teacher
Social
in social
studies.
studies teaching in Kannada does in ordinary course cannot be discharged by persons with absolute blindness, though their educational qualification to satisfy the rule requirement, it is bit difficult to agree with. As already mentioned above, the 2011 notification in so many words states secondary school assistant grade 2 assistant master arts and languages can be blind candidates. How blindness would come in the way of discharging duties of a teacher of the kind is difficult to appreciate. History is replete with instances of blind people who have achieved great things in life. Homer, 900 BC, of great epics, Iliad and Odyssey, John Milton, 1608 to 1674, in bracket Paradise Lost, Louis Braille, 1809 to 1852, Braille script, etc.
Next. Apex Court held.
Apex Court has held that even a nearly
Blind person
50% visually impaired can be appointed as a judge / magistrate. Vide V. Surendra Mohan versus State of Tamil Nadu and others. There are several UN conventions which provide for special and preferential treatment inter-alia for the blind and visually impaired.
Convention on the rights of persons
with disability.
CPRD 2006,
Yes.
resolution on accessibility, then resolution on inclusive education.
Yes. In fact, your lordship, I have produced one judgment also which covers the very aspect whether there can be exclusion of a person who as primary graduate teacher who's 100% blind. That order also I have produced, your lordship, in the memo.
Which is that?
It is at page number 67. The question is at page number 67. Judgment starts from page number 43. Reportable judgment. Akhila Karnataka Andha Shiksha.
Andha Shikshakarugala.
Yes. It is at page number 67. The
3 begins at 43.
yes, the relevant portion is at page number 67. Whether completely blind person can be precluded from being appointed as teacher in primary schools. Page number 67, your lordship. Top of the page.
You are right. Whether completely blind persons can be precluded from being appointed as teachers in primary schools.
Yes,
ಇದೆಲ್ಲ ಹೇಳೋದೇ ಇಲ್ಲ ನಮಗೆ ನೀವು. ಮತ್ ನಾವು ಒಂದೆಯಿಂದ ಬರ್ಕೋತ ಹೋಗ್ಬೇಕು ಜಡ್ಜ್ಮೆಂಟ್ ಇದನ್ನ ಹಾಕೊಂಡು ಕಳಿಸ್ಬಿಡ್ತೀವಿ ಅವಾಗ.
Yes, and the answer is at page number 77, paragraph number 24.
$74.
77, page number, paragraph number 24. May I read it, your lordship? We find that the attempts made to justify the exclusion of the blind persons and the persons with low vision from the recruitment process based on the government circular at Annexure R1 and R2 is equally untenable. We reiterate that the government has to withdraw the circulars which run contrary to the provisions of PWD Act and issue necessary notification under the said Act. Just because the circulars are not challenged, the writ petition cannot be thrown out.
Correct.
In fact, the state government.
Out of 35,094 teachers,
Yes,
not even one blind teacher was appointed.
yes, Your Lordship.
This is what the finding of the court is. And this happens in a welfare state.
Yes, sir.
What is that welfare?
In fact, in two different districts, they have appointed 100% blind candidates in the same recruitment procedure.
In the
That
very
is-
same treatment place. Is it?
Yes, Your Lordship. In Bagal court,
Barkat. Two differently abled persons, ಕೂತ್ಕೊಳ್ಳಿ, be seated. Bracket ನಲ್ಲಿ absolutely blind, bracket complete, or knocking at the doors of writ court, grieving against the action of the respondent authorities in excluding them from the fray, recruitment fray, comma, their complaint before the state, please be seated. Complaint before the state administrative tribunal having failed. Full stop. Learned counsel, Mr. Faruqi, appearing for the petitioners, vehemently argues that absolute blindness cannot be an absolute bar to the staking of claim for public employment, where that disability does not come in the way of discharging the duties of the post in aspiration. Full stop. In support of this submission, he banks upon a decision of this court, a recent decision of this court in Science. Lata, la?
Lata, yes. 19994 of 2024.
Lata versus in WP number, 19994 of 2024 SKAT between, correct?
Yes, Your Lordship.
State versus Lata, Miss Lata, decided on 11/11/2024, and a coordinate bench of this court in report illanidrally report adangide alla.
Yes, my lord.
That is also,
reported.
Report agide.
yes.
Somebody can help from the bar. Ask them, anybody. Report kodbek, reportable judgment iddaga.
Yes, second, both are reportable.
Where it is reported. Citation ಕೊಡ್ಬೇಕು.
Citation,
ಇರ್ತದೆ.
I will get. Okay.
ಹಾ?
And ಅಖಿಲ ಕರ್ನಾಟಕ ಅಂಧ ಶಿಕ್ಷಕರುಗಳ ಕ್ಷೇಮಾಭಿವೃದ್ಧಿ ಸಂಘ versus selection authority and another. ಅಲ್ಲಿ WP number 16396 of 2006 PIL decided on 29/6/2007. First off. Learned AGA on request appearing for the official respondents opposes the petitions with equal vehemence, contending that the post of teacher in question requires the candidate being capable of discharging the duties attached thereto, and that the blindness would come in the way. Full stop. She also adds that in one companion matter, that is WP number, delay ಇರೋದು ಯಾವುದು?
Both delays.
He also adds that the tribunal denied relief inter-alia on the ground of delay and laches, comma, the petitioners having had approached it after brooking lot of delay. First, please be seated.
Yes.
In reply, Faruqi submits that when persons with absolute blindness are grieving their are grieving before the grieving, comma, delay should not matter if the recruitment process is halfway through. First, he also adds that the petitioners were before the writ court earlier and they were relegated to the tribunal, and in that process, the delay has been occasioned. And that should the period of pendency of the petitions be excluded, comma, arguably there would be no delay. First, next, having heard the learned counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission made by learned counsel appearing for the petitioners. And therefore, the relief granted to the litigants in the cognate cases has to be extended to petitioners herein on the principle of parity and equality, especially when the recruitment process in question is still ongoing. First, the blindness is arguably a disability, and to that the constitutional institutions should not add, comma, to say the least. First, it is the policy of the state as enacted in 97 Act, 95 Act.
95 and 2000.
95 Act, the erstwhile 95 Act and the present 2016 Act, comma, the policy enacted is to come to the protection or to protect the interest of persons with disability. Semicolon. More the disability, more protection is warranted. First off, a court of justice cannot deny justice on the sole ground of delay and laches, especially when there is a plausible explanation for that, coupled with the disability pleaded. First, in the above circumstances, these petitions succeed. First, the impugned order of the tribunal, impugned orders of the tribunal are set at naught. Semicolon. Subject applications of the petitioners having been favored, comma, carry direction. The respondents are directed to allow the petitioners to be in the recruitment fray under ocular disability category.
Yes.
Category, provided that other conditions they do comply with. No costs.
That's obvious.
The case of during the disciplinary proceedings, Your Lordship, the delinquent DGO died, Your Lordship. Hereafter it was, the delinquent official died during the disciplinary proceedings, Your Lordship. It was dropped.
Official died.
Please, Your Lordship. It was abated.
Proceedings abated.
Abated. Thereafter to initiate proceedings, Your Lordship, because it is case of 25 lakhs of rupees misappropriation. Not following the procedure, he has granted pension, Your Lordship, to the army. Freedom fighter pension, Your Lordship, sanctioned without following the procedure. Therefore, the 25 lakh, in order to recover it, your lordship, suit was filed. And that was challenged before the KAT. KAT says, your lordship, you proceed with the inquiry proceedings until such time you request the court not to proceed with the original suit.
Disciplinary proceedings are going on.
Not going on. Now, the court says, the tribunal says you proceed with the disciplinary proceedings
And
because
keep
it is
the
at the-
suit in pendency.
Please, your lordship. That is not permissible.
ಯಾಕೆ?
Because ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ, since he has
ಬೇರೆ
died,
ಇದೆ ಬೇರೆ, ಅದು ರಿಕವರಿ.
please, your lordship. Here, a disciplinary proceeding does not arise. Now, it is only question regarding recovery, whether is we have, the government is entitled to
ಯಾರು
recover or
ಇನ್ನೊಬ್ಬರು?
not.
ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸಾ?
Please, your lordship.
ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್.
Initiating departmental inquiry, my lord. And appointing inquiry officer, my lord, was challenged by the respondent. And the KAT has allowed their application, my lord, hence this writ petition.
Why it is allowed?
My lord, without application of mind, that is what,
Allowed, all right. Then what they did?
my lord, the contention was that, my lord, the report which was submitted by respondent number 3.
Then if it is set aside,
Yes, my lord.
that goes to the level of 14A.
Yes, my lord.
So
I
could not have been foreclosed.
Yes, my lord. There is a judgment
Issue.
on this also, my lord.
The Dharwad bench judgment. Our judgment.
Masil money.
Yes. Issue emergent notice. Stay of impugned order ಕೇಳಿರಿ no?
ಹೇಳಿದ್ದೀವಿ.
Stay of impugned order.
Obliged.
All right, very good. Yes, you- good.
Appearing for the official liquidator, my lords.
Lordship, for the appellant in this case, my lord, the senior is engaged in another court. Hold a short pass over, my lord.
Yoshi is engaged.
Not Joshi, sir. Hold a second.
And we'll have some other, today we have also submitted.
Very well.
Otherwise, we cannot proceed with the suit. your lordship.
Along with suit ಅಂತ ಅಲ್ಲಿ ನೋಡಮ್ಮ ಮೊದ್ಲಿಂದ ಒಂದು ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಮಾಡಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಆಸ್ ಪ್ರೇಡ್ ಫಾರ್ ಅಂತ. After Mr. Holla. They wanted Passover, but we wanted.
My apologies, my apologies.
No. In fact, we also wanted time only. Therefore, we are seeking adjournment at your hands.
No, sorry.
At your hands also. In January, you can have this matter.
Please, my
What
lords.
of oil? We can have it in
Whenever
January.
my lord wishes, yes.
No issue. But they are paying the regular,
No, my lord.
that
rent-
also they are not
That
paying.
rent is being paid.
No, my
In fact, there is excess. What had happened is there is, my lord, a settlement. It went before the mediator. Mediator, my lord, has accepted that settlement. Before the settlement, my lord, mediation occurred. That was placed before, my lord, the court. What happened unfortunately?
Every month ಎಷ್ಟದು?
How much is that?
10,43,000. 10,43,000.
10,43,000.
According to you, how many months they are not
Correct.
given us? We are paying.
My lord, sir.
10,43,000.
10,43,000.
My lords, recently we have filed the calculations. The total dues are 9 crore 97 lakh. My lord, they are calculating on the basis of the joint memo which have been rejected by the Honorable Company Court. Not as per the lease agreement.
ಕೊಡಿ ಇಲ್ಲಿ.
So the document which
But-
does not.
ಇದನ್ನ
Yes.
ಹಾಕಿದ್ದೀರೋ?
ಹಾಕಿ sir, ಇವಾಗ.
ಹಿಡ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರಿ ನೀವು?
Yes.
Lord, please take, my lord, this. ಅವನಿಗೆ ಬುದ್ಧಿ ಇಲ್ದೇ ಇದ್ರೆ ಇದನ್ನ
ಬಡಿ.
ಕೊಡಿ ಒಂದು ಪಾಪ. ಅವರದ್ದ ಇದು.
This joint memo on settlement is rejected.
My lord, that is assailed before your lordship. Joint memo is, my lord, what happened was, please take, my lord, what I have now filed before your lordships. ಒಂದು ಕಾಪಿ ಎಲ್ಲ ಇದೆ.
Yes.
ನನಗೆ ಕಾಪಿ ಇರಲಿ. ಕೊಡಿ ಇಲ್ಲಿ. ಪುನಃ ಅದು ಎಲ್ಲಿದೆ?
This settlement you had also agreed to.
No, my lords.
You are
I
not
can, I
agreed.
can
Come to
point
my
out from the
But how
minutes.
is that your seal and signatures appear on that?
My lords, can I just point out, I'll wait for the learned senior to finish his submissions and thereafter I may be
All-
permitted to make.
Mr. Holla,
Please, my
are
lord.
they signatories to this settlement?
Yes, yes. Now please come to my lord, running page, the compilation that I have now filed.
The one now filed.
Page number, my lord, bottom your lords get the page numbers. Third page bani, mediation report.
Page number?
3, bottom ಅಲ್ಲಿ ನಿಮ್ಗೆ ಸಿಗುತ್ತೆ. ಮಾಡ್ತೀರಿ ಸುಮ್ನೆ.
Yes. ಏನ್ರ ತೊಂದರೆ ಇದೆಯೇನು?
ಇಲ್ಲ, ಇವರು ಹಾಕ್ಬೇಕಾದ್ರೆ ಪೇಜ್ ನಂಬರ್ ಅಲ್ಲೊಂದು ಇಲ್ಲೊಂದು ಹಾಕೊಂಡಿದ್ದಾರೆ. ತಮಗೆ ತಾವು ಪ್ಲೀಸ್ ಕಮ್ ಟು ಮೈ ಲಾರ್ಡ್ ರನ್ನಿಂಗ್ ಪೇಜ್.
ಆಯ್ತು ಬಿಡಿ, ಏನಂತ ದಿಸ್ ಮಾಡಿ.
ಮೀಡಿಯೇಷನ್ ರಿಪೋರ್ಟ್ ಅಂತ ಬರುತ್ತೆ. ನಾನು ಇಲ್ಲಿ ಜಸ್ಟ್
ಡೋಂಟ್ ವರಿ, ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋಣಂತೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡಿ. ಏನೇನೋ ಸ್ವಲ್ಪ ಒಂದ್ಸರಿ ಆಗಿರುತ್ತೆ ಒಂದ್ಸರಿ.
ಅಂದ್ರೆ ನಮಗ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಪೇಜ್ ನಂಬರ್ ಹಾಕಿರ್ಬೇಕು. ಇಲ್ಲಿ 3 ಅಂತ ಹೇಳಿ ನಿಮಗೆ ಯು ವಿಲ್ ಗೆಟ್ ಟು ನೋ ಒನ್ ಒಬ್ಜೆಕ್ಷನ್ಸ್ ಮೆಮೊ. ಮೀಡಿಯೇಷನ್ ರಿಪೋರ್ಟ್ ಈಸ್ ಮೈ ಲಾರ್ಡ್ ಆಫ್ಟರ್ ದಟ್ ಅದು ತಿರ್ಗಾ ಕೆಳಗಡೆ
ಸರಿ ಮಾಡಿ ಕೊಟ್ಬಿಡಿ.
ಅಲ್ಲಿ ಕೊಡ್ಬೇಕು ಸಾಹೇಬ್ರಿಗೆ, ನನಗಲ್ಲ. ನಾವು ನಾನು ಏನೋ ಮ್ಯಾನೇಜ್ ಮಾಡ್ತೀನಿ, ನಮಗೆ ಕರೆಕ್ಟ್ ಆಗಿ ಇರ್ಬೇಕು. ಕೋರ್ಟ್ ಅಲ್ಲಿ
ವಿ ಶುಡ್ ಬಿ ಆನ್ ಸೇಮ್ ಪೇಜ್.
ಇಟ್ ಶುಡ್ ಬಿ ದಟ್ ಐ ಆಮ್ ಆನ್ 1 page and you are sir
ಲೈಫ್ ಆಲ್ಸೋ.
life also, correct, absolutely.
All right. Interim order would continue. We'll have this matter on the other date ಕೊಡ್ರಿ. ಅವತ್ತು ಕಡಿಮೆ ಮ್ಯಾಟರ್ ಸಾಕ್ಸಿ ಮುಗಿಸ್ಬಿಟ್ರ. ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ. 5th of December. All right, 5th of December. Interim order to continue. All other matters ಎಲ್ಲ up to 2000 ಏನಂತ ಹೇಳ್ಬೇಕು. All other matters list after 2 weeks, and wherever interim order is there, continue also. But
Yes. Morning, I argued on that.
medical post graduation.
PG, after PG it is DNGS.
No, correct. He has done that. Now we have read again that one very carefully. They have a case. We may be wrong, but we felt that way, and we have recorded he is undertaking on your insistence, which you have written, that they should serve 10 years. They can't leave it. But only thing is, in the event they leave, what are you going to do? That you did not indicate. Bond total. Bond amount bond. Bond specified amount that they will get. ಅದಕ್ಕೇನು ನಾರ್ಮೇಟಿವ್ ಬೇಸಿಸ್ ಮೇಲೆ ಫಿಕ್ಸ್ ಮಾಡ್ತೀರಾ ಅಥವಾ ನಿಮ್ ತಲೆಯಲ್ಲಿ ಬಂದಂಗೆ ಫಿಕ್ಸ್ ಮಾಡ್ತಿರೋ ಅದು ಅಮೌಂಟ್ ಸಮ್? ಓಕೆ, ದಟ್ ವಿಲ್ ಆಡ್.
50 to 60 lakhs they pay and they leave the institution.
We understood that. ಬಾಂಡ್ ನಲ್ಲಿ ಸ್ಟಿಪ್ಯುಲೇಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ನಿಮ್ಮ ಅಮೌಂಟ್ ಏನಿದೆ ಆ ಪ್ರಕಾರ. ಸಮ್ ರೂಲ್ಸ್ ವೇರ್ ದೇರ್, ದೇ ವರ್ ಅಮೆಂಡೆಡ್ ಇನ್ 2013 ಅಥವಾ 14. ಅಲ್ಲಿ 15 ಲಕ್ಷ ರೂಪಾಯಿ ಇದ್ದಿದ್ದು 50 ಲಕ್ಷ ರೂಪಾಯಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿರ ಅಲ್ಲಿ. ಆ ರೀತಿ ಒಂದೇನೋ ಒಂದು ರೂಲ್ಸ್ ಮಾಡ್ಕೊಂಡು ಮಾಡ್ಬೇಕು ಅಂತ ಬರೀತೇವೆ ನಾವು ಅದ್ರಾಗ, ಅಲ್ರಿ? ಓಕೆ.
ಅಲ್ಲ 2 weeks ಅಂದ್ರೆ ಹಂಗೆ ಡೇಟ್ ಕೊಡಲ್ಲ ಅಂತ
Thank you. ಹಂಗೆ ಮಾಡ್ತೀನಿ ಅದು ನೆಕ್ಸ್ಟ್ ನಿಮಗೆ ಅದೇ ಡೇಟ್ ಹಾಕಿ ಥ್ಯಾಂಕ್ ಯು ಸರ್ ಥ್ಯಾಂಕ್ ಯು.
ಏನಿಲ್ಲ, ಅದೇ 42nd ಮ್ಯಾಟರ್ನ ಮೆಮೋಗೆ ಓಪನ್ ಮಾಡಿದಾರ ಸರ್, ಅದೇ ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇಟ್ ಆರಾಮಿದೆ ಬಂದಿದ್ದೀರ ನೀವು ಅಪ್ಪ ಏನ್ ಕೊಡ್ತೀವ್ರ ಬಂದಿಲ್ಲ